Okay, good morning, everyone, and welcome to the Widener Commonwealth Law Review Symposium on Judging and Administrative Law, hosted in conjunction with the Law and Government Institute's 25th anniversary this year. I'm the Editor-in-Chief, Erica Firestone, and it is my pleasure to introduce the Dean of the Law School, Dean Hussey, to kick things off for us. Dean Hussey has served as Associate Dean for Academic Affairs and Associate Professor of Law before becoming Dean in 2020. He teaches and writes in areas of taxation, business organizations, and wills and trusts. He founded and co-directed the school's business law advising program and has also directed the school's volunteer income tax assistance program for 16 years. Dean Hussey earned his degree magna cum laude from St. Louis University, where he also graduated summa cum laude with Bachelor's of Arts degrees in mathematics and philosophy. He holds an LLM in taxation from Washington University and St. Louis School of Law. Prior to his work in education, Dean Hussey practiced with law firms in Illinois, and he currently serves on the United Way of the Capital Region's Board of Directors. Please join me in giving a warm welcome to Dean Hussey, and I hope you enjoy today's events.
Thank you, Eric. I appreciate that. I'm Michael Hussey, Dean here at Widener Law Commonwealth, and it is my pleasure to welcome all of you to our annual Law Review Symposium. In particular, I'd like to welcome Judge Childs, who I noticed is here with us already at the symposium. She'll be our keynote speaker later in the day. I would like to thank Erica Firestone, who just introduced me as our Editor-in-Chief of the Law Review, and her amazing editors and staff for envisioning and planning today's symposium. Thank you all. In particular, I'd like to thank Carrie Nace, the Pennsylvania Law and Symposium editor for the Law Review. She has been the driving force behind today's event, as she is for so many events at the law school. When she graduates, I think we're going to need at least 3 students to step in and cover all that she does. Thank you, Carrie. I would also like to thank Professor Quinn Yeargain for their leadership of the Law Review as faculty advisor. At Widener Law Commonwealth, our mission is to produce professionals, lawyers that are highly ethical, mindful of the public interest, and engaged as leaders in their communities. We seek to transform promising students into skilled lawyers who know the law and use the law to compassionately solve problems, whether they serve in government or in the private sector. Our signature programs, the Law and Government Institute, the Environmental Law and Sustainability Center, and the Business Advising Program, all seek to engage our students in this most important work. Today, our Law Review Symposium, Judging and Administrative Law, nicely complements the work of our Law and Government Institute, which is celebrating its 25th anniversary this year. This symposium will explore recent changes to administrative law, focusing specifically on the roles of judges in the development and implementation of administrative law. Our Law and Government Institute helps students explore how government works and the roles that lawyers play in making and implementing the law. As a result, our students develop a passion for government law, which in turn leads to Widener Law Commonwealth alumni working in all areas of government and public service. Our alumni are key to ensuring that the rule of law is rightly developed and faithfully implemented. I hope you find today's symposium engaging and thought-provoking. It is now my pleasure to hand things off to Dennis Whitaker, an adjunct professor here at the law school, who will be moderating and leading our first panel.
All right, good morning, everyone. As Dean Hussey said, my name is Dennis Whitaker. I'm moderating an all-star panel here on the impact of counsel and administrative adjudication. We have 3 professors who have done quite a bit of both research and work variously across the spectrum, particularly with immigration law. We have Professor, the Honorable Tiffany Williams Brewer, professor at Howard University School of Law, Professor Ingrid Egley from the UCLA School of Law, and Professor Haiyun Damon-Feng, who's at the NYU School of Law. My background, not to take up too much time about that, but I have tried more administrative law cases than I can count in front of more administrative law judges than I can remember. So hopefully we'll be able to mesh our experiences together here. I'm confident that we will. Just to give you a little, our first speaker will be the Honorable Tiffany Williams Brewer. Professor Brewer is at the Howard University School of Law. She teaches courses in evidence, professional responsibility, legislation, regulation, and Black women in the law. She's a former New Jersey administrative law judge. I never appeared in front of her, so there's at least one judge I haven't appeared in front of. And the governor of New Jersey, Governor Murphy, recently appointed Judge Williams Brewer as the first African-American to chair the New Jersey State Commission of Investigation. She served as a federal prosecutor, represented clients at some large law firms, and also had senior leadership roles in state government. She's vice chair of the ABA litigation section. She should be chair next year in 2025. And she, as you can tell, brings quite a broad swath of experience to our panel. So with no further ado, if Professor Williams is ready to go, I'll turn it over to her.
Well, thank you, Dennis. And
good morning.
Thank you, Widener Commonwealth, for having me today, and for also really hosting this forum that I think is really important to continue to focus on the importance of administrative law. Our panel today is really looking at not only just judging in administrative law, but the important topic of the right to counsel. And when I saw the call for papers, I was very excited because my experience as an administrative law judge definitely left me with the indelible impression that the right to counsel is vital in many administrative law proceedings. The one I'm going to talk about today, I, unlike the other panelists, have no experience in immigration law. I'm going to focus really on the importance of the right to counsel for parents and children in abuse and neglect administrative proceedings. And so, in fact, my proposed paper is entitled Reexamining a Right to Counsel for Parents and Children in Abuse and Neglect Administrative Proceedings. I want to start by both giving a little background for those that may not be familiar with how these proceedings work, and then also share with you some of the motivation for my being interested in this topic based on my experience with some administrative law cases that and litigants that appeared before me. So in New Jersey and many states, in addition to there being formal proceedings that are brought before a trial court, either kind of quasi-civilly, quasi-criminal, or actually in criminal proceedings for termination of parental rights or for some level of supervision and temporary termination of rights, there is also a parallel administrative proceeding under many state statutes, because a determination by a state agency that a parent has been involved in abuse and neglect can also result in a record that is placed on what is commonly called our child abuse and neglect registries. Those registries maintain a list of individuals that have been found to have substantiated findings, or however a state categorizes that sort of conclusion by a state agency that there has been abuse and neglect. The registry is kept because it's used as a database to search when individuals are going for employment, and in some instances also trying to be either a resource parent or a relative that is trying to take custody over a child, but any sort of interaction, certainly with children. And so the issue with many of these child abuse neglect registries is there's no way to get off. Once you're in, you're in. And the due process that's required is really codified in the administrative proceedings. There is typically no right to counsel in administrative proceedings where you have, as a parent, the possibility that you will be on this child abuse neglect registry for the rest of your life. That's one constituency that in my paper, I really am advocating that we consider having a right to counsel for, and I'll explain some of the things that I have seen and why this is important. The other constituency is the child themselves. So in many of the termination and pendency hearings that are going on, many states allow there to be a lawyer and a right to counsel for the child themselves. When I first left the bench and went to teach full-time at Seton Hall Law School, one of the projects that I did on the side was serve as a contract attorney for the Office of the Law Guardian in New Jersey, representing the interests of the children involved. But when I look back at my experience as an administrative law judge, I realized that while I could be a great advocate for children as they were going through this process, once the proceedings were over, there was no one really representing them in the administrative process. And some of these child abuse and neglect cases on the administrative level, you're really relitigating the same facts to make sure that there is a substantiation that qualifies the parent to be put on this registry. So if you think about things that I have seen, like children having to come and testify about sexual abuse, but those children not being represented. So there are many interests of the child themselves that an administrative law judge could take into account, even the manner in which the child testified. There was no advocate there for the child to truly, from a legal perspective, really be directing how that examination should even occur. Now, because of just my background, I was sensitive to it as an administrative law judge, and I took matters into my own hands, and certainly with the consent of the other side, to arrange for the children to testify separately and have the other counsel and the petitioner monitoring that testimony. They could submit questions, but that was really my proactivity. And every judge, even in my court, did not handle proceedings the same way. There was not uniformity. So that is the second category of litigants, really, and an interest in an administrative proceeding for abuse and neglect, who deserves this right to counsel. Now, let me back up for a moment and just share some of the things that I saw that really motivated my work in this area. Most troubling to me was an incident where it turned out that in New Jersey, the Department of Children and Families, excuse me, had discovered that they had lost files for 30 years. So they found these 30-year-old files, and they decided that it was their responsibility to still move forward with these administrative hearings. So they did not have witnesses that were fresh and available anymore. This was 30 years later. So I received one of the cases before me, and there was a pro se litigant who was contesting the fact that she should not be placed on this child abuse neglect registry. The department, represented by the Attorney General's office, did not have a single witness. And I asked them, were they considering perhaps not going forward or dismissing the case? And they said no. So as you can imagine, there really would be no evidence other than if the petitioner who's trying to not be on this child abuse neglect registry, unless she were to put some evidence in the record that would substantiate the finding. So as an administrative law judge, I have to listen that day and determine, are there any facts that would support the division's initial finding of abuse and neglect? Well, the woman before me was a grandmother. And 30 years ago, she was a mother who she described as being troubled herself. She said that she was addicted to both drugs and alcohol, and DIFAS had gotten involved on several instances and cited her because, as she described, her daughter was very disrespectful to her, and at one point her daughter said something kind of back to her, very rude and disrespectful at the breakfast table, and she slapped her across the face. It left a mark, and I think the child had fallen out of her chair, and this was reported at school, and the division got involved. Another incident was that the mother pushed the daughter, and the mother acknowledged on the record that she had been under the influence of drugs and alcohol while this discipline happened. She also related that while she was outside one day, same sort of situation in her mind. The daughter was disrespecting her. She was telling her to come inside, and she pushed the daughter against the fence, and the daughter fell and injured herself. So I wouldn't know any of this unless the petitioner testified that day. I could not give her legal counsel, but I did say at the beginning of the proceeding that I would give her an opportunity. I would adjourn the matter, and I would give an opportunity, if she wanted, for her to consult a lawyer. I reminded her that the division was here today to proceed, but that they did not have any witnesses. But she could not, as a pro se litigant, truly understand what all the attorneys in the room knew. I knew that the only way that I could truly substantiate this finding is if she testified, which is exactly what she did, and inculpated herself. And that's exactly what she did. She, as a pro se litigant, thought the best strategy was to come in and to share with me her side of the story. And why she was really adamant about even needing to do this is because that same daughter, because remember, this is 30 years later, the same daughter had really taken a wrong path in life and was strung out on drugs herself and had had a child. And this litigant wanted to care for permanently her grandson. They had no other family, and they did not want him to go into the system and into foster care. But she could not move forward because she had this case pending. And so for her, this meant the difference between being able to raise her grandson or not. And she decided to talk that day and testify to explain all this to me. And in doing so, telling me how she had reformed her life and telling me how she didn't want to pass on, kind of her sins in parenting, right? While she was addicted to her grandson. She wanted to really redeem the moment and the failures that she had made with her own daughter. So that was her motivation as an unrepresented person going through the situation of needing to give an explanation in her mind to prevent her from being on this child abuse neglect registry. Now, unfortunately for her, because she was not represented by counsel, she did not understand the legal implications of that, because in her detailed and passionate testimony that day, unfortunately, she gave corroboration in detail for all of the findings that the division had made. So as an administrative law judge, I had to look at the testimony. I had to make credibility findings. There's only one witness. I found her very credible, but unfortunately, she gave the facts in the record that would substantiate the original finding by the division. And as a matter of law, she has to be put on this child abuse and neglect registry. That case happened about 10 years ago, and it still troubles me to this day. And while I don't justify that or in any way feel that the division was not correct initially 30 years prior with having had concerns and citing her and substantiating it, it just seemed that in both the situation where the division had waited 30 years and had no witnesses, and just seeing the other circumstances around the impact that this decision would have on this litigant's life, it just struck me that this is a classic case of the importance of having counsel. So the right to counsel can also, make a difference, not only in a child's experience that has to testify about their sexual abuse in an administrative proceeding. What we are also seeing, we live also where statistics are showing us that there are also disparities in who is regulated in the child protection arena. Disproportionately low income and minority parents find themselves to be the ones who are subject to this sort of regulation and therefore put on the child abuse and neglect registries. The impact then becomes economic as well, because they cannot have jobs that really relate to dealing with children, even school bus drivers, being a janitor in a school, being a teacher. All of these sort of roles really are impacted because a background check, even certain volunteerism in nonprofit organizations, if they deal with children and youth, being a coach on a team, these are all impacted. So when we look at the similarities to what is at stake here, to what we see at stake in a criminal proceeding, that where we have Gideon protections, we can see parallels as to the breadth and depth of the sort of rights that litigants may need to be counseled on by attorneys. Attorneys matter. And when the right to counsel is not offered and implemented in administrative proceedings, you then are left with needing to really resort, if you don't have money to retain private counsel, to legal services. And I read some statistics the other day that said that legal services is really looking at, we all know it's underfunded, but they really look at 1.9 million civil legal problems per year. And that is just the individuals that meet their eligibility criteria. That is the sort of press and crush on legal services. And they turn away about half of those cases. And it's really not guaranteed that all of the rest of those cases receive the legal assistance required. We know that legal representation in civil matters really matter, and they make a difference. So to not have it in administrative proceedings with so much at stake in the sort of issues that we're talking about that could result you on a child abuse neglect registry, we are really deviating from the very policy that we have in the criminal context, where we justify the need for the right to counsel. In most states, this right to counsel is really in civil cases, particularly involving child abuse and neglect. There's really a patchwork that even exists. And really, most states do not have a right to counsel in the administrative proceeding where there is a child abuse and neglect registry. The ABA continues to call for a civil right to counsel as well in cases that may result in the loss not only of physical liberty, but also the loss of sustenance, the loss of things that are most germane to daily existence. So my paper really looks at the areas that I've talked about and the vulnerabilities that exist when both parents and children do not have the ability to have right to counsel. I look at it in the backdrop of the overregulation of underrepresented families, the implications that registry placement has on unequitable impact on communities of color and those at the lowest socioeconomic status. And, also examining the necessity of the right to counsel for children to ensure that they are able to not be re-traumatized, even in the administrative proceeding part of this whole cycle of what has happened in their life. I conclude in my paper with some recommendations on best legislative and administrative practices in implementing a right to counsel to really avert a miscarriage of justice. But I believe that looking at strengthening this area in administrative proceedings will help the judges to be able to deliver the type of justice that is required in these proceedings. Thank you, Dennis. I'll turn it back to you.
Well, thank you very much, Professor Brewer. That was very, very thorough. I can tell you in Pennsylvania, civil Gideon is much talked about, but it's only been within the last year that the Commonwealth has even provided additional funding to public defenders' offices. So, the civil Gideon has even been below that. I know Pennsylvania has an intermediate appellate court that's a government law court. It's called Commonwealth Court, and you see 2 or 3 cases a week where somebody's been put on the child abuse register, and an appeal taken there, and much like the impact that even a DUI conviction or something like that can have, if you don't have a lawyer who's experienced in administrative law, you can take a plea to disorderly conduct or something like that. But if it's a misdemeanor, the next thing you know, if you have some sort of state issued license, a real estate license, if you're a barber, if you're a hairdresser, there's ripple effects on all these sorts of licenses. I know we have around 101 folks here. You can use the chat function if anyone has any specific questions for Professor Brewer before we move on to our subsequent presentations. And I think one of the things you'll hear from both Professor Egley and Professor Damon-Feng is the same issue: the lack of access to counsel is pervasive across their areas of study. I'll ask if Professor Damon-Feng, do you have any follow-up comments before we move on to the next presentation?
I think, my remarks tack on really beautifully to what Professor Brewer has been talking about. And Professor Brewer, if you have any follow-up comments before I move on, but I think they dovetail together really nicely.
Okay, great. And Professor, before we move to Professor Damon-Feng's presentation, Professor Egley.
Yeah, I just thought that especially the example that Professor Williams-Brewer offered from her perspective as a judge as adjudicating a case with someone without counsel is something that is so important. I really appreciated hearing that perspective and that particular story, and it's something that we should keep in mind as it connects to the rest of the discussion, and really sort of it really humanizes and makes more concrete the importance of counsel.
Well, thank you very much. I don't see anything in the chat. So since we don't have any additional questions, and I want to make sure that everyone has plenty of time and we have time for discussion at the end, we'll move on to Professor Damon-Feng.
Great. Thanks so much, Professor Whitaker. Thanks to the Widener Commonwealth Law Review for having me, for putting on this incredible symposium, and happy 20th anniversary to the Law and Government Institute. Very exciting. So like I said, Professor Brewer, I think, mentioned a lot of really great things, and I think leads really well into kind of the topics that I'll be talking about. She mentioned that there's no right to counsel in these state abuse and neglect proceedings on the registry side. And, that's generally true, like she said, across the administrative state. The Supreme Court has held that there's no due process right to appointed counsel in these proceedings generally. There are some exceptions, but generally in administrative proceedings, there's no right to counsel. And yet we've heard from her, and I'm sure we'll hear from Professor Egley as well, that counsel in these proceedings is incredibly important. It can have a huge impact on outcomes. And that's true on a trans-substantive basis in the child neglect context, in the immigration context, as I'll talk about. In the veterans context, folks with attorneys are denied benefits only half as frequently as those who go pro se on appeal. In the Social Security context, disability claims for those who have attorneys are 3 times more likely to get benefits than those who don't have lawyers. And then in immigration court, depending on the group, those who have lawyers are between 5 to over 10 times more likely to get relief if they have counsel than those who don't. So access to counsel can be really meaningful, but like you've been hearing, it's far from guaranteed, right? In the immigration context, only about 37% of all immigrants ever have an attorney in their case. And if you look at just detained immigrants, that number drops to 14%. So only 14% of detained immigrants ever have a lawyer by their side. And these are really complicated proceedings. And there's lots of reasons for why this might be. You've heard that legal services face these big funding issues, capacity issues. If you can't qualify or don't qualify or can't get a pro bono lawyer, you have to pay for your own. That's quite expensive, as we all know. And those are structural issues that folks have been talking a good deal about and that we're still trying and working really hard to address. I'm going to focus my talk on something that we don't talk about, I think, as much, which is how agencies can internally change their procedural rules of how the adjudication process works to either introduce or remove barriers to accessing counsel. And so my remarks are going to focus on the immigration context, but the principles that we talk about are going to be more broadly applicable across the administrative state. So this type of kind of agency-directed policymaking or rulemaking and kind of tweaking their procedural rules are a version of what some folks call internal administrative law, right? They're ways that the agency speaks to itself and its components to bind the ways that the agency behaves, including binding judges' discretion in their own individual cases. This can happen in a number of ways. It can happen through rulemaking, of course, which gets a lot of attention. It can also happen through the issuance of guidance documents or memos that set agency policies and priorities. And this gets a little bit less attention, but it's being used more and more to kind of effectuate agency policy making and policy change. So a couple of key attributes to highlight about these kind of procedural guidance documents is that they are quicker than rules to implement, and they're quicker to change than rules. And they also don't invite a lot of public comment or input before they're put into place. And so they often happen behind closed doors, sometimes as a surprise, and they often happen immediately. So there's no kind of transitional time frame where you can kind of prepare for the changes to come. Professor Family has done a lot of great work on this type of rulemaking or policy making rather in guidance documents. If you haven't looked at it yet and are curious to learn more, I highly recommend looking into that body of scholarship. But so these rules and these policies are generating a lot of change in kind of how courts in the administrative state can operate. And they're also a way for presidents to exert control over agencies and their processes, right? Which are often highly consequential when you think about these politically controversial, contested, volatile areas like immigration. And when agencies tweak their procedural rules, they often justify them using kind of these administrative law values that seem really great and seem really neutral, like efficiency, cost effectiveness, expediency, right? And these are generally goals that we favor in terms of adjudication, and that's why we kind of funnel things through the administrative state. But when we do that, these rules are often also kind of juxtaposing this right to counsel, this access to counsel, as in opposition to those values. And the access to counsel issues are often classified as a delay that sits into tension with these kind of more efficacy, cost effectiveness, and expediency goals. And so when the agency couches their policies in these more managerial terms, they can seem more kind of neutral or kind of milquetoast, but they can have, again, these really big substantive material effects on outcomes of individual cases. And again, when you think about kind of these politically contested areas like immigration, affecting those outcomes might sometimes be part of, if not the entire point, right? The pattern of agencies taking up these types of procedural shifts in their practices in terms of how they govern these administrative adjudications is troubling in itself for other reasons. When the door to these kinds of moves is opened, it's really hard to close. Empirically, scholars have found that presidents are really quite willing to use these types of tools, especially when their predecessor administration used them to get stuff done on a quicker timeline, right? And so this means more aggressive forms of procedural control over agency adjudication. We've seen more and more of this happening, and I'm guessing that we are in store for kind of seeing more in the years to come. So a few examples of how this is unfolding come out of the immigration context, like I mentioned. The first example is what folks call rocket dockets or accelerated dockets or dedicated dockets. These are basically kind of docket management directives that are used to fast track a particular group through immigration court proceedings. They shorten the time that people have to file for relief, to collect evidence, to prep their cases, and of course, it shortens the time that people have to find a lawyer to help them do all of that. I'll also note that in immigration court, the initial burden of proving that someone is removable or deportable lies with the government. But that is a really kind of quick and easy burden to meet. They just have to prove that you don't have kind of the authorization, the paperwork, the documentation to be legally present in the country. And for the most part, people generally either don't contest or concede the fact that they are removable. When that happens, if you have an affirmative defense, like you're seeking asylum, the burden then shifts to the individual to prove that they qualify for asylum. And that is a complicated process. The burden's on the individual to either defend their deportability or to make an affirmative case as to why they qualify for other forms of immigration relief. And so when you shorten the time that folks have to prep their cases, you're really kind of kneecapping their ability to make their case as strong as possible. So in the use of these rocket dockets, they again kind of shorten the time frame that folks have in immigration court. Rocket dockets have, as they've been used in the past, typically targeted certain groups, typically unaccompanied children or families with kids that have recently arrived in the US. They've been used in each of the Obama, Trump, and Biden administrations, all to kind of similar effects. So under the Obama administration, like I said, the rocket dockets were used to target unaccompanied kids and families with children. And the use of the rocket dockets significantly reduced the likelihood that people on these dockets would be able to ever find counsel. One report found that 70% of families on the rocket dockets were unrepresented. And we know that people with counsel are much more likely to win their cases than people without counsel. The striking thing about rocket dockets is that it wasn't just that people, weren't able to kind of amass a strong enough claim in the end and weren't able to win because they weren't able to be persuasive enough, right? Which is how we typically think of, counsel kind of being effective in court or in adjudication. What's striking about the rocket dockets is that most people without lawyers never even had a chance to make a case. What these reports found was that of the families who didn't have lawyers, only 6.5% of them, 1 in 15, were able to ever even file the paperwork needed to seek asylum or some kind of relief from deportation in immigration court. Contrast that with people who had lawyers, 70% were able to file applications for relief. That is a huge difference. The consequence of that is that nearly half of families without lawyers were ordered deported at their very first preliminary hearing. This is a scheduling hearing. It's not the individual merits hearing where you get to kind of lay out all the facts of your case. This is a preliminary hearing. Nearly half of the families without lawyers were ordered deported at that very first hearing, compared with just 4.4% of families who had lawyers. So that means that families without lawyers were 10 times more likely to be ordered deported basically immediately than those who had lawyers, right? And we know that the number of people who have lawyers is incredibly small. The rocket dockets have continued in various forms, like I said, under the Trump and Biden administrations, and these effects are the same. Today, the people who are on rocket dockets also have trouble finding lawyers. Fewer than 70% of people who are on these dockets today have lawyers, right? Agencies can also directly limit the time that people have to find counsel. They can do this through the same kind of methods, through guidance, through rulemaking. In November of 2020, the Executive Office for Immigration Review, the EOIR, which is the federal agency that houses the immigration courts, issued a notice of proposed rulemaking that would limit what constitutes good cause for a continuance, right? And you can only issue a continuance for good cause shown. One of the stated motivations behind this proposed rule was a concern with an individual, quote, manipulating their right to counsel to delay proceedings or to subvert the administration of justice by the immigration courts. So again, we're seeing access to counsel being presented as this impediment to good administration, but the data suggests that access to counsel really reinforces fairness in the process, which you might think actually bolsters good administration. So the proposed rule would do two things to limit the time that people have to find counsel. First, it would not require an immigration judge to grant a continuance if it's been more than 10 days since the person was initially served with their notice to appear in immigration court, right? So there's no requirement that an immigration judge give anybody more than 10 days from the start of their case to find a lawyer. The second thing the rule would do was that it would handicap the individual immigration judge's ability to even issue a continuance, to use their discretion to give people more time to find counsel. It would limit the immigration judge to granting at most one continuance of not more than 30 days to allow a person to find counsel, and only then under certain circumstances, right? So you're taking away people's discretion, the judge's discretion to give people more time, and you're also not requiring the judges even use their discretion to give people more time if it's been more than 10 days. That said, we know from Professor Egley's research, in part, that finding counsel often takes more time than that, right? Finding counsel takes an average of anywhere between 33 days to over 150 days, depending on kind of the group that you're looking at. So really the rule is kind of cutting off people's ability to ever find a lawyer. And then, even if you kind of overcome all those obstacles, even if you can find a lawyer, agencies can further tweak their own procedural rules to make it more difficult for that lawyer to be effective in the immigration court proceedings. So the rule that I just described that's being proposed would also functionally do a couple of things. It would eliminate continuances for attorney prep time in most circumstances, and it would also shorten the time that's allocated by the immigration courts for the overall case adjudication. And so all of this condensing really puts a strain on attorney time and resources and makes it more difficult to put on a compelling case altogether, right? If we know this, if you don't have time to gather evidence or draft a brief or prep testimony, you're not going to have a very good shot at winning your case, right? Everyone knows this. That said, this isn't the only example of how agencies have tried to kind of limit the ability to do that. The Trump administration also issued this policy memo that explicitly shortened the hearing times and filing deadlines just for people who had attorneys, right? So pro se litigants, with all of the kind of disadvantages they have, were not affected by this rule. But if you found an attorney, then your time to mount your case was shortened. This memo was thankfully rescinded by the Biden administration, but it's a policy memo. Like I said before, it's easy to issue, it's easy to change, and there's nothing to say that it wouldn't come back in some form in subsequent administrations, right? And so these types of procedural rules are kind of less flashy. They get less attention than these big substantive bans or bars. And that's, I get that, right? These are somewhat sneaky rules that often fly under the radar, but they too can have these huge effects on outcomes, as well as the kind of adjudicatory process itself. Like I said, they make it more difficult to put on an effective case. They put a tremendous strain on the resources of attorneys and the legal services providers, which might then further reduce capacity and result in even more people going unrepresented. And they also inflict trauma on attorneys and contribute to attorney burnout. A study found that asylum attorneys during the Trump years had higher burnout scores than immigration judges, than prison wardens, than social workers, and that women attorneys and attorneys of color were among the groups that reported the highest symptoms of burnout and secondary traumatic stress from these types of policy changes. So, takeaways. Counsel is super important, and everyone knows it. And as we are discussing kind of the barriers to access to counsel, we should also be aware that the internal agency levers that can encourage or discourage finding a lawyer, or that make having a lawyer more or less effective, even if you can get one. I'll also note that there are some processes in the administrative state where there is no right to counsel at all. And I don't mean a right to appointed counsel, but that even if you have a lawyer, you're not allowed to bring that lawyer into the adjudication with you. Right. And I'm happy to talk more about that if folks are curious. I'll also just note that having counsel, while again, incredibly important, is not the whole story, right? There are also these substantive issues related to how the law is drafted, interpreted, policed, enforced, applied, not just in immigration law, but across the administrative state, that contribute to disparities in outcomes and that might implicate our notions of fairness. And so as we are thinking about adjudication in administrative law, we should keep kind of all of this in mind and really kind of move towards fair processes across the board for individuals that are in the system and who are regulated by these systems. So I will stop there. Happy to address any questions and look forward to discussion and learning more. Thanks.
Thank you very much, Professor Damon-Feng. I had just a couple of observations before I turn it over to the rest of the group. It's interesting that you mentioned both immigration law and Social Security. I think it's one thing that's not taught as much or glossed over in admin law courses is that when government hands out benefits, it over time has a tendency to make it harder. Certainly, I think if you look at the Social Security process from 20 or 30 years ago and look at it now, there's been added layers of complication, additional hoops to jump through. And the idea is the more hurdles you add, the more people you lose at each level, and people just sort of give up. It's almost like no bureaucrat gets an award for giving out the most benefits. And no immigration law judge gets the award for letting the most people into the country. It's when the government starts agencies like that, it becomes almost proprietary that they not grant the relief they're set up to grant as opposed to granting it. And as I said, I've seen that in the Social Security realm, certainly. Two other sort of questions, comments, policy and guidance documents. I'm assuming that, obviously the difference between policy and guidance documents and regulations is policy and guidance documents aren't binding. But to have a challenge, I'm assuming the way it's set up is that by the time anybody would challenge that and it gets through the court level challenges, that you essentially, a lot of people lose the ability or lose their cases because it takes so long to challenge the guidance document unless you could somehow get it stayed. And then I guess the last thing to throw out there is these are lawyers, especially in immigration, need to have experience. And there's not that many of them around. And it almost doesn't do you any good to have a lawyer who doesn't know what they're doing or isn't familiar with the process. It's sort of the same as not having one. So, if we have time to chat about that, I wanted to allow or turn it over to Professor Egley to see if she had any additional comments, and then Professor Williams-Brewer. And it looks like we actually have something on chat here. Oh, nope, that's just about CLE. Okay. Professor Egley?
Yeah, no, I really enjoyed hearing about this project. I think it's really important to be putting the spotlight on some of these administrative rules. I agree that they oftentimes get sort of overlooked and not focused on. So hearing, sort of on the ground how these different policies and priorities of the administration are impacting lawyers, I think I found really illuminating, and I want to thank you for that work.
And similarly, I echo that, and I actually teach legislation and regulation here at Howard. It's a required 1L class, and so you have definitely just emphasized to me how important it is, I think, as the administrative state, and then the importance of it and those challenges is continuing to grow, to just encourage students, law students, how to really prepare themselves to be great advocates in these areas. And you certainly have also emphasize how this right to counsel issue is impacting another underrepresented community, a lot of times being people of color. So thank you for your work.
Thank you, Professor Brewer-Williams, or Williams-Brewer. And I guess now we will move to Professor Egley.
Great, thank you. Well, I just want to start out by also singing the praises of the organizers and the law review. This is such an important topic, and I really am very grateful to be here and to learn from all of the different presenters on this incredibly important topic of the administrative state, and particularly with this panel, access to counsel, being an issue that I focused on for a while now. So for my presentation, what I want to talk about is really three interrelated projects. One paper that I published a while back on access to counsel, a current paper that I'm looking at the detained immigration courts, and then a future project that's going to, again, revisit the topic of access to counsel. So to begin, in 2015, Stephen Schaefer, my co-author, and I published the first national study of access to counsel in immigration court. And we did this by analyzing data that's provided from the immigration courts, the Executive Office for Immigration Review, or the EOIR, that provides a huge amount of information about cases that are handled by immigration judges. And this information also, fortunately, includes information about whether a lawyer was involved in the case. So we're able to look at the information that's provided and see if a lawyer at some point joined the case, and if that lawyer was involved also in, filing some sort of application for relief. We can see how the case resolved, and a lot of other things about the respondent or the immigrant whose case it was, as well as about the judge. So in the 2015 paper, we looked at a sample of over 1.2 million immigration cases that were decided by immigration judges between 2007 and 2012. One of the things with working with the immigration court system, it being so large and growing, there are so many cases to analyze. So we always have a really robust sample. And so what did we find? We found that access to counsel, I think as Professor Damon-Feng's paper is highlighting, is uneven and limited in the immigration courts. So overall, during this time period, we found that only 37% of immigrants who had their case decided by an immigration judge during this time period were able to secure a lawyer. So in immigration court, there is a right to counsel. You can have a lawyer represent you. That hasn't always been the case. When you look back historically, there has been times where you did not have a right to have a lawyer present, but there is no right to appointed counsel as we have in the criminal system under Gideon and other subsequent case law. I think the sort of standard story at the time that you wrote the paper was that access to counsel was expanding, that when you looked at the statistical report for the immigration court, the percentage of people who had lawyers was increasing. But we found in looking at the data over the time period studied that this is actually misleading. That what was happening was the number of cases with representation actually had remained entirely steady during this time period from 2007 to 2012. The same number of people had lawyers. It was just that the total cases that were being decided during that time period was declining, and as a result, the percentage of those with lawyers increased. So I think one important thing when you're studying representation is to both look at, how many lawyers are there and what's the ability to provide, for how many people are actually finding counsel, sort of what is the supply of lawyers, as well as the representation rate. But the representation rate can fluctuate when we have things such as, for example, the recent pandemic, where fewer and fewer cases are being decided. That doesn't mean that the supply of lawyers, the conclusion that the supply of lawyers is increasing would be erroneous when we just have a decrease in the number of cases that are being decided. In terms of distribution of counsel, we also found a lot of variation in access to lawyers based on nationality. People from Mexico had the least access to counsel. Only 21% of respondents from Mexico found lawyers during this time period. And you can contrast that to, for example, people from India, where 71% had lawyers, or from China, where 92% of those before immigration judges found lawyers. We found consistently that those who did have lawyers had better outcomes in their cases. And I think one of the things that we did that was different from prior attempts to look at representation was really sort of breaking down the entire immigration court process. And that's one of the reasons why I really appreciate Professor Damon-Feng's contribution of looking at sort of the rules that allow these different stages to happen. But starting with a custody hearing. So if someone is detained, we find that people who had lawyers were more likely to even get the custody hearing in the first place. If they got the custody hearing, if they had a lawyer, they were more likely to then be released from immigration court. We also found that those who had a lawyer, having a lawyer was associated with a gain of between 19 and 43 percentage points in terms of actual success in the case, meaning that the case got terminated or that they received relief from deportation, so that they received a grant of asylum or adjustment of status or cancellation of removal, being some of the big areas for relief from removal. And they were more likely to get that kind of relief because they were also far more likely to apply for a form of relief, because in cases where it's so complex to actually access the kind of information that you would need to fill out the forms, to file a legal brief, to make those legal arguments, support it with that having a lawyer, allows you to actually get those applications filed on time. So we find a huge divergence in terms of actually applying for relief and among those who have lawyers and who do not have lawyers. So I wanted to now turn to a new project that Stephen Schaefer and I are actually publishing this month. Is going to be coming out in the Virginia Law Review. I was up late last night working on some of our close to final edits. But in this paper, it's titled Detained Immigration Courts. And what we're making here is an argument that we tend to think of the immigration court system as just being one immigration court. We refer to it just as just sort of one entity. And the literature on immigration courts that has studied sort of deficits in immigration courts tends to also describe sort of the overall problems with immigration courts. The courts have a problem in access to counsel. The courts have a problem with having sufficient judges, or sort of rules that deny due process. And separately, we have this literature on detention, and the literature on detention tends to think of detention as a problem of, criminalization, a problem of, sort of conditions within jails and prisons where people are held, a problem of, mental health and how that can affect people's mental and physical health. But what we're trying to do is really connect these two literatures together to be looking at what happens at the intersection between immigration courts on the one hand and detention on the other. And at that intersection is this concept that I think lawyers who practice in immigration courts are familiar with, but we are really trying to introduce to the literature and convince people that the detained immigration courts are actually a separate and segregated space. It's not just a docket, it's a separate court. And that separate court has a separate set of judges. It is a separate institutional space. It is a separate hardscape. It is separate courtrooms, a different geography. And for purposes of our topic here today, this really matters in terms of access to counsel. So when we start really thinking about having the detained immigration court, and the detained immigration court is a separate institutional space, we can ask different questions about access to counsel. From 1983, when we start this study, to 2022, only 16% of immigrants in detained courts found counsel, compared to 53% of those in the sister courts, the separate court, the non-detained immigration court. In more recent years, as funding for pro bono counsel has improved, legal representation in detained courts has increased somewhat, but we still have serious deficits. Between 2009 and 2022, only 23% of those who completed their case in detention found a lawyer, compared to 61% of non-detained respondents. And we also look at particular aspects we try to identify what are the different sort of models that we've used in the detained court system. And one new model has been the migrant protection protocols, or the Remain in Mexico program, which we might not think of as being a form of detained adjudication, but it's actually considered by the EOIR to be a form of detained adjudication. And when you think about Judge G's recent decision regarding children at the border in the United States, in California, she recently found that the sort of makeshift camps where the CBP was requiring children to remain as they wait to be processed for immigration court hearings to be a form of detention, and one that requires immediate reaction, response to limit detention times for children and improve conditions. The same logic applies to the migrant protection protocols and the required remain in Mexico as you are awaiting a hearing. And EOIR does categorize these cases as detained. In the MPP program, we found that virtually nobody received counsel. Only 3% of individuals in that program had lawyers. We also look separately at another institutional form, which is the institutional hearing program. And to connect to the prior panel in terms of how sort of, congressional lawmaking and different rules can create, these court spaces that really form how people access lawyers. The institutional hearing program has required individuals who are serving sentences or are held in local jails awaiting a criminal proceeding to have their immigration court hearing start. This creates a lot of impediments for accessing counsel. And we found in the IHP program, again, very low rates of representation. Only 13% of people found lawyers. We also find by looking at detained courts, there's, a lot of these detained courts are co-located with prisons, jails, or immigration detention centers. In other words, for those who aren't familiar with the immigration court system, the court is literally inside the prison, right? You need to have, ability to access the prison in terms of, complying with all the prison rules, getting authorization to enter. It's not easy, even if you're a lawyer, to enter one of these facilities to counsel a client, and then to enter the facility to also have your hearing inside, behind the barbed wire, inside this closed space. And we find within those co-located facilities also very low rates of representation. So for example, in Florence at the detention center there, only 17% found counsel. And that's despite having one of the best pro bono programs that's considered a model across the nation located within the detention center at Florence. And access to counsel in detention really matters. It matters because virtually all persons who appear before a detained immigration judge without a lawyer are ordered deported, 96%. So in this current paper, we look at, what are some of the features of detained immigration courts, and we identify what we argue is a structural disadvantage for people who have their case assigned to a detained immigration court. First of all, I think one thing that people may find surprising is that we really have a whole separate set of judges assigned to detained immigration courts. This is really a separate, it is, as we argue, a separate court, and it's adjudicated by a separate set of judges. And these judges are more likely to be male, 69% versus 56% in the non-detained courts. They're more likely to have past military experience, 23 versus 15%. They're more likely to have previously served as a DHS attorney, 62 versus 51%. They're more likely to have previously been a criminal prosecutor for a locality, state, or the Department of Justice, 45 versus 36%. So there's really stark, statistically meaningful differences between the judges that serve in detained and non-detained courts. And when you look nationally, judges tend to spend their career adjudicating almost exclusively one type of case or the other type of case. And this, we don't look at this in this particular paper, but there's a whole literature looking at sort of background characteristics of judges in immigration courts and sort of grant rates on asylum cases and other things. And so the sort of features that we identify in detained judges tend to be associated with lower grant rates. The geography of detained courts is also very distinct. We find that detained courts are more likely to be located in the South, closer to the border. The docketing speed is much faster. Detained cases are most frequently adjudicated in only one day, as we heard about in the prior panel. And this has been also regulated by a very different set of rules that has placed these cases on very fast timelines and binded detained judges to those timelines. And of course, just the fact of the geography of where these courts are located and where the detention centers are located makes it much harder for attorneys to access their clients, makes it harder for attorneys to access the actual hearings, and has increasingly segregated detained lawyers who handle detained cases from lawyers who handle non-detained cases. Because in many jurisdictions, as we found from interviewing lawyers around the country, it can be impossible to handle both cases in both courts at the same time. So if you have to, travel to Purcell, for example, to have your cases heard in front of a detained judge, you can't be at the non-detained courts in San Antonio that same morning. You really have to make a decision in terms of the cases and the court in which you are handling cases. So the last thing I wanted to talk about, and then leave it open for our discussion to conclude this panel, is a project that we're starting to work on now, which we are calling Revisiting Access to Counsel in Immigration Courts. And so this project is one that I don't yet have findings to share with you, but what we want to do is return to the prior paper that we will have published. By the time we publish this one, it'll be 10 years since the first study, and really re-ask the questions that we were asking before about access to counsel. We think this is a really important time to engage in this study because over the past 10 years, there has been a national movement to provide access to counsel in immigration courts. So we've seen localities and states, particularly in blue states, provide more and more funding to create sort of more of a right to appointed counsel, at least locally in a city like Los Angeles or statewide. So we think that this has sort of, and we know from studies that the Vera Institute has published, this has created many more nonprofit organizations that are handling high volumes of immigration court cases. So as opposed to when we did the study 10 years ago, the lion's share of lawyers who were handling cases in immigration courts are solo or small firm practitioners. So people who are either practicing entirely on their own in their own practice, or at a firm that's composed of 10 or fewer lawyers. That's sort of how we define small firm. But today we have more and more lawyers who are practicing at nonprofit organizations that tend to take sort of a higher caseload in terms of how the models are working out. So I think that's one really important question that we want to look at, is how is that shaping the landscape of lawyering and the practice of lawyering as we sort of shift who's handling those cases and the model of practice in which lawyers are coming at the work from. So I think I've used up my time. I'll end there, and I'm really looking forward to the discussion.
Well, thank you, Professor Egley. That was I did read your earlier article. Interesting to hear the follow-up on it. I wanted to ask you a question. Are you surprised? I wouldn't think, but again, you would know better than I, that most people who end up in the immigration system are, as you put it, they're not of means. So there's not, for lawyers, there's not a lot of money to be made there. So to hear you say that, I wasn't surprised to hear that it's small firms, that it's nonprofits. And certainly one of the things we see, with the debt load that students come out of college and law school with these days, that it's difficult for someone who's interested in doing that kind of work to actually be able to afford to do it. So how do you see moving forward mechanisms for increasing, I guess, just the availability of lawyers to do this kind of work?
Yeah, I mean, I think that the nonprofits are very important for this work, and I think that's a crucial area for practice. For those of you who are law students listening, there are increasingly fellowship opportunities and other nonprofit organizations that are hiring in this area. I know that we have a lot of students at UCLA that go into deportation defense, and the movement for universal representation has really made that possible. In terms of the small firm practices, this is also a very fruitful area for lawyers. You would think, I mean, look, people who are in immigration removal proceedings do have sort of limited access to resources.
Right.
But I was actually just on a panel on Friday that was talking about sort of community funding and community banking for people who are migrating. And oftentimes there's contributions coming from family members, in their home country, who are helping to support people. We see that, for example, with the representation rates of people from India, people from China, that I talked about earlier. So this is something that's incredibly important to people, to have access to a lawyer. People are able to provide at least some level of funding when resources are pooled. At least some segment of people who are in removal proceedings are able to do that. The piece that I failed to mention just now, which you're triggering me to mention, is also the role of big firms. So, and also as to the small lawyers, first of all, many of those cases are pro bono as well. Like small firm lawyers are an incredibly important source and a very generous source of pro bono representation. So just because someone's coming from a small firm doesn't necessarily mean that they are hired on every case. They could be a small firm lawyer in the immigration field, for example, that is handling business visas, but does a lot of pro bono work in removal defense. And I want to acknowledge that, because that is incredibly important in this space. But the other piece is the big firm lawyers. So when we see in the data, lawyers from, Arnold and Porter or Melvany or Jones Day, right? Some of these lawyers might have a small immigration practice, but when they're doing the removal defense, where you have, 50 lawyers from O'Melveny who are filing their EOIR 28s. These lawyers we sort of are very confident in saying, because we know that they have these large firm pro bono projects, are doing pro bono work. And we tend to find that lawyer representation associated with asylum cases. And we think in the recent study that we will be able to look more closely at the kind of work that the big law firms have been doing, and we think we'll find an increase in it overall, although we're not ready to make those conclusions yet. But there has, especially during the Trump administration, this really animated a lot of firms to start thinking more about doing immigration work, and with Human Rights First being one of the main really pro bono arms nationally, really, that has a huge number of volunteers and is training people. That has also enabled more and more large firm lawyers to come into this space and provide quality representation.
And before I turn it over to Professor Williams-Brewer and Damon-Feng to take our discussion across the finish line here, I do want to point out to everyone, with your UCLA background there, you said you were up late. It sounds like you never went to bed, because I know you had a call before. I know you had a call before this, and it was 6 a.m. out there when this panel started. So you were sitting there. It was dark outside when you started. So I really appreciate you doing that. You have a lot more energy than I would have displayed at 6 in the morning, put it that way. So thank you. And Professor Williams-Brewer and Damon-Feng, anything to add?
Well, you definitely get the award, the champion award, for being up the earliest. I thought I was up early this morning.
Yes.
I just wanted to comment that I really appreciate your work and what it's really adding to, from an empirical perspective as well, how you're really using empirical data, not only to give a framework of how we should even evaluate these sort of issues, but it just gives a framework for layering on the arguments, really why the right to counsel is important to implement. So I just wanted to just commend the empirical aspect of your work and just encourage you to keep going. We need it.
Yeah, I'll echo that and just say, as a former immigration legal services nonprofit lawyer, I did a lot of recruiting of pro bono lawyers at big firms to take on these cases and train them. And I used a lot of your statistics and your findings. So thank you for that. It generated a lot of interest, I think, and we were able to kind of boost capacity in that way. I'll just highlight maybe just 1 or 2 points that you made and kind of add a little bit of color to kind of what I have seen in those contexts. So in the detention context, you mentioned geography as a limiting factor for representation in a lot of ways, and that is certainly true. It's also interestingly the case that when a person is detained in any given center, they can be moved at the government's will to any other center, right? And they don't have a say-so in this process. And when that happens, you can imagine there's a lot of disruption in their ability to have counsel and keep counsel, right? So I've had clients be moved from the Adelanto Center, which is in Los Angeles, across the country to New York, down to Texas. And when that happens, you try to follow their case, but it's really, really difficult to do that, especially on these quick timelines. I've also seen the folks kind of, there's been debates around kind of closing down these immigration detention centers, especially the ones that are privately run. And I think that is an absolutely amazing goal, especially if the goal is to kind of shrink the size of detention generally across the immigration state. What happens though sometimes is that we don't see a shrinkage in the overall detention capacity. We just see more and more centers kind of crop up in more far-flung geographies, right? And so there's been a lot of discussion in Seattle, where I used to live, around closing the detention center that's located in Tacoma, right near Seattle. There's a lot of capacity relatively in those areas to take on this work. And when that detention center closes, one might imagine those people who were detained there being sent off to places like Idaho or these local jails that are more spread out across the state, or to other jurisdictions. There was a memo that the Trump administration put out saying, find any military base with any capacity, we'll just put people there, right? And those jurisdictions might not have as much capacity built up. And so when you do that, you would then kind of, again, erect barriers to accessing counsel. So there are all these levers that are being pulled that work together in tandem, that I think are worth kind of considering across the board as we have these discussions. And so again, just want to echo the folks' points that have been making, that counsel is super important. And thank you again for all of your work, and Judge Brewer as well, your work in these spaces, because it's so important to have judges that are mindful of these issues and using their discretion to kind of bolster people's abilities to make their claims and defend themselves in these positions.
Well, speaking of, what we touched on before about how the government erects barriers within the system, certainly using military bases to house people. There aren't a lot of military bases in the middle of New York or large cities. They have a tendency to be in more rural areas because that's, so consequently the number of lawyers there is also more limited. So I can't imagine how you manage to, follow your cases around as they jump from city to city. So certainly, this is all, I was interested to read everyone's work and hear what everyone had to say. And I certainly learned a lot here. So I thank all of you for taking the time. Obviously, all of you are experts in your field, and it certainly came across in your presentations. I'd also like to thank Carrie Nace, who's the Widener Law Review Symposium leader, for helping put this together. And also, I know all of you know Jill Family, Professor Family. So that's, thanks to her also. And I don't see any questions from anyone. So I think we're at 10:15 and there's a break until 10:30. So does anyone have any final words that they'd like to impart before the IT people pull the plug?
No risk
right.
of IT pulling the plug, but thank you all for attending. Thank you guys for joining us this morning. I am Carrie Nace. I'll be in two different screens today. But as he said, there is a break built into the schedule. Take a moment, clear your Fitbit alerts, get a cup of coffee, take care of any personal needs, and we'll see you back here around 10:30. So thank you, panelists. That was phenomenal. We really appreciate you joining us today.
Thank you for all you've done, Carrie.
Thank you.
Thank you.
All right, welcome back. It's just about 10:30, so we'll get started with the new challenges in adjudication and judicial review. Moderating today's panel is Professor Sarah Eberhardt of Widener Commonwealth. And from there, I will pass it over to her to take control.
Thanks, Carrie. Appreciate that. Good morning, everybody. Thank you for joining us. We've got a wonderful panel here. We are well aware that we are the warm-up act for the keynote that's coming up after us, so we will do our best to get the crowd pumped up today. So I am not going to waste much time here. I'm going to briefly introduce our speakers, and then what we're going to do is I'm going to ask them each a question, give them about 10 minutes of response time, and then we're going to leave time for questions at the end. If you have questions for the speakers, please go ahead and type them in the chat. If you want to address it to a specific speaker, it'd be helpful if you could specify that, and then we'll address all those questions at the end. So we have Professor Bridget Dooling from the Ohio State University Law School, Professor Emily Bremer from Notre Dame Law, Assistant Professor Adam Cruz from Rutgers Law School, Professor Ronald Levine from Washington University School of Law, and Professor Jeffrey Lubers from American University. We're going to kick it off with Professor Bremer. So Professor Bremer, does the APA authorize reviewing courts to vacate challenged agency action?
Thank you, and thank you so much for having me today. So I'm going to give you a really clear answer to that question, and the answer is yes. This, of course, is something that has been subject to a lot of debate, and I think I'm coming at it from a bit of a different perspective. I have sort of a new theory to offer. But first, I think I need to give you some context, because the truth is maybe 5 years ago or so, nobody was asking this question, right? So as Chief Justice Roberts said in an oral argument last term, DC circuit judges vacate agency action 5 times a day before breakfast. It's just what you do in an APA case. And so I think the first thing to understand is like why we're having this debate. And I think it's best understood as an outgrowth over the longer running debate over universal or nationwide injunctions, right? And this involves situations in which judges, often district court judges, have issued injunctions that don't just enjoin the agency from taking action against the parties who are before the court, but purport to enjoin the agency from enforcing a policy against anyone, including anyone outside of the territorial jurisdiction of the court in question, right? And scholars of remedies and of equity have said, well, wait a second, that's inconsistent with the limitations on the judicial power to issue injunctions. And so there's been sort of a wide-ranging debate about that. The scholar, of course, that's sort of most salient to me in that vein is my colleague Sam Bray. And then as that debate has been going on, and the scholars who sort of argue against nationwide injunctions, I think have gained some traction, especially perhaps among the more conservative members of the Supreme Court. People, I think, quite naturally started to realize, well, wait a second, what about vacatur? Right, because courts routinely vacate agency action on review, and especially when they vacate or, which is to say they nullify an agency action that's a rule, that has the same sort of effect as a nationwide injunction in the sense that it offers relief not only to the parties who are before the court, but to anybody else against whom that agency might have enforced that rule. Now, in the debate over vacatur, and I think that's in part because it's coming out of this debate over injunctions, the premise has been that vacatur is a remedy, right? Like an injunction, like a declaratory judgment. And if you approach it from that remedial perspective, there are a couple of points that I think have some real force, right? One is that there's no such remedy that seems to have been understood to exist at the time the APA was enacted in 1946. Right, the APA mentions injunctions and declaratory orders in Section 703, but it doesn't mention vacatur. Set aside the language that people usually point to as the basis for a judicial vacatur. It appears in Section 706, not alongside the other mentions of remedies. And if you look in the legislative history and in the contemporaneous discussions of the APA, you just don't see a discussion of a remedy called vacatur. Right now, on the other side, proponents of vacatur, like my co-panelists Ron Levin and Mila Sohoni, have done a really wonderful job of very exhaustively showing how courts in the pre-APA period used proceedings for injunctions and declaratory orders to consider requests to annul or set aside agency action. Now, overwhelmingly, the debate on sort of both sides of vacatur, again, has sort of accepted the premise that vacatur is a remedy. And my principal thesis is that premise is wrong, that vacatur is not a remedy, it's an appellate determination. And I'm really building on the work of Tom Merrill. He and others have established, right, that the APA codified an appellate model of judicial review. And the first implication of that is that instead of looking to pre-APA administrative law alone or looking to pre-APA remedial law, we should also be looking at pre-APA appellate principles, right? The law that in the decades before the APA was enacted would have defined what it means to say that the APA erects an appellate model of judicial review. And so if you look at it from that lens, where you're going to look is the law of appeal and error, which were the two devices, one from equity and one from law, that were the principal devices that sort of defined the appellate jurisdiction. Those devices were merged along with the sort of broader merger of law and equity, and they were subject to really substantial reform themselves in the decades preceding the APA's enactment, right? And in fact, the justices of the Supreme Court who developed the appellate model of judicial review for administrative action were really actively involved in procedural reform and reform of judicial organization, such that they would have been, I think, really very much steeped in the law that governs that appellate relationship. Now, it can be really easy to get mired in the details, but the truth is that the details actually don't matter all that much. And the reason is because the governing principles of appeal and error of the appellate relationship map so nicely onto the APA's judicial review provisions, right? So, and I'll give you a few examples, and actually this will pretty much run through all of the provisions of judicial review in the APA, right? So first of all, appeal and error spent a lot of time defining the parties who could appeal, right? Who has the right to review of a lower court's determination? And the principle that rises to the fore in the pre-APA period is the principle that the only parties who can appeal are those who are adversely affected or aggrieved by an erroneous judgment. Now, of course, that principle is codified in Section 702 of the APA. Another principle, a big focus of the law of appeal and error, is that there are only certain kinds of judgments that are reviewable by appellate courts, right? Appealable judgments are only final judgments, not interlocutory decisions. And again, that's exactly the same in the APA, which submits to judicial review only final agency action. That's codified in Section 704, right? Another really substantial focus in the law of an appeal and error is in defining the limits of an appellate court's jurisdiction or power, right? Part of the focus is on keeping them in their sort of proper role, not allowing appellate courts to meddle in matters that are confided to the discretion of the trial court, right? Again, that principle also appears in the APA and Section 701. There's a huge focus in the law of appeal and error on defining what constitutes reversible error and specifying the appropriate basis for a determination that a lower court has erred, right? And the core principle is really sort of the idea that the primary purpose of appellate courts is to control the development of the law, right? And so you see emerging in the early half of the 20th century, a proposition that there should be more robust review on questions of law, more deferential review on matters of discretion and on findings of fact, that appellate courts should not, be a second trial court, but instead should review the judgment that's on appeal based on the record that was before the trial court. Now, of course, all of these principles are codified in Section 706 of the APA, right? And then another chunk of appeal and error, and this is the one that I'll sort of end with, because I think we're going to be almost out of APA provisions actually at this point, is the procedural matters, right? How do you take and perfect an appeal? And of course, the APA also has this kinds of procedural provision in Section 703 specifying the form of action and the venue, right? And so the question, coming back to where we started, is whether or not that language in Section 706, hold unlawful and set aside, has a clearer meaning when you view it through the appellate lens rather than through the remedial lens. And the question is, the answer is absolutely yes, right? The treatises on appeal and error and an appellate procedure that I've been spending an awful lot of time reading reveal a really narrow range of options for appellate courts, right? They could reverse, affirm, modify. You have over time a developing practice of remanding to lower courts with instructions for further proceedings. And you find at the time in the sort of first half of the 20th century that reversal is broadly understood to have the effect of nullifying, of vacating, of setting aside the judgment that's under review, right? These are treated as synonyms. You can see this in the treatises, but also in, Black's Law Dictionary, right? Even in the U.S. Code, right? So 28 U.S.C. Section 2106, which of course defines appellate judicial determinations, right? In its current form, which dates to the 1948 codification of the Judicial Code, so contemporaneous with the APA, provides, quote, the Supreme Court or any other court of appellate jurisdiction may affirm, modify, vacate, set aside, or reverse any judgment, decree, or order of a court lawfully brought before it for review, and may remand the cause and direct the entry of such appropriate judgment, decree, or order, or require such further proceedings to be had as may be just under the circumstances. So this all just maps on directly to the APA. Now, I'll end here because the final point that's frequently made is that, well, things have changed since 1946 in the sense that even if this kind of appellate control of adjudicatory decisions is appropriate, and remember, in 1946, most agency action was adjudication. Something should be different now because we have had the shift to rulemaking. Most agency action that is on review now tends to involve rules, and maybe there's a sort of more of a question of whether or not the APA's drafters really intended for courts to vacate rules the way a court would vacate a judgment. And I think the answer to that actually is clearly yes. People point to Abbott Labs, a much later case, as sort of the origin of pre-enforcement review of rules, but that's just wrong. There are opinions in the pre-APA period, including the one that's most notable for me is a 1942 decision from the Supreme Court involving a review of FCC regulations and saying, no, when regulations have the force of law, they fall within the sort of category of agency actions that are properly reviewed and can be set aside if unlawful. So I'll end there, and I'm looking forward to all the other presentations.
Thank you so much, Professor Bremer. I really appreciate all those insights. I'm going to turn it over to Professor Cruz. How are the lower courts carrying out or implementing some of the administrative law trends that we've seen at the Supreme Court in recent years?
Well, first of all, thank you as well so much for having us here today. When I was thinking about this issue of sort of new challenges in judicial review, one of the most interesting challenges that I think arises across any area of law is anytime the Supreme Court announces doctrinal change, a lot of times you're going to get an opinion that says some big, broad, kind of mushy stuff, and the real action is going to be in the years that follow in the circuit courts that have to sort of make an administrable rule out of this. And in the last several years, we've really had no shortage of doctrinal change in the administrative law space from Supreme Court opinions. And a lot of those doctrinal changes have been described very broadly as sort of anti-administrativist. That is, we've had a lot of decisions that come out adverse to agencies, but not only adverse on the doctrine, but also these are also accompanied often by a sort of anti-administrative state rhetoric, right? You'll see a lot of language in the opinions that sort of says agencies and agency actions lack democratic accountability, lack political accountability. Some of these actions, because of this lack of democratic accountability, are threats to individual personal liberty. So there's sort of this underlying mood behind these decisions that says, you know, not only are we handing you a new doctrine that's anti-administration, but also lower courts, we're signaling to you sort of a general skepticism of the administrative state that you ought to be taking with you. So one thing I've been very interested in is seeing the extent to which circuit courts, lower courts are taking that broader signal, that anti-administrativist signal, and running with it, as opposed to maybe putting up some resistance, finding some areas where they can take these doctrinal changes and make it perhaps less anti-administrativist on the ground. So I want to talk about two situations in particular where I think there's maybe a counter narrative of lower courts trying to make things not as bad as they might otherwise be if you have some objections to some of these doctrinal innovations. So one of these is in the space of the major questions doctrine. I'm not going to speak too much about the major questions doctrine itself because another panelist is going to go, I think, more in depth on that. But suffice it to say, a couple of years ago in West Virginia against EPA, the Supreme Court sort of crystallized this canon that we're now calling the formalized major questions canon, which really enforces limitations on when a court should allow an agency to claim some sweeping new power and expand the scope of its regulatory scope. And to read that opinion, it's not exactly a model of clarity. There's a lot of moving pieces going on that sort of motivate when the major questions doctrine might be justified in applying. So one of the interesting things to look at on the ground is from all of those moving pieces in the opinion, what are the circuit courts gravitating around? And it might not be surprising to learn that different circuits are having different approaches. So certainly there are some circuits that are generally regarded as more conservative leaning, more formalist, more in line with, or perhaps even to the right of the current Supreme Court that are really running full force with the major questions doctrine. The Fifth Circuit's a really good example. There have been a number of Fifth Circuit opinions that have looked at the major questions doctrine and said, really, this doctrine is triggered simply by the existence of a question that is of political and economic significance. It's sort of just a one-factor, very narrowly focused test that's going to allow the doctrine to be implicated in lots of situations. But even within this court, which is more willing to apply the major questions doctrine, one of the challenges that we're seeing even intra-circuit in the Fifth Circuit is that from conservative jurist to conservative jurist, there's not a lot of agreement or uniformity about what it means for something to be politically or economically significant. We see some jurists who have gestured kind of broadly at the idea that this is implicated anytime the political process has sort of been talking about or thinking about an issue in recent years. Other opinions have sort of taken the approach and said economic significance goes to sort of value, dollar value out in the market. So a lot of confusion, even when there's this effort to have a very aggressive application of this doctrine that will reign in the administrative state. By contrast, you can look at an approach at a court like the Fourth Circuit, which is generally regarded today as more progressive than, especially when compared to the Fifth Circuit. The Fourth Circuit has taken a very opposite approach. Rather than having this sort of one-factor political or economic significance test, the Fourth Circuit, in its leading opinion applying the major questions doctrine, was very careful to go through West Virginia against EPA and identify as many possible motivating factors as it could. And the Fourth Circuit said, if you read West Virginia against EPA and take it quite seriously, there are at least 5 factors that courts should be thinking about before they invoke this doctrine. So they've really leaned into this idea that the major questions doctrine should apply only in very exceptional cases where lots and lots of boxes are being checked on the front end. And in that regard, we might see a vision being painted by the Fourth Circuit for how other courts that are more skeptical of the major questions doctrine can put a gloss on that doctrine that will sort of brunt the effect, the anti-administrative effect that might otherwise be felt if we more broadly adopted the Fifth Circuit's view. Another trend that I've been seeing in the circuit courts that I think might have some promise for a counter narrative against this idea of anti-administrativism is a resurgence in interest in the Vermont Yankee doctrine. So Vermont Yankee is this canonical case from 1978 where, broadly speaking, the Supreme Court said, reviewing courts should not impose judge-made procedures that aren't contained in the statute. At the time, they were talking specifically about the APA, that aren't contained in the statute onto agencies. Agencies should be able to pursue sort of reasonable methods of inquiry to carry out their delegated authority. That seems like a pretty straightforward and simple enough rule. And there wasn't a lot of attention paid to Vermont Yankee as a doctrine for quite some time. Starting in the early 1990s, actually, the Supreme Court never cited Vermont Yankee once for about 20 years. And it wasn't until 2015 that the Supreme Court invoked Vermont Yankee as sort of a substantive part of its reasoning, again, saying to take this principle and use it to overturn what a lower court had done on the ground that the lower court had, in effect, imposed additional procedures that weren't justified by statutory text. Since that revitalized interest in Vermont Yankee in 2015, the Supreme Court has invoked the case again and again in a lot of recent decisions. A couple of them in the rulemaking space, where again, the Supreme Court has used Vermont Yankee to disavow certain lower court doctrines that have the effect of forcing agencies to engage in more procedures, but also in some important adjudication cases. There are 2 recent cases at the Supreme Court that were immigration matters, where applicants for immigration relief had challenged agency action on the ground that they had been entitled to more or better procedures at the agency. And the Supreme Court invoked Vermont Yankee as the way to brush that aside. That interest in Vermont Yankee at the Supreme Court, I think, has been picked up on by circuit court judges. I went back, and in that same period from 2015, when the Supreme Court started showing interest again, to the present day, there's been a noticeable uptick in circuit court citations to Vermont Yankee. And disproportionately, this uptick in citations is coming from traditionally conservative judges who have really gravitated towards using Vermont Yankee and rallying to its defense and urging its application in particular cases. And what makes this so interesting to me is that a lot of what these conservative judges are doing when they invoke Vermont Yankee is engaging in a type of analysis that looks an awful lot like Chevron. So you'll often see these conservative panels that are confronted with an argument that some procedure spelled out in some agency's organic statute required the agency to do X, Y, or Z. And what these conservative judges will do is say, well, the statute doesn't plainly require that specific procedure. And what the agency did instead seems within a zone of reasonableness. Therefore, we can't tell the agency to do something else. See Vermont Yankee. That sort of two-step approach is, in substance, a lot of what Chevron would ordinarily call on us to do. Yet these conservative judges, who we tend to associate with being critical of Chevron and with being critical of deference to agencies, have no problem whatsoever deferring on these complicated procedural questions, using that same method of analysis, but citing the Vermont Yankee rather than Chevron. So as we look at sort of a perhaps emerging challenge, if we live in a world where the Supreme Court, as many people expect this term, abandons or modifies the Chevron doctrine, I think realistically, we're never going to be fully able to get rid of deference. We'll spend the next several years rebuilding some sort of deference doctrine. And one possibility to do that might be through the lens of Vermont Yankee and just taking this familiar mode of analysis from Chevron and calling it a Vermont Yankee deference or a Vermont Yankee mode of analysis, which isn't going to offend a lot of the critics who have been pushing for reforming Chevron. So in that sense, I think this too shows some promise for overcoming an anti-administrativist challenge that might be coming down the pipeline. And so with that, I'll hand it back to you.
All right, thank you so much, Professor Cruz. I appreciate those thoughts. And you have teed up Professor Levin quite nicely because he's going to be talking to us about the major questions doctrine and telling us what he thinks about it.
Well, thank you. Thank you, Sarah. I appreciate the invitation to join this symposium, and I appreciate all the work that the Law Review has done, Carrie in particular, for organizing it. And I'm happy to be on a roster of these very distinguished speakers to discuss a variety of interesting topics. And I heard Sarah say that our function here is to get the audience pumped up in preparation for Judge Child. So I'll try to do my part by giving a suitably inflammatory speech about the major questions doctrine, which I am fairly critical of. I'm going to summarize a few of the points I'll be making in an article that I'll be publishing in June in the California Law Review. It's available now on SSRN for those who'd like to read it now. I trust that most or all of you are at least vaguely familiar with the major questions doctrine, which the Roberts Court has deployed during the last few years to invalidate EPA rules on emissions from power plants and health requirements that OSHA imposed during the COVID pandemic and the Biden student loan program and so forth. And it's not very easy to define what the doctrine is, which is part of the problem, as Adam mentioned, and I'll explain further. But roughly speaking, I think the doctrine signifies that an administrative agency may not adopt a regulation that has vast economic and political consequences unless the agency has clear congressional authorization for the rule. That is a more secure foundation in legislation that would be required in the case of most regulations. While the bulk of academic commentary on the major questions doctrine has been critical, but much of that commentary has focused on issues such as how it has bad consequences, how it should be interpreted, whether it's consistent with textualism, and so forth. And my article has a different focus because it suggests that the doctrine has a serious legitimacy problem, because the court has made no serious effort to justify the existence of the doctrine, or so I'm going to assert. The court came closest to trying to justify the doctrine in 2022 in West Virginia versus EPA. Chief Justice Roberts' opinion for the majority devoted several pages to arguing that the court had already applied the doctrine in a host of cases. So my forthcoming article spends about 20 pages reviewing each of those cases and explaining why they didn't exactly provide the precedential support that Roberts claimed for them. Now, we all know the court does frequently overstate the teachings of past cases, but I would say the West Virginia opinion was exceptional in the extent to which the court used exaggerated accounts of its case law as a substitute for analysis rather than a supplement for it. Chief Justice Roberts also relied heavily on what he said was a presumption that Congress itself would not use ambiguous language to confer on agencies the authority to adopt rules with a major economic and political impact. But the big problem with that reasoning is that in the past, the court has found many times that Congress did confer such authority in statutes that use broad language such as public interest, convenience, and necessity, or just and reasonable rates, or requisite to protect the public health, and so forth. Many of those laws were enacted by Congresses that were a good deal more liberal than the current court is. So I think the best explanation for the presumption under discussion is that the justices in the Supreme Court majority have projected their own skepticism about the regulatory state onto the legislative branch. In short, I think the court's been remarkably inarticulate about the reasons, if any, that underlie the major questions doctrine. However, some of the individual justices in the majority have deployed more elaborate defenses of the doctrine in concurring opinions. So I want to spend some time discussing those opinions. I have in mind specifically Justice Gorsuch's argument in the employee vaccination case, NFIB against OSHA, which rested on the non-delegation doctrine, and also Justice Barrett's concurrence in the student loans case, Biden v. Nebraska, which sought to justify the doctrine as a so-called linguistic canon. First, as to Justice Gorsuch's position, quite a few commentators have taken it for granted that the major questions doctrine appears to be an offshoot or variant of the non-delegation doctrine. But I see a number of problems with that equation, which may help to explain why the court as a whole has never endorsed that supposed linkage. In the first place, the theory seems to rest on the vigorous non-delegation doctrine that Justice Gorsuch would like to see, rather than the essentially toothless non-delegation doctrine that we actually have. Relative to the latter baseline, the major questions doctrine can't be explained as constitutional avoidance because the statutes involved in those cases have no constitutional problem that needs avoiding. Furthermore, even if we assume for the sake of argument that a reinvigorated non-delegation doctrine could come into existence, a serious difficulty with Justice Gorsuch's theory is it doesn't provide a satisfying basis for distinguishing major questions from non-major questions. If Congress's decision to delegate authority to an administrative agency is constitutionally suspect, logically that problem would seem to exist, regardless of whether the resulting regulation would be expensive or not so expensive. Justice Gorsuch tried to justify that distinction by relying on a dictum that John Marshall wrote in 1825, suggesting that there is some category of matters that are too important to delegate. But Chief Justice Marshall said nothing to explain why that distinction would or should be drawn. And the court has never in 200 years elaborated on what matters would fall into that category. I think it's quite a stretch to contend that this long neglected dictum can provide authoritative support 2 centuries later for a newly created judicial review doctrine in the 21st century. For her part, Justice Barrett contends that all statutes should be interpreted in light of their context, which in her mind includes what she calls common sense limits on the breadth of whatever delegation is involved. But a problem with Justice Barrett's theory, in my view, is that common sense is very much in the eye of the beholder. In fact, she claims that all the court's holdings in the major questions cases can be explained on the basis of her theory. And yet in all of those cases, the court was deeply divided. So her theory seems to assume that the conservatives on the court possess common sense and the liberals on the court don't have common sense. I mean, you can believe what you want about that proposition, but I seriously doubt that a jurisprudential approach that rests on such a premise can be viable. So if none of the rationales actually put forward by the majority justices holds water, what's actually going on? I want to take a minute to discuss what I believe the majority probably thinks it's doing in these cases, although it hasn't said so. The court probably thinks of the major questions doctrine as a substantive canon, which is adopted as an exercise of its power to create administrative common law. Unlike the other theories I've discussed, this explanation does strike me as internally logical and coherent. But it does have a big problem of its own, which I call a problem of legitimacy. It basically amounts to the majority justices writing their own ideological preferences into the fabric of administrative law. And that move is very hard to reconcile with the justices' often repeated assurance that they sit to enforce neutral principles of law and not to implement their own value preferences into the law. And one final basis for objecting to the major questions doctrine is that its outer boundaries are completely undefined, at least at the court level, which is why we see the dissonance that Adam was talking about. I think supporters of the doctrine might reply that that's a cheap shot, because plenty of other doctrines in administrative law are also ill-defined, like what does arbitrary and capricious mean? Or how ambiguous does a statute have to be in order to survive scrutiny under Chevron step 1? But I contend that the major questions doctrine is unique in at least one respect. Not one of the justices who support the major questions doctrine has ever written a single sentence in any opinion to tell us what circumstances would not trigger the doctrine. The court literally acknowledges no limits on its prerogative to decide what is or is not a major question, which does give it a certain lawless character. So to conclude, I don't expect the major questions doctrine to go away anytime soon. But if people come to appreciate the extent to which the court's creation of this doctrine has been unexplained and maybe is illegitimate, the court might feel pressure to apply the doctrine with greater restraint than it has yet shown. And I hope that's sufficiently inflammatory, but I'll now turn the podium over to others.
All right, thank you very much, Professor. Yes, that was sheer rock and roll. No, I agree with a lot of your points. Teaching the major questions doctrine, I have some of my students that are on this conference today. They can probably agree that, I don't know, it is migraine inducing for law professors. That's that's for sure. That's something we can probably all agree on. All right. Moving on, I'm going to turn it over to Professor Lubers. Professor Lubers is going to take us in a slightly different direction. What does Jarchese portend for the future of agency enforcement?
Well, thank you, Professor Everhart, and special thanks to Carrie Nace for accommodating my teaching schedule today and for organizing the whole program. The Jarchese, and that's how it's pronounced according to his counsel in the Supreme Court, the Jarchese case has potentially dire implications for both agency enforcement and for administrative law judges. In that case, the Fifth Circuit invalidated an SEC enforcement action in which an SEC ALJ, affirmed by the SEC, found that Mr. Jarchese and his hedge fund violated the securities laws by engaging in several types of fraudulent behavior. According to the government's cert petition, Mr. Jarchese falsely represented to brokers and investors that a prominent accounting firm served as the fund's auditor and that a prominent investment bank served as their prime broker when that wasn't the case. Second, he allegedly misrepresented the fund's investment strategies. And third, he allegedly overvalued the fund's holdings. For example, by arbitrarily inflating the value of certain holdings from 30 cents per share to $3.30 per share so that they could charge higher management fees. The SEC ordered him to cease and desist from committing further violations and to pay a civil penalty of $300,000, and it ordered his hedge fund to disgorge nearly $685,000 in ill-gotten gains. The commission also barred Jarchese from various security industry activities. But the Fifth Circuit, in a 2-to-1 panel decision, overturned the order on 3 independent grounds and denied rehearing on bank. The 3 grounds were that first, the in-house SEC adjudication that imposed the civil penalty for fraud liability offends the Seventh Amendment's right to a jury trial and should instead have been brought in federal court. Second, that Congress violated the non-delegation doctrine by providing the SEC with no intelligible principle for deciding whether to pursue a civil penalty action before an administrative law judge or in a federal court. And I should note here that the SEC is one of the very few agencies that can make that choice itself. And third, that because both the SEC ALJs and the SEC members have for-cause removal protection, that violates the constitutional rule from the 2010 decision in Free Enterprise Fund versus PCAOB that Congress cannot impose 2 levels of removal protection between officers like ALJs and the president. The Supreme Court granted cert on all three issues, any one of which, if affirmed, could be extremely disruptive to agency enforcement power. A potential ruling that SEC ALJs cannot be protected by for-cause removal protection was the issue that got the most attention when cert was first granted. And it was the issue I was most worried about because if the argument is accepted by the court, it would be a huge blow to ALJs across the government and to the fairness of agency enforcement if they become at-will employees due to this case. But curiously, in the oral argument, there was only one brief Q&A on this issue. Otherwise, the nearly 2-hour oral argument solely focused on the right to a jury trial issue. Before the oral argument, I had thought that the jury trial issue was a non-starter because the 1977 Atlas Roofing versus Osherick case seemed to have definitively settled the issue by holding that Congress could assign a civil penalty adjudication to an agency. And if it did so, there was no right to a jury trial. The court held there that the Osherick civil penalties were a means of enforcing a public right rather than a private right, a distinction developed in earlier cases that in part looked to see whether the issue in the case was a new type of case involving the government as a party or a type of private common law lawsuit that dated back to Old England. To be sure, the court clarified 9 years later in the Tull case that when Congress did require agencies to go to district court to collect penalties, as under the Clean Water Act, the jury trial right would still obtain. These precedents would seem to have settled the issue as Justice Kagan insisted in her questioning, but the Fifth Circuit distinguished the SEC fraud enforcement case as being similar to private fraud litigation in Old England and determined that it was therefore a private rights type of case, unlike the workplace violations in Atlas Roofing. From the oral argument, it seemed clear that Justices Gorsuch, Thomas, Alito, and Kavanaugh were quite dubious that Congress should be able to control the Seventh Amendment jury trial right by simply choosing which forum to assign the case to. Justices Kagan, Sotomayor, and Jackson seemed to feel there was no reason to distinguish or overrule Atlas Roofing, and that a statutory fraud prosecution was very different from a common law fraud case anyway. So that leaves the Chief Justice and Justice Barrett, and I think they will be looking to overturn this action in the most narrow way possible. How could they do that? Well, they could say only that the jury trial right extends to SEC fraud cases, but that might leave a lot of unanswered questions about other agency enforcement cases that cover fraudulent conduct. They could extend it to all SEC civil money penalty cases, or even all agency civil money penalty cases. Or they could go all the way and extend it to all agency enforcement cases. My hope is that if they do rule for jarcossy, they will base their ruling on the peculiarity of the SEC's power to choose the forum, court or in-house adjudication. That way, the court could avoid overturning the Atlas Roofing and Tull cases by saying that those decisions were founded on the right of Congress to choose the forum, and along with it, the right to a jury trial. But that in the case of the SEC statute, the Congress failed to make that choice. But if the court were to rule more broadly and reverse itself on the principle that Article 3 permits Congress to assign public rights cases to non-Article 3 tribunals, and that when Congress does so, the Seventh Amendment does not apply, then we would be back to the pre-1970s era when there was severe under-enforcement of agency regulatory statutes. At that time, the traditional civil money penalty statute enacted by Congress did require that the enforcing agency resort to a court for collection. Under that scheme, the agency would notify the respondent of a violation, there would be some settlement negotiation, and if that failed, the agency would assess a penalty. If the respondent didn't pay, the agency would have to go through the Department of Justice, normally meaning the local U.S. attorney, and seek to collect in the appropriate U.S. district court. In that proceeding, the respondent would have a right to a jury trial. Needless to say, this was cumbersome, and many U.S. attorneys did not want to prosecute cases that would require them to learn a whole new body of regulatory law and go through a time-consuming trial, potentially against a locally powerful defendant, all for a relatively small penalty that would flow into the general treasury. So in 1972, the Administrative Conference of the US, ACUS, looked at this situation before I started working there, by the way, and suggested a different model, the administrative imposition model, in which Congress would authorize the agency to assess the penalty itself, but only after giving respondents a right to a full APA hearing before one of its ALJs. After that, and any agency appellate review, the respondent could seek judicial review in the Court of Appeals, but on the record of the agency proceeding, not a trial de novo. This model began to be accepted by Congress, and numerous statutes began to incorporate it. In 1978, in the Atlas Roofing case, the Supreme Court basically validated this model, and a later ACUS study showed a much higher level of enforcement through civil money penalties. Justice Kavanaugh cited the ACUS study during the oral argument, so hopefully he may have read it. Anyway, I would not want to go back to the bad old days of the court collection model. Equally troubling would be a court ruling that ALJ's for cause removal protections are unconstitutional. That would also turn the clock back with respect to ALJs, but back even farther to the time before the APA, when the 1941 Attorney General's Committee report bemoaned the variability and lack of independence of agency hearing officers, as they were then called. When mixed with the now open-ended selection of ALJs based on President Trump's Executive Order 13843, so that now is no longer, the selection is no longer limited to lawyers with at least 7 years of experience who have been certified as qualified by OPM, the elimination of their removal protections would deal a fatal blow to the position of ALJ, in my opinion. I do see a way out of this potential problem. The court could stand up for the principle that the independence of purely adjudicative officers, whether principal or inferior officers, can and should be protected by for cause removal. In the 1958 case of Widener versus United States, for example, the court held that the members of the War Claims Tribunal could not be removed for cause, except for cause, even though the agency's statute was silent on this issue because it was a purely adjudicative body. And in the now famous footnote 10 of Free Enterprise Fund, Chief Justice Roberts wrote, "Our holding here also does not address the subset of independent agency employees who serve as administrative law judges. Unlike members of the PCAOB, many ALJs, of course, perform adjudicative rather than enforcement or policymaking functions." So I think the court can and should hold that Congress may provide for removal protection for purely adjudicative officers, whether they are principal officers like the members of the War Claims Commission or inferior officers like ALJs. Such a holding would also apply to the purely adjudicative members of commissions like the Occupational Safety and Health Review Commission, Federal Mine Safety and Health Review Commission, and importantly, the Merit Systems Protection Board. It would also apply to the 4 Article I courts we have, the Tax Court, Court of Federal Claims, Court of Appeals for Veterans Claims, and the Court of Appeals for the Armed Forces. Each of them are purely adjudicatory bodies with judges who are also protected from removal except for cause. Such a holding could also apply to some non-ALJ adjudicators like immigration judges and agency appeal boards if Congress wanted to provide them with independence. In fact, if this court is so concerned about the power of the administrative state and the unfairness of agency enforcement proceedings, why would they want to reduce the independence of adjudicative fact finders? So in conclusion, I think there are very strong reasons for rejecting all 3 reasons given by the Fifth Circuit in overturning the SEC's enforcement action in Jarkissi, amply voiced, by the way, in the panel dissent by Judge Eugene Davis. I'm not too optimistic that a majority can be mustered for that on this Supreme Court, but I do have some hope for a very narrow decision. Thank you.
Yeah, thank you, Professor. I appreciate that. Okay, well, yet another direction. It's really exciting that we've got so many interesting perspectives on this panel. And last but not least, Professor Dooling is going to speak to us about generative AI. She's been doing some writing about generative AI, and I'm hoping she can talk to us about how generative AI might intersect with agency practice and judicial review.
Thank you so much. Yes, we are really covering a lot of ground here on this panel, so just hang on, everybody. I'm going to cover something rather less doctrinal. I'm going to talk to you about the intersection of some emerging tech and particularly the rulemaking space, not just how agencies make rules, but then, what happens when they get to the point where they're being reviewed in court. So rulemaking is my specialty, I would say. Before I came to academia, I spent 10 years in the Office of Information Regulatory Affairs, working with agencies like FDA and the Veterans and, VA and all kinds of different agencies on their rules before those rules, were released to the public. So I tend to do a lot of writing on regulatory process and sort of the inside of how agencies make rules. So when I started hearing more and more, and generative AI kind of took the world by storm, naturally for me, I was thinking about, okay, what does this mean for regulation? Because rulemaking generates a lot of text, both in terms of regulatory text itself, that is, the binding language that becomes law. But also those sometimes voluminous explanations from agencies where they describe the choices that they're making and their reasons for how they, exercise discretion. And judges also work with a lot of text, as we know, both in terms of the material in the docket, particularly for rulemaking cases. These rules can be up thousands of pages long, as well as supporting materials, and then of course the judge's own written output, that is opinions and orders, that kind of thing. So generative AI, and I'll just digress briefly in case that term is not unknown to you. By that I mean the class of tools like ChatGPT and these other sort of fun things that popped up and have been in the headlines a lot. These are tools that are trained on a large amount of text, and you key in a prompt directing them to generate some kind of text. So you could say, write me a love story, or write me a catchy song or catchy jingle, and it will oblige. There's no particular reason that you couldn't use these tools to generate legal documents. And so there's lots of people in legal academia thinking about like how this will affect lots of areas of legal practice, as I'm sure you all know. So that's what I mean. And the purpose of this talk is just to go through in a little bit more detail what those might mean for rulemaking. So who might use those tools in the regulatory process? I've got just a quick list of 4: the public, regulatory agencies, the e-rulemaking program, which is something that you might be less familiar with, and then the courts. So I'll just go through those in turn. And I'll try to spend more time on the court portion, given the topic of our panel. But the public might be interested to know that a rule is coming out. This is sort of the perennial challenge, is figuring out how to get new rules on the radar of members of the public who might be interested. So you can think of different tools are sort of always crawling through large amounts of text in order to basically put an alert out for you that something is related to your interests. But more particularly when it comes to generative AI, once you want to write a comment, you might use a generative AI system to help support you in crafting that comment. So in our system, it's okay to send comments in almost any format. So that leads to a wide range of formatting and structures of comments from the public. And that's not necessarily a bad thing at all. Our system permits it. But it's also probably true that some kinds of public comments are more helpful or persuasive to an agency, and that writing, good persuasive comments is something of an art. And we know that generative AI is good at mimicking forms of text. So perhaps a member of the public could use generative AI to help them draft a comment. An agency could also create something like this, build it into their website to help the public structure their comments and extract information from the public that could be more useful for the agency. So taking a comment from, an up-down, I support this or I don't support this, and prompting the member of the public to give reasons to help support, why, what it is about their personal or professional experience that informs their opinion of support or non-support for the rule. So generative AI could could potentially be used to provide additional richness to comments that are otherwise, not likely to strongly influence an agency because they just weigh in yes or no, right? Which is not the kind of information that agencies are generally able to make use of. Generative AI also paves the way for a sort of turbocharged phenomenon of mass comments, potentially. Generative AI can develop large volumes of text very quickly and very low cost. And so there is an interesting sort of puzzle in the idea of how agencies are going to cope with this inflow of, potentially pretty sophisticated looking individual comments, where they're used to dealing with, a high amount of overlap right now in mass comments. So you might get a letter writing campaign where, say, 80% of that letter is roughly the same across 30,000 comments. Well, generative AI could turn that into 3 million comments, and the similarity is only 10%. So when you think about that inside an agency, managing with that inflow, managing that huge inflow of text, I think is a management challenge that's provoked by generative AI. So turning to how agencies might use generative AI, they could use it to actually write the rule, right? They could train a model on, prior agency rulemakings or other agency rulemakings that they think are acceptable, and prompt something like this to take a first crack at crafting regulatory text or a regulatory preamble. They could do it in a more targeted way related to comment analysis and response. So if the regulatory docket has 3 million comments, they might ask that model to, sort of go through, assess what the core topic areas are, and then generate a potential, first draft of a response. All of these things that I'm doing here, I'm just sort of provoking you to think about the way that tech might end up informing what agencies are doing. There are lots and lots and lots of questions, including, is this okay as a legal matter, right? As a normative, do we want the government doing this, right? But the point of this conversation is just to provoke you into thinking this through a little bit, and just some signals about, legal issues to come. The third entity that I would raise for you that might use generative AI is something called the e-rulemaking program, which is the part of the federal government that works on that website, regulations.gov. This is an interagency team housed at GSA that does a great job of managing this huge resource that federal agencies use. So I won't dwell on this, just to say that it's a great team that has a good track record of managing new tech challenges associated with, for example, mass comment campaigns. But generative AI is a new frontier for them as well. So that will be interesting to see how they cope. But the bulk of my time, or the remainder of my time, I guess I want to spend thinking about the courts and how they might use some of these tools in their own workload. And I think this is possibly the most provocative part of the speech. So trying to get spicy here as the minutes tick away. So one idea would be that, courts try to leverage large language models and generative AI to help them review agency rules. I'm not aware of particular articles on this specific question, on the use of these tools to work on regulatory issues, but there are a couple of articles that I'll drop into the chat once my talk is over, in case you want to take a look at those. One is by Dave Hoffman and Jonathan Arbel. And of course, the title of that just went completely blank on my screen. I think it's called Generative Interpretation. Yeah, there it is, Generative Interpretation. And that article goes through the idea of using large language models to interpret contracts. So, as we know, in a lot of rulemaking cases, the question comes down to, okay, what did the statute mean? Is the agency interpreting the statute in a permissible way? And so what Hoffman and Arbel are working through in this article is the idea of using large language models to interpret contracts. Obviously, they're dealing with, a different domain of material, but the concept is the same. The idea that there are these large language resources that you can tap to try to figure out what things mean. So perhaps you could imagine, a court developing a tool that allows them to gather information from lots of different regulations, lots of different statutes, to harness towards, figuring out what terms mean. The second article is by Jonathan Choi, and this one is called Measuring Clarity in Legal Text. This one is about the idea of using an algorithm to determine if a term is really unclear. So that's an interesting idea in administrative law. Choi wasn't writing about it, limited to the administrative law context, but I think when you bring it over into this area, what's sort of interesting about it is when you think about issues of deference and sort of how we even figure out when we're going to defer to an agency's interpretation. What Choi is thinking about in this article is the idea that there might be some way to basically come up with an index of clarity, where you basically sort of plug a piece of a statute in and say, how indeterminate is this text? And might that influence, how it's sort of an empirical way of determining the indeterminacy of text, if you will. So this is provocative. This could potentially upend, the way you think about the judge's discretion in figuring out what it means for something to be arbitrary, for example. So I think that's helpful, just to know that there's a lot of really fascinating scholarly work going on. It tends to be interdisciplinary with people that have lots of different kinds of training. And so it's just something to keep an eye out if this is an area that interests you and you're thinking about what this means for your own practice or for the courts. So we've talked about how courts might use different tools to parse the meaning of statutes and legal words related to agency rules. We've talked about the implications potentially for something like deference. Might AI sort of challenge the underlying assumption that agencies know so much more about the context than any individual court, if the courts are able to, come up with their own resources basically to compare, or even if it's not in the court's own, right? If parties are able to reference materials like this that sort of provide some kind of extrinsic evidence of meaning. And then also, and maybe most provocative, I don't know, is how courts might use these tools to draft legal opinions themselves. We've certainly seen courts rebuke litigants who use generative AI in a way that, hallucinated cases. These are cringeworthy opinions where, courts really express much disdain, and, possibly even the litigants themselves, facing action by their bar for turning in proceedings with, false, totally fabricated cases. So that might, perhaps chill judges from even getting anywhere close to this. On the other hand, perhaps, a more tech forward judge, or maybe their clerk, might sort of plug something into generative AI and say, hey, sketch the outline of opinion in a case that, looks roughly like this. So perhaps, turning to something like generative AI to write the first draft. So, in 9 minutes, we've really only scratched the surface. But I hope this provokes you to think not only about how agencies might use some tech, but other actors in the rulemaking arena, especially courts. Thank you.
Thank you, Professor Dooling. I was going to throw a question at you while you were still in the hot seat, but I think you sort of spoke to it, but I'm going to throw it to you anyway, just to see if you have anything else to add. So how can a court ensure that this large language models are not hallucinating cases or term meanings if they choose to use generative AI to help a justice's caseload?
Yeah, I mean, I think at this point in the state of the art, like, everyone should be really, 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 capital R, really skeptical that, a generative AI is competent to actually serve up case citations. You're going to want to shepherdize, or whatever that term is, go ahead and check that case immediately before including it in any document. That's where we are. But I would expect that to get better. I mean, you're seeing, the major, legal analytics providers working on tools like this. And so I would expect this to improve over time, but we are not there yet. Okay, thank you. So all questions, go ahead and pop them in the chat. And thank you, Professor, for giving us that citation. I do have one question, and sort of a broad overall question while we get some others in the chat. I'll let the panelists address it in the order that they went today.
Are there any themes that cut across each of these important issues? And why are we seeing so many new challenges in administrative law now? This is definitely something I have asked myself. I'm an environmental law person, and I've sort of wondered, are we just at the age with environmental law that because we're around 50 years old by most folks' account? You know, are we at a point where we're, you know, why we're getting, we have so many curveballs right now, especially with the West Virginia case, but I'll turn it over to the panelists to address those two questions.
So I guess I went first, so I guess I'll go first. I mean, I feel like you could probably come up with a long list of answers to that question, a lot of which are extrinsic to law in general, not just administrative law. One thing that I sort of focus on a lot, because my work has predominantly been on interpretation of the APA, is just that you know, these statutes are getting old, and this is kind of part of what you were sort of saying. And I feel like when the APA was enacted in 1946, the legal profession has a sort of broad-based understanding of an awful lot of kind of background principles that if you don't have access to those, the text is either not going to make sense or is going to seem to say something other than what it was understood to say in 1946. And you know, we're far enough away at this point that I think a lot of that knowledge has been lost, has been shifted. I mean, the background principles, I think some of them have changed as other areas of the law that are adjacent have changed. And so you just have a situation where the meaning is less, I think, readily available to us, and that creates creates challenges in trying to figure out what it means, and is fertile ground for the raising of new disputes, especially as we continue to apply these older statutes to new disputes. And it puts I think a lot of stress on the system and creates pockets of disagreement that probably then are being influenced by the polarization that we see coming from sort of outside of administrative law.
So
Professor Cruz, yeah, go ahead.
I think I'll sort of piggyback off that a little bit about there's sort of this interesting phenomenon of statutes are old, and to pull in what Professor Dooling was talking about, technology kind of is becoming new, but what agencies are doing isn't always anymore, you know, a lot of stuff that captures the public imagination that agencies are doing these days aren't necessarily responses to technological things. So, you know, I think like when administrative law was kind of like in its heyday, when deference was maybe stronger and there was less skepticism of the administrative state, like some of the leading cases in this area really do strike you as like agencies talking about really, really technical things that judges just couldn't wrap their heads around. And that leads inevitably to an idea that we should have deference and, you know, hands-off sort of doctrines. But some of the stuff that you see today is getting away from in the weeds scientific technology judgments, and sometimes touches on stuff that judges feel more competent to wrap their heads around. So for example, in West Virginia against EPA, which there was a flavor of the EPA trying to implement a cap and trade policy. We've been talking about cap and trade forever. It's sort of just a political topic. Judges probably feel like, well, I kind of understand the basic parameters of that. I can be a little more probing in my review of what the agency wants to do. Whereas I still think it's the case that even among judges who are more anti-administrativist or more skeptical of the administrative state, you know, when the EPA rolls in and says, here's a whole bunch of new rules about regulating hydrofluorocarbons, a judge is still going to throw up their arms and say, I don't know what that is, and basically let the agency do what it wants. So maybe so I think part of the challenge might be the drift away from, you know, the old regime, which was these statutes that were really tailored to channel agency discretion on things that genuinely did draw on specialized expertise that judges acknowledged in themselves they just weren't competent to address, and maybe a bit of a drift towards administration as broader, higher level normative policy questions that judges feel like, I don't have to defer to anyone else. I know this too.
No, it's my turn. So the question you raised has any number of answers to it. I'll just throw in two more ideas. One is, I think you really have to take seriously the importance of recent judicial appointments of judges with a very anti-administrativist bent. This was conscious administration policy by the preceding administration, acknowledged as such. So you get what you're looking for. And that comes about in turn because of a political movement that clamors for appointments like that. Now, I think I don't want to simplify this too much because you could say there are factors that have generated the political movement. But I think the immediate causes would include simply the question of who's sitting in many of these cases. The other thing I would mention is that we've had a real fall off in productivity in Congress. If Congress isn't updating statutes to the extent that it used to do, then the executive branch is put to the choice of taking the initiative itself with initiatives that may be contested, or accepting stasis in the face of developing world challenges and national challenges. That's not a lovely choice. You'd prefer a situation in which Congress is being proactive, but we don't have that these days. And so you've had a choice between two unpleasant alternatives.
Yeah, I would agree with all of those previous comments. I just add a couple of points. One is that I think not only did the prior administration want to appoint judges with that point of view, but they had a pretty good roster of judges, potential judges to choose from, thanks to the activity of the Federalist Society and Leonard Leo's organization, and which were very focused on kind of deregulation as a good attribute for judges. And secondly, I think, you know, the way it's a lot easier now to pick judges. And when you have a circuit like the Fifth Circuit and single judge district courts like in Texas, and standing rules being relaxed enough to allow red state and blue state attorneys general to bring these cases where they know basically what the results are going to be at the district court and court of appeals level, then that, like in Jargassy, you know, then that leaves it up to the Supreme Court to correct overreach by these lower courts. And sometimes the Supreme Court doesn't want to do that. And finally, I think I'd mention the fact that justices like Chief Justice Roberts often resort to saying, well, if our decision, that Congress can come in and step in and fix what we're doing here. This is really something Congress should do. And, we've seen that in the voting rights cases. We've seen that in a number of administrative law related cases. And, I think they know well that Congress is not in a position to do that right now. So it kind of looks like they're being reasonable and saying, well, this is something that Congress can and should fix if they want to do that. But knowing that Congress is somewhat paralyzed right now, it's not going to happen.
I think the only thing I could add, and that was a great question, Professor Everhart, what's the sort of through line to all of this? What I would add is just the stakes and the breadth of the decisions that are being handled by executive branch agencies is pretty remarkable. I mean, you see, tremendous amount of really important policy being handled through the executive. And so I think it's sort of natural that when so much is sort of flowing through that direction, through that pathway, that you would see a lot of attention to, how do you check and review that pathway?
Can I ask a question of Adam? That'd be okay? So I was very interested in Adam's presentation. With respect to his comments about the Fourth Circuit adding all of these steps to the major questions doctrine, it's almost like they're trying to add a step 0 to it. But my real point has to do with the Vermont Yankee, because I was so surprised that you said that the conservative judges are sort of latching on to Vermont Yankee more these days, because I would have predicted that they would be going the other way on Vermont Yankee. Vermont Yankee, when you to really look at it broadly, is kind of a pro-agency decision, because it's preventing courts from adding additional procedures to what agencies want to do. And so I can understand why a conservative judge would want to invoke Vermont Yankee in the immigration context if some immigrant is trying to challenge what the government's doing. But in the mine run of cases, Vermont Yankee is kind of a pro-regulatory decision to me, and I'm surprised it withstood the Supreme Court's general anti-administrativist view as long as it has.
No, I mean, my reaction to that when I was first sort of observing or looking into this trend was the exact same as yours. I would not have guessed that this was a rallying point for folks on the legal right. And part of it, if we put on our pessimism hat, we can maybe, think that this is all sort of wrapped up in politics. First, partly for the reasons you said, a lot of these cases are immigration cases where we might think that, the conservatives are more, as a policy matter, are more okay with expedited hands-off review of immigration matters and just processing these things through the system. In a couple of other contexts where this has come up, it has been efforts by judges to wave through or get rid of challenges that were trying to gum up deregulatory actions. There's some really interesting cases where there were efforts to roll back regulation, perhaps, for example, like under the Trump administration. And then people tried to say, this, that, or the other procedural formality wasn't met in achieving that deregulatory action. In that situation, again, the politics might be a little different, where, it's kind of like Chevron always had its heyday when agencies were trying to have deregulatory interpretations. And it might be a bit of that same flavor. When administrations come in and try to roll out back the administrative state, folks on the legal right might then want to embrace Vermont Yankee and say, yes, allow this to happen. Now, whether or not that holds as, challenges arise to things the Biden administration wants to do, I don't know that we have enough data points yet. So it is possible that this is all, that there's just a political undertone to all of this.
Okay, do we have any other questions from the audience or from any of the panelists?
We have one in the chat here. Isn't the Majors Questions Doctrine a return to the substantive due process of the Lochner era?
I've heard that analogy made by Cass Sunstein, and that's good company to be in. I think there are some relationships, but I think it certainly doesn't overtly adopt that proposition. It is masked or wrapped in more neutral terminology of attributing views to Congress, and from some justices, the emanations of the non-delegation doctrine and so forth. I think there's a sense in which you have anti-administrativism, which has some resemblance to the Widener era, but I think isn't really predicated on the Constitution. It's a reflection of social philosophy. And up to a point, I think we have to accept that, because if you have judges of any philosophy, it's going to inform their decisions. And that is just an inevitable part of the fact that we have the people who are appointed through a political process. And so for my part, I was not criticizing the holdings of West Virginia or Biden v. Nebraska or any of those cases. The tangible holdings I might agree with, but they're the kind of holdings that I would have expected judges of the majority to adopt. But I do think the Major Questions Doctrine is qualitatively different, because it's a purported rule of law that just doesn't seem to have a foundation in accepted doctrine. And if you say, well, it's really Widener, that's not exactly accepted doctrine now.
Okay, well, Carrie, unless you see any more questions, I do not. I want to thank our panelists for their unique and valuable insights. It was really a wonderful panel. Thank you all. I definitely think we've energized the crowd. They're ready. So I will hand it back over to Carrie.
Again, thank you, panelists. Thank you, moderator, for attending this morning and for devoting a chunk of your morning, and as well as the last several weeks in preparation. Very much appreciated. We have a built-in, again, break, 15 minutes to stretch your legs, grab something for lunch, and then we'll be back at noon with our keynote speaker. So thank you and stand by. All right, it's just about noon, so welcome back. Thank you for joining us. We're going to have our keynote presentation at this time. It'll be moderated by Professor Jill Family. Many of you know Professor Family. She is absolutely a rock star who made this session and this entire day happen. Her help has been phenomenal for the Law Review Symposium this year. So my personal appreciation to her and everybody else that's joined us today. And I will pass things over to Professor Family. If you have questions during this session, which we hope you do, please address them directly to Professor Jill Family. Thank you.
Thank you so much, Carrie, and good afternoon, everyone. I've really been enjoying the symposium so far, and I want to express my appreciation to the Law Review and all of the speakers for being so generous with your expertise and your time. I am the faculty advisor to the Law and Government Institute at Widener Commonwealth, and as you have heard, it is the 25th anniversary of the Institute, and the Institute is one of the law school's signature programs, and it is something that is very near and dear to my heart, and so it was with great pleasure that I was able to work with the Law Review and with Carrie and Professor Yeargain to plan this symposium on this incredibly timely and important topic, as well as one that really goes to the heart of the mission of our law school. As Carrie said, if we have left time at the end of Judge Child's presentation for your questions, so please address those questions, direct message them to me in the chat, Jill Family, and I'll be able to compile those questions and ask them of Judge Childs. And it is my absolute pleasure to introduce Judge Childs. Judge J. Michelle Childs was appointed to the United States Court of Appeals for the District of Columbia Circuit in July 2022. And for those of you who may not know, the Court of Appeals for the DC Circuit is really the premier federal administrative law court in the country. Judge Childs spent a significant amount of time in private practice before she turned to government service, where she worked both for the South Carolina Department of Labor, as well as the South Carolina Workers' Compensation Commission. And in 2006, the South Carolina General Assembly elected her as a state circuit court judge. And during that time, Judge Childs served as Chief Administrative Judge for General Sessions, which is South Carolina's criminal court, and as Chief Administrative Judge for the state's business court. In 2010, she was appointed to the United States District Court for the District of South Carolina, where she served until her appointment to the DC Circuit. Judge Childs is the president of the Federal Judges Association. She is active in the American Bar Association, where she is a member of the Section on Administrative Law's Governing Council. She's a fellow of the American Bar Foundation, a fellow of the Litigation Section, and a member of the Committee on the American Judicial System. Formerly, she was chair of the American Bar Association's Judicial Division and the secretary of the American Bar Association section on labor and employment law. She is a member of the American Law Institute and its counsel, having served as an advisor on the Restatement Third of Employment Law. She currently serves on the Bolch Judicial Institute Advisory Board, and she joined the class of 2022 Rodell, I hope I pronounced that right, Rodell Judicial Fellows. Please join me in welcoming Judge Childs. We so appreciate her time and her dedication to the law.
Good afternoon, everyone, and thank you, Widener Law School, for the opportunity to appear before you at your 25th anniversary celebration of the Law and Government Institute. And I personally want to thank Professor Jill Family for the invitation to be your keynote speaker. I had the good fortune to begin my term as a member of the Administrative Law section of the American Bar Association under her outstanding leadership when she was then chair. And thank you so much, Jill, for your many initiatives that you led during your tenure. Now, your topic of judging and administrative law is particularly appealing to me as a circuit court judge for the District of Columbia Circuit Court of Appeals. The DC Circuit, as we call it, is called the second highest court in the United States because it hears cases dealing with national security, executive and legislative powers enshrined in the Constitution, and issues regarding foreign sovereigns. The DC Circuit is also known for its unique role regarding administrative law and plays a key role in hearing cases related to federal administrative agencies. And it also hears such cases from the many agencies, including National Labor Relations Board, the Securities Exchange Commission, the Environmental Protection Agency, the Federal Trade Commission, and the Federal Energy Regulatory Commission, Federal Communications Commission, just to name a few. And I'm sure many of you play various roles in representing clients in that regard. In fact, the DC Circuit considers proportionately more administrative law cases and petitions concerning the federal government than other circuits, nearly double as many of some of the other circuits. Our statistics from the 2022-23 term show that we heard 33.6% just in agency cases. And second in line to that was 29.1% of civil cases in which the United States was a party. So I'd like to begin because as I heard the introductory remarks today, it kind of reminds me of how I need to tune up my work-life balance. I have this thing about saying no to one thing and then somehow gaining 3 other assignments, but all the more fitting for my topic today, which would be Carpe Diem, the gift of public service. It is quite an honor and a privilege to address this illustrious group because all of you have so many talents and you're outstanding lawyers and even judges. And while your organization is essentially formed where you want to promote exemplary practice in federal courts and other courts, provide excellent education and cutting-edge legal topics as you've done today, and then of course there's always those wonderful networking opportunities. This gives you a strong reputation for serving our legal communities and your own personal and professional communities in your town. It gives you the opportunity to give that much needed pro bono activities and access to justice. And of course, we love your support for the federal judiciary and other parts of our judiciary. So I send my heartfelt appreciation to all of you for making this event possible, because this is a time where we can have open discussion about engaging in the rule of law as lawyers representing your clients zealously within the boundaries of the law, and then enjoy these moments as we have the opportunity to spend time with our colleagues. I know that I do because I'm a generalist. You all are specialists, and so you have so much to inform us about as experts in your particular field. Now, as I indicated, the title of my remarks is likely not foreign to this crowd. Indeed, I'm sure you all know the Latin phrase carpe diem, or seize the day. It was popularized by the 1989 movie Dead Poets Society, if you recall, where the late Robin Williams plays a dynamic English teacher at an elite conservative boarding school. But what you may not know is that the phrase was first coined over 2,000 years ago by a Roman poet. His name was Horace, and the poem's name was Odes. When he wrote the poem, Latin teachers argued that he intended the phrase to convey a different meaning than what is popularized today. Horace intended the phrase to mean that we should strive to enjoy the present moment. Well, society arguably understands the phrase to mean that we should take the risk because life is short. Well, let me just give you a little bit of history about Widener University and how it fits into all of this. Widener University has produced civic leaders for over 200 years. As you all well know, Widener was founded in 1821 by John Bullock to prepare young men for college, and through that, leadership in their communities. That goal continued as the school changed its name to the Delaware Military Academy in 1858, producing defenders of our liberty in the form of leaders and soldiers alike. During the strife of the Civil War, this school and its leadership made clear that they took seriously what our founders promised in the Declaration of Independence. When the state of Delaware said that it did not support abolition, this school's leadership pulled up stakes and moved to Pennsylvania to support its pro-abolitionist stances, allowing all its students to learn what the phrase, "all men are created equal," meant. In Pennsylvania, the school would eventually become the Pennsylvania Military College, continuing its mission of creating future leaders in our own civic institutions and on the battlefield. And a century later, during the domestic tensions caused by the Vietnam War, This school again showed that it was dedicated to providing leaders and producing them to move around the country and move the country forward by establishing a civilian college alongside its military school. Then it opened its doors to all citizens to help push our nation forward. That school would later become Widener University, and it continues to educate and produce leaders today. Now, it took courage for the founders of Widener University to strike out to educate the youth, not for renown, but because it was the right thing to do. It took courage for the school to leave its home state because of the wrongs that the state endorsed starting over in a new place. It took courage for the institution to see the nation's needs around the Vietnam War and change itself to better suit the new world it found itself in. And it took courage to continue the mission until today. The leaders and students of this institution have always known what Otto von Bismarck, a German statesman and diplomat of the 1800s, said so long ago. With bad laws and good civil servants, it's still possible to govern. But with bad civil servants, even the best laws can't help. Well, I understand the phrase carpe diem, kind of to be a mix of both staying present and taking risks. And no matter how you understand the phrase, I think my professional journey thus far is exemplary of it. Truth is, I was only a partner at a former law firm for about 6 months before then Governor Hodges called me to public service. And for nearly 8 years, I was dedicated to my labor and employment practice at the firm. And I had notoriety because I was actually the first Black woman partner at a major law firm in the state of South Carolina. And so I did the opposite of carpe diem. I kindly rejected his offer, meaning the governor, to move me to public service. Well, the governor then called again, and I accordingly and kindly rejected him once more. Now, how dare I do so? But then I reflected. I sought advice from friends and family. They offered me a different point of view, the gift of public service, using one's talent to help others. What better present use of my law degree than to use it as a force of good? I failed to realize that although the call toward public service was not convenient, it was nevertheless opportune. Whatever risk I thought I was leaving by leaving my comfortable law job as a partner could be assuaged by the wealth of good I could do as a public servant. After all, one does not reject a job 3 times. And how nice it was to be in a position to assist by stating, I'm with the government, I'm here to help you, and I mean that. I said yes to becoming a deputy director within the South Carolina's Department of Labor Licensing in hindsight, but I was saying yes to now 23 years of public service and counting. A single yes to one job led to one more gubernatorial appointment as a commissioner on the South Carolina Workers' Compensation Commission and 2 appointments as a federal judge on 2 different courts from 2 different presidents. So if I could travel back in time to a young Michelle, I might climb on a desk like Robin Williams did in Dead Poets Society and tell myself that carpe diem means to accept the call to service the first time. Now, a commitment to public service can begin at law school. When I was coming along, there was an effort by the big firms and corporations to seek diversity. And my interviews consisted of trying to obtain those experiences. But now law students are more proficient in providing varied opportunities. These opportunities allow students to gain practical experience while also meeting the social needs of society through various substantive areas of the law, including veterans, domestic violence, and housing for disadvantaged communities. Working through these clinical programs offers a transformative experience for these students as they provide access to justice to those with some of the most basic needs in our societies. And clinical programs can be so impactful. For example, at my alma mater, the University of South Carolina Law School, students in the legal clinic helped Breonna Taylor's family secure $12 million in settlement. As you may remember, Breonna Taylor was the 26-year-old EMT who was minding her business, fatally shot by Louisville police in its pursuit of a late-night no-knock warrant in a narcotics investigation. 2 USC law students and a professor reached out to the family in the middle of the litigation to offer pro bono assistance. When it became clear that the family was open to settling, the student conducted legal research on how no-knock warrants disproportionately impact people of color and cause harm to civilians and police officers. Their research also covered relevant case law about shootings connected to no-knock warrants and whether they led to jury verdicts in favor of victims' families. Their work helped secure the family's settlement, but by extension also helped to secure Louisville City Council's Breonna's Law, which bans no-knock search warrants. But even at the Supreme Court, law students can have an impact through legal clinics that are aimed at public service. In 2020, Stanford law students, as part of the school's Supreme Court Clinic, the oldest of its kind in the country, helped develop the arguments in a landmark case, Bostic versus Clayton County. That case asked the court whether Title VII of the Civil Rights Act of 1964 prohibited discrimination against gay, lesbian, and transgender persons. As you know, those students were part of the winning team. Justice Gorsuch wrote the majority opinion, reasoning that, quote, because of sex, end quote, encompasses discrimination, quote, because of sexual orientation, end quote. Now, graduating law school and becoming a lawyer should increase our access and connection to the public. But the public's perception of our profession is not to be admired. In fact, Gallup's June 2022 poll on public confidence in the Supreme Court of the United States found that only 25% of Americans have a great idea or quite a lot of confidence in our court. This percentage was down 11 points from 2021. Now, if we were to take Gallup's poll as a reflection on American society, that means a full 75% of individuals do not have a high amount of confidence in our highest court. Notwithstanding these disappointing numbers, confidence in the Supreme Court still beats the confidence poll respondents had in the presidency and in Congress, 23% and 7% respectively. So much work has to be done in all fronts with respect to our respective governments. However, as we continue to serve and do pro bono work, we can make a significant positive impact upon the lives of others and upon our profession. We can show others how to be honest in our dealings, how to work toward resolution of our disputes out of respect for our individual differences, experiences, and perspectives, and how to enable others to have fair access to justice through competent legal representation. And we've heard that presentation earlier today. Through each and every task and service, you improve the perception of our profession as a gracious community of thoughtful and caring leaders, service-oriented individuals serving passionately to better our communities. The gift of public service also allows us to live a meaningful life, one that is inspired by purpose, not just promotions, one that is committed to service, not just to success, one that is motivated by authenticity, not just accolades, one that seeks wisdom, not just wealth. It is through living a meaningful life that you will make a difference in the lives of others. After all, Model Rule 6.1 of the ABA asks every lawyer to aspire to render at least 50 hours of pro bono public legal services per year. And many law firms around the country assist in that effort. For example, one firm in Columbia uses its pro bono capabilities to challenge minimally adequate education in South Carolina. It brought much needed awareness to South Carolina's corridor of shame, as some of you may heard. It was the nickname for the region of rural, impoverished school districts, mainly along Interstate 95, burdened by dilapidated and poorly performing schools. ORIC, a law firm based in San Francisco, California, has a racial justice fellowship that places lawyers at partnering organizations to advance their missions. One lawyer used that fellowship to start Howard Law School's first civil rights clinic. They filed amicus briefs in numerous cases in the Supreme Court, or consider Jenner & Block, a law firm headquartered in Chicago, Illinois. It committed $250 million firm-wide to pro bono opportunities, allowing attorneys to count those hours toward their year-end goal. Indeed, staying connected to the needs of public keeps lawyers nimble. Think about how we all stepped up during COVID-19. Lawyers and judges have been at the forefront of public service as they have moved our society forward on social justice and equality issues, having served as leaders and trailblazers. And as we come to our new era in the aftermath of COVID, let us recognize how much we achieved and can achieve in the event of the most turbulent times. While we are all persevering, and while we were at that time social distancing through a worldwide crisis, coping with the grief of missing loved ones and important life events, and being flexible through the interference of our daily routines, I recall lawyers stepping up to assess the civil and criminal needs resulting from the pandemic, collaborating with the courts to address access to justice issues for those displaced in the justice system and physically displaced in our communities. The Federal Bar Association and many other national, state, and local bars collaborated with the courts to determine effective processes, procedures, and best practices for conducting court while attempting to address the dire backlogs created before the pandemic and reinvent the jury system essentially through Zoom. Seeing and serving during this adversity, we revealed our steadfast commitment to our broader society. But more importantly, when we continue to serve outside of the contours of an emergency, we serve with grace, humility, and passion for the greater good. As lawyers, the gift of public service allows you to build upon your strengths, talents, and meet new challenges. Each of my life's experiences and relationships have prepared and nurtured me for the next set of experiences. So public service leads to mastery of the necessary skills for the task at hand, the ability to be competitive in all opportunities, and the desire to conquer the challenges of any position, and particularly the willingness to recruit and mentor others to prepare and guide them for such opportunities. We all have to pay it forward. And while we are grateful for this gift of public service, let's think about the courage it takes for you as lawyers, the courage it takes for us as judges to stand for the rule of law. While we may have different lenses from which we looked to resolve these issues, if we do so with the care to understand our differing roles, then we do so respectfully, humbled by our service to this noble profession, and gratified by our concern for humanity and our communities. I made the short list for the United States Supreme Court, proudly rising from my great public school education at the University of South Carolina. My former colleague, the late Judge Matthew J. Perry, which building when I am in South Carolina is where my office is, made it possible as he integrated public education in South Carolina by litigating against Clemson University and the University of South Carolina while a young, passionate civil rights lawyer and advocate. He influenced the lives of many generations and was never discouraged by the turbulent times or his formidable opponents while he transformed prior societal norms. He was endearingly referred to as the Thurgood Marshall of the South, as he fought for social justice in areas affecting basic human and civil rights, racial injustices, and equal opportunity for all citizens in South Carolina. Now, for all of us, we are certainly proud of and stand on the shoulders of Judge Perry. But I must say, lawyers have one thing we may regret about Judge Perry. A little known fact is that during the time when he came along, Students who graduated from USC Law School were admitted to the state through a diploma privilege. That meant that if you went to the law school in the state of South Carolina and graduated, you were automatically admitted to the bar. It was not until 1948, the year that Judge Perry entered the law school of South Carolina State College of Law, that our state came up with the bar exam and required all applicants to take it after July 1, 1950. Imagine that. And yes, Judge Perry passed the bar on his first attempt in the summer of 1951 and was the only student in his class to do so. So Judge Perry would chuckle and laugh and say that you can blame him for the students having to take the South Carolina bar exam. And as a young lawyer, Judge Perry appealed many unfavorable rulings. As a lawyer, he was asked, well, how do you approach incivility among lawyers and also strive toward your causes? He responded, I do not conform myself to their conduct or their approaches. Much of what I saw, I was able to deal with in my own terms, armed with the Constitution. And he set about to vindicate the rights of whoever his client was. So I implore lawyers to remain objective about your cases and understand the passions on both sides of the V as you represent your clients. Also understand the judges are always trying to engage in a neutral, deliberative process as the fair and impartial fact finder concerned about the perceptions of justice in our courtrooms. We, the judiciary, are necessary for the integrity of our constitutional principles applied to every person and entity equally. The role of the third independent branch of government at present in our nation's history has been no less monumental in shaping our union than the presidency or major acts of Congress. Courts are an institution to hold actors in other branches accountable. Since Marbury versus Madison, generations of judges have and are succeeding to interpret the law free of influence. Today, judges do not have to just worry about being shunned. Sadly, we are still worrying about personal attacks from our detractors. According to the United States Marshal Service, threats against and inappropriate communications to judges jumped from roughly 2,800 in 2017 to over 4,500 in 2018. And since 2021, that number has not substantially changed. And more than one federal judge has been killed in office over the last 30 years, one too many. But two recent examples are chilling. In June of a couple of years ago, a California man was arrested near Justice Kavanaugh's home. According to a federal agent, the man was armed with the intent to kill the justice. And while the investigation was ongoing, the attempt made on the justice's life encouraged the Department of Justice to provide around-the-clock security at all 9 of the justice's home. Attorney General Garland said in response to the attempted attack on Justice Kavanaugh that threats of violence and actual violence against the justices, of course, strike at the heart of our democracy. And you may recall the tragic story of the attack on Judge Esther Salas's family. On July 19, 2020, while she was at her home in Brunswick, New Jersey, a gunman shot and killed her son at the front door. Judge Salas' husband was also shot multiple times and had over 15 surgeries, but thankfully survived the attack. The gunman was a former litigant in a case over which the judge presided. And just not long ago, trial judges have told me that someone from connected in a high-profile case contacted him, extended graphic comments, informed about the name of his child and location of the school, and told the judge how he or she must rule in the case. These events bring unimaginable heartbreak to family and friends, and they undermine the independence of the judiciary. But thankfully, you all as lawyers, particularly in the Federal Bar Association, have stepped up because you've emphasized judicial security as a priority. And because we need a safe and independent judiciary, that is vital to the administration of justice. And they actively supported the Daniel Anderall Judicial Security and Privacy Act, which was originally introduced in 2020 and named after Judge Esther Salas's son. So we all stand proudly in support of that and continue to do so. Now, I also wanted to tell you all that while I went through the journey of being on the short list for the United States Supreme Court, there was so many things that I had to do. But I want you all to stand strong and step up when you're called to the public service. So don't let it deter you when you're being vetted for a position, or you need to take a stand, or you need to go through an FBI background check that goes all the way back to age 18, including residences, education, personal, professional references, international travel, interactions with the police, lawsuits filed against you or that you have filed, financial information, and even your social media presence. Thankfully, I have none. And so you want to look at that Senate Judicial Questionnaire if you have any interest there, but also don't let it deter you that you would have to go through an interview with the American Bar Association, which was 4 hours, the FBI, another hour, White House Counsel, Office of Legal Policy, another 4 hours, other White House officials. And then, yes, I had the opportunity to interview with the Vice President and the President of the United States. Don't let it deter you that I had spent over 300 hours of prep time, because this is the gift of public service. So no matter where your path may lead you, public service is always the best path to be on. It's unendingly rewarding. And as a judge, one of the best parts of my job is getting to know new lawyers, getting to be among you and fellowship with you, network with you. And as the great Brian Stevenson has said, we all have a responsibility to create a just society. So, carpe diem. Thank you all for this opportunity to be with you.
Thank you so much, Judge Childs, for those inspiring words. That was great to hear, and we appreciate the inclusion of Widener University in our story into your remarks as well. So I'll start it off with the question sort of towards the end of your remarks. You were talking about challenges for the judiciary, unfortunately, that include threats to personal safety. And so that sort of had me thinking about the public's understanding of the role of the judiciary and the importance of the independence of a judiciary. So what can we do as lawyers, as law students, to help educate the public about, what we really should expect of judges?
Thank you. First, I'll start with, it is our responsibility as judges to keep up the perception of a fair and independent judiciary. And what I mean is, it's the approach to our work. Every litigant, every lawyer should feel that we have prepared for court, that we are looking at the facts and evidence in the individual particular case, and that there's due process. Everyone needs to feel the ability and opportunity to be heard. Now, we realize that courts are overflooded in their dockets, so it does not mean your opportunity to be heard will always be a hearing. But if we're writing well-reasoned decisions where you understand that we've looked at the issues and we've come up with what we believe is our best resolution of the case, then you have the opportunity to feel that you can be guided by that law in that particular case and perhaps other cases where it was set precedent. I also believe that in terms of public service, we all have a duty to engage in more civic education in terms of everybody understanding the role of each branch of government, because a lot of times the decisions that come out, citizens just simply don't understand what was that process, why that judge did what they did in that particular case, why perhaps that judge's hands were tied just based on a particular statute or a reading of the Constitution or a reading of precedent. So that's where lawyers can help, just engaging in elementary schools, middle schools, and high schools, and starting with civics education.
Thank you. Okay, we've got a few questions from the audience to start with. We've got two related questions from Jessica Poley. One is, what's been the most rewarding thing for you being in public service? And sort of the second half of that is, that being said, that it's rewarding, have you ever thought about leaving public service during your career?
Thank you. Well, starting with the second question first, I was, like I indicated, a partner, and I've made partner in the 7-year rank. I think it's like 7 to 10 years these days. And then I became a public servant. And quite frankly, I've just never looked back. When I started that first position as deputy director, it was for a 2-year unexpired term of someone else. And then I had the opportunity to go back to my partnership, had been offered another partnership at another firm, and then also in-house counsel at another firm. But then when I got the second opportunity to engage in public service, I just kept having the wonderful opportunity of rising at different levels, within the judiciary. I enjoy this position. I come to it every day with the mindset that I'll have intellectual stimulation in terms of the cases that I get to hear. DC Circuit is so broad. We deal with foreign sovereigns, as I indicated, national security, executive, legislative privilege. So it's never boring. But I feel that in addition to that challenge, I'm always concerned about how I'm approaching the law and making sure it's clear. And so that feeds my soul, if you will, in terms of the public service. But I'm more like the mentoring of the law clerks that come through, or the interns and externs that I have, belonging to my local Inn of Court and having the interaction with various law students. So I think that this is my goal to be here. Now, at the time of retirement, I'll revisit, how long I would stay or take senior status or do something else. To your first question, I believe you said something about how rewarding. If you can repeat that, I apologize.
Yeah. What's the most rewarding thing about being in public service?
I think it's the opportunity to create that fair and impartial perception to others. For example, while we are guided by our laws, I do believe that there are opportunities within the judiciary to create that efficiency. For example, when I was on state court, I was chief of general sessions, which is our version of criminal court. And we had such a backlog. And so one of the things that occurred one time was we had a particular defendant, and our solicitor's office or prosecutor's office is in charge of actually setting the cases. And that's rare. I think a lot of it happens through the clerk's office. And so they determine which cases come first. And I had the opportunity to observe that we had lots of people sitting in jail, incarcerated 4 and 5 years before their case came up. So I met with the jail warden, met with the clerk, and then I worked that down. When I started, there were 200 people overcrowded, I should say, in the jail. But then when I was stepping down from chief judge, it was 200 under. Not because I let everybody out of jail, but I had weeks where we took the pleas, or we had the federal public defender as well as the prosecutor come together and say, who truly deserves time served? Who truly deserves probation? And then just kind of burst the bubble in that regard. So those are opportunities that allow us to see where should the efficiencies be in, and not just wait for the work to come to us. Another example would be in federal court, where I saw the opportunity to start a federal drug court, where I had this one particular case where there were a lot of people who were truly addicted to the drugs, and the drugs led to the crime. It was never set up as a get out of jail free card, but it was for persons, and many of whom had no prior record, and they were older, but they got caught up into the selling of oxycodone or Oxycontin and things of that nature, selling even their own drugs and then buying their own drugs back because they actually needed them. And so just those opportunities, and then to see how when you have that intensity where people have to come in court, I call it suit up, show up, and then allow the opportunity for counseling, individual and group, and doing community service and a lot of other things, and then never having relapse, but it's giving them the opportunity for alternative sentencing.
Thank you. The next question is from Kendall Swank, and she says, For students considering entering private practice, what recommendations do you have for managing a regular caseload plus getting involved in pro bono work?
Well, as a young lawyer, I would encourage you through your state bar as well as the American Bar Association. There is a Young Lawyers Division, and I became president of Young Lawyers Division in our state. They take lawyers from 36 and under or 5 years or less in practice. What is good about that is that you're engaging with people who are your peers. They've been practicing for a short while, and then they have that age range. The second thing I do is in your bar, pick your particular subject matter expertise, and you can rise. I went from newsletter editor to president of the labor and section law section. And so that gives you that opportunity to meet lawyers, to give and receive cases, with each other, and then have a balanced life in that regard. And then I didn't do well at it, as I indicated at the beginning of my remarks. Be more particular in what your yeses are, because you can't overcrowd yourself when you don't know how to say no enough. And then do things that you enjoy and you'll have a passion for, because all of our volunteer service is more work.
The next question is, how did your private practice experience help when you moved into public service?
It was very helpful because I believe that being a good judge makes us understand what it was like to be a lawyer, even down to allowing for continuances, allowing for vacation, understanding how witnesses will interact with the court, how to treat the jurors, how to manage discovery disputes, things of that nature. So I think there's a lot of carryover in terms of the skills into coming onto the bench.
The next question, sort of going along with your Carpe Diem theme, which I wholeheartedly agree with, but I think it's also interesting to think about, how can we mentor younger lawyers to put themselves in the best position so that those opportunities become available to them, right? Because there's a lot of work that goes into putting yourself in the position so that, for example, the governor thought of you, when there was a position to fill. So do you have any advice on that?
Well, I'll start with you, Professor Family. As a professor at your very esteemed law school, not just the classes, but providing perhaps some sort of incentive for the pro bono work. There are so many clinics available. There's so many other outside issues and things that are just right in the local community that will give students a good skill, but then it's also meaningful work. So I would start there. Then as we move into being young lawyers, the firms, I'm now talking to you, and even in government service to the extent it's available, sometimes it's better to have the billable hour credit. And then as my firm did, we had a 200-hour pro bono credit that you actually got credit for toward, your whole package of billable and non-billable. What that does is not make a lawyer only focus on what they'll get paid for. It makes them focus on the community. It makes them build their skills as a lawyer, because generally, if you're doing some type of pro bono work, if it's not just community service, in many instances, it might be something like a free legal clinic that you're volunteering for through the bar, and you're advising the broader community about various issues, whether it's wills and estate, family law issue, and things of that nature. And then that builds your resume because you're being seen around town in various settings. And when your name is called, you need a lot of people to know who you are, so that hopefully they'll say some good things.
Thank you. And so I think we have time for one more question. This question comes from Professor Lubbers, who admits that it's a leading question, but he asks, as you progress through your career, have you become more convinced of the importance of administrative law?
I have. And as I indicated, the numbers are rising in terms of our docket, and I pay very close attention to those cases, and I'm learning, and I expect you all to continue to teach me along the way. So thank you for that question.
Yes, I mean, I know you describe yourself as a generalist, but I think that's only going to last so long. I think soon you're going to have to admit that you're an administrative law expert, just like the rest of us.
Correct. Thank you for helping me get to that.
Well, thank you so much, Judge Childs. We really appreciate your participation today, and I'll turn things over to Carrie.
Thank you both so much, Judge Childs, Professor Family. It's been phenomenal hearing this and being inspired with only 4.7 weeks till graduation. This is exactly what we needed to prep us as we go into the long and enduring bar prep. So thank you. We'll take another break here and we'll come back at 1:15 for emerging administrative law questions. Good afternoon and welcome back. Thank you for joining us. We will now begin with emerging administrative law questions. And our moderator for this panel is Professor Michael Domino of Widener Commonwealth. As before, if you have any questions for the panelists, we encourage you to let us know via the chat. You can either send them to me, Carrie Nace, or directly to Professor Michael Domino. Thank you very much. And Professor Domino?
Very good. Thank you. Thanks very much for organizing the program. Thanks to all of the audience members for joining. Thanks especially to the panelists for bringing their insights into this. I have had the great fortune of seeing some of these panelists' scholarship in the past. I am just delighted to be on the same group talking about these exciting issues with all of them. So I'm deeply grateful to the Law Review for organizing the panel and for the panelists for being here. We're going to talk about two cases which the Supreme Court is struggling with now. They're pending at the Supreme Court. They may turn out to be really important cases, although one never knows until the Supreme Court actually decides them, and sometimes even then it's difficult to determine whether a case will be significant in the end. The two cases are Loper-Bright, the case that is a challenge to Chevron, and the Jarisky case, which is shaping up to be a Seventh Amendment kind of case. So what we're going to do is I'm going to introduce the panelists. I'm going to talk a very little bit about Chevron because I figure that if you're part of an administrative law symposium, you're already quite familiar with that case and its associated doctrine. And then we'll turn it over to the panelists to talk about Chevron and the challenge to it. And then after we do that, for a while, we'll do the same thing again with respect to the second case. I'll summarize it. We'll turn it over to the panel to discuss them. Some of the panelists have more to say about one case or another, but it's perfectly fine for them to talk about both. We don't have a lot of time to talk about major issues, but we do have enough time to hear the important things that they want to say. So in no particular order, our panelists are four wonderful scholars. Linda Jellem comes to us from the University of Idaho College of Law, where she is a professor of law. Prior to that, she was at Mercer in Georgia. She is a graduate of the Cornell Law School. She's a prolific scholar and teacher in the areas of tax, statutory interpretation, and civil procedure. Rob Glicksman is the J.B. and Maurice C. Shapiro Professor of Environmental Law at the George Washington University Law School. He is also a graduate of the Cornell Law School and came to GW after having been at the University of Kansas. He is also a tremendous scholar, especially in the environmental area, in addition to his work in administrative law. Richard Frankel is the Associate Dean of Experiential Learning Programs and the Director of Civil Litigation and Dispute Resolution Program at the Drexel University Thomas R. Klein School of Law. He is a graduate of Yale and has an LLM from Georgetown, and he runs Drexel's Federal Litigation and Appeals Clinic. Chris Walker is a professor of law at the University of Michigan. He came to Michigan after having been at Ohio State, which I imagine produced quite a few interesting conversations. He is a graduate of Stanford. He clerked for Alex Kaczynski on the Ninth Circuit and Anthony Kennedy on the Supreme Court. He was the 2022 recipient of the Federalist Society's very prestigious Joseph Story Award and teaches and writes in administrative law, federal courts, and civil procedure. So Chevron, as I imagine just about everybody knows, held that when agencies interpret statutes that they administer, that reviewing courts should assess not whether the agency's interpretation of those statutes is correct, but merely whether they are reasonable. Reviewing courts should defer to agencies' reasonable interpretations of the statutes that they administer. The Chevron doctrine was begun in 1984 and has been quite controversial for most of the subsequent 40 years, although it was not immediately perceived as controversial when it was first decided. It has been criticized by some, including by some members of the Supreme Court, as improperly taking away the power to say what the law is from the judiciary and instead placing it with the administrative agencies, the executive branch. And some people have suggested that it gives too much power to the executive branch to manipulate the law or the interpretation of statutes passed by Congress, perhaps in a way different from what Congress intended. Other people, on the other hand, have argued that the amount of deference that courts pay under Chevron is appropriate, and that Congress can decide how broadly or narrowly to delegate power to the executive branch when it decides to write statutes and grant delegations to the executive branch. The current case arises out of seems like a kind of rinky-dink dispute about fishing. The challenger to this famous administrative law doctrine is objecting to federal agencies' requirement to pay for inspectors to go out on fishing boats with them to ensure that the fishing boats don't catch fish that they're not supposed to. The dispute is not about whether there's any kind of power of the government to require these kinds of inspectors, and it's certainly not about the merits of the catching fish that are too small. The question is whether the agency had the power to force the fishermen, the fishing companies, to pay for these inspectors, or instead whether the government had to fund the inspectors themselves, and who it is. Of course, the classic American governmental legal question: who decides? Who is the institution or individual who gets to decide who should have to pay for the presence of these inspectors? So, Professor Jellum, if you don't mind starting us going and giving us our description of your take on Chevron and Loper-Bright.
Sure, I'd be happy to. Before I start, of course, I just want to say thanks to everyone for having me, and for Michael for serving as the moderator to our panelists. But more importantly, I want to thank each of you for being here, because if you weren't here, we would have no one to talk to. And we all love talking about Chevron. So let me go ahead and get started with my take on Chevron. First of all, I have been writing about Chevron for probably about 20 years, most of my career. So I dig very, very deeply into it. And a few years back, I wrote an article where I suggested that the court had moved Chevron's first step to being almost a pure textualist. If the text was unclear, the language was ambiguous. And I think the court may have done that when I said it did, but I think the court moved substantially away from that in recent years. And I think that may have led us to where we are today. So my thesis, and like all academics, I'm going to also talk about a paper I'm in the process of publishing. My view differs substantially about the importance of whether this doctrine is, quote, overruled or not. So I call my latest paper, I call Chevron the doctrine that cannot be named and cannot be overruled. And I want to just briefly speak about why I think both these things: one, that it's not being named, and two, why it can't be overruled, really overruled. So let's start with why it can't be named. So first of all, the Supreme Court really hasn't been naming it for a very long time. In a very famous study that Eskridge and Baer did from the court of 1994 through 2006, they found that the Supreme Court was citing Chevron only half the time in the cases where it applied. More recently, the last time the court actually deferred, so last time we actually had Chevron deference was in 2016 in the Kuzo Speed case. And then in 2022 alone, there were 5 cases where Chevron should have applied, and the court did not mention it. The only mention was in Justice Kagan's dissent in West Virginia. So in re-listening to the Loper arguments and last night, I recognized or noticed that Robert's comment was, well, haven't we already impliedly overruled this doctrine? We're not really citing it. We're not really using it. So I think, and I recognize, especially with Chris Walker here on the call and about to speak, the lower courts do have a very different approach to Chevron. They're much more sort of reactive and much more sort of automatically moving to the second step, or at least they have been. I think some of that is changing. But so my suggestion to you in the beginning is that one of the ways the court has sort of gotten rid of Chevron in the last many years is just choosing not to talk about it. And I'll explain why I think the court is doing that and why it doesn't really hugely matter. But second of all, I want to talk about why it can't be overruled. And to do that, it requires that I identify for you what Chevron is. You know, is it a standard of review? Is it a canon of interpretation? Is it a rule of law? And Professor Hickman and one of her students, Han, said in a 2020 article, I believe out of Ohio State, that it was a standard of review. And I want to respectfully disagree in part with them because I think actually Chevron's 2 steps are 2 different things. So you'll remember that Chevron has, well, at least 2 steps, right? Maybe 3, maybe 4, who knows? But let's just focus on the 2. And step 1, I think, really is a standard of review. It is de novo review. It is footnote 9 of the Chevron opinion, where Stevens said that the court should interpret statutes using all the traditional tools of statutory interpretation. And I believe that what has happened since I wrote my article years ago, where I thought the courts weren't using that approach, is the Supreme Court really has moved in that direction. It is approaching all of these cases with de novo review. And so in my mind, Hickman and Hahn were correct that this part of Chevron's first step, really is de novo review. And I don't think that that has changed. I think the court is still using de novo review, even if it's not talking about Chevron in any way. But step 2, in my mind, is not a standard of review. Step 2, really, to me, is a canon of construction or interpretation. Courts are going to defer to reasonable agency interpretation when there's no clear answer at step 2. So to me, I see this pretty much as an ambiguity resolver. We have 2 interpretations. They're both okay. That's what Chevron said. The lower court said in Chevron, both interpretations would work, but we're going to defer to the agency. So why do we defer to the agency? We defer to the agency because it has expertise, because of separation of powers issues. We don't want courts deciding policy or making policy decisions. And there is a sort of idea, whether it's made up or not, it's another story. But this idea that by leaving blanks and ambiguities in the statute, Congress may be implicitly delegating to the agency. All right, so if I'm right, and Chevron is these 2 things, 1, a standard of review, and 2, a canon of construction, then I would suggest to you that we really don't or can't overrule either. We could say that another one would apply. So let's start with standards of review. What do we normally say with a standard of review? If we don't want it to apply, we'll apply a different one. Well, there aren't a whole lot of good options out there for a conservative court that wants to delegate less to an agency. De novo review is about as non-deferential as you can get. There's, of course, abuse of discretion, clearly erroneous, arbitrary, and capricious. I don't think any of these standards are ones that this Supreme Court is going to want to adopt at the first step of Chevron. They are all significantly more deferential to an agency. And in any event, the court has already been using de novo review for the past few years. So I honestly can't see that this is going to change. The nomenclature may go away, hence my title, The Doctrine That Shall Not Be Named, but I don't think step 1 is going anywhere. So really, what are we fighting about then? We're fighting about step two. What is step two? I say it's canon of construction or canon of interpretation. So do we overrule canons of interpretation? Generally, no. I mean, we may say that we're no longer going to apply them. We may limit them. We may narrow them, as the court did to our deference and Kaiser. But we generally don't say we're overruling them. It's a procedural approach. And sometimes even when we do, it doesn't mean the other justices are going to go along with it. We've seen all the fights over justices that want to approach, or judges that want to approach cases with a textualist approach versus an intentionalist or purposivist approach. And other judges will say, well, you can't tell me how I'm going to do my job. So I do think that this canon of interpretation is the most at risk with Loper and Relentless. That the court very much could say, okay, we're going to keep step one as it is, de novo review. Maybe not calling it step one, but we're going to keep de novo review. But when we're stuck, when we don't have an answer through our statutory interpretation process, what are we going to do? And so the question is, well, one, the court could do nothing and keep the status quo, leaving any reasonable agency interpretation as the tiebreaker. Two, the court could say, okay, well, we'll do that, but we want sort of a stronger stance on what is reasonable. We want a really good reasonable interpretation. And so it might require more out of the agency. One way it could do that, or one alternative, is that the court could require something that Ron Levin and Mark Seidenfeld have argued for years, that step two is really more of arbitrary and capricious review. It's a focus on the process. In other words, the agency can't simply flip a coin to reach a result. It must actually think about what it's trying to do and provide a process where it really comes to a good interpretive decision. And finally, the fourth option, and I honestly, having listened to the oral arguments, believe is most likely, is a movement to Skidmore, a movement back to say, okay, we're not automatically going to defer to agencies anymore. But you know what, agencies, if you give us really good, thorough consideration, sound reasoning, and you're consistent, I mean, let's be honest, one of the major problems with Chevron has been this flip-flopping that's been going on. In fact, Chevron itself was a case of flip-flop, right? We had the original view was the bubble concept, then Carter came in and said, no, the individual stat concept, and then Reagan came in and said, back to the bubble concept. And it's sort of a little bit like whiplash. And so I imagine, and I know that the conservatives on the court are concerned about this whiplash. So I think that the most likely outcome is that we will keep de novo review. We'll probably stop calling it Chevron step one. And then we'll get to something along the lines of a Skidmore test, that we require the agencies essentially to do the same level of proof, shall we say, or persuasiveness that we require of other litigants who are arguing what a statute means. And so I anticipate that's where we're going to end up. I personally don't see it as a major problem. In fact, I think it might be a good move personally, based on all the flip-flopping that's occurred, but who knows whether I'm right. And I just want to close. I'm actually teaching Chevron and Skidmore tomorrow to my students, and I don't know about the rest of you who are teaching this subject. I feel a little bit at a loss to know, okay, here's, where we've been, where are we going, we don't know. So it's been very timely for me to be a part of this. So thank you again for having me.
That's wonderful, Linda. Thank you very much. Chris, would you like to join in and comment?
Sure. I mean, Linda, I think highlighted things, great on this front, kind of the different options that are out there. If I were guessing, I think there are kind of two ways after argument the court may go. One is just switch to Skidmore. I think de novo review seemed to be off the table after the parties all said that Skidmore would be the replacement. Or, which I think is more likely, although maybe I'm just drinking the Kool-Aid because I wrote an amicus brief, and I'll throw that in the chat in a minute, defending Chevron as a matter of stare decisis, that the court will keep Chevron but substantially narrow it by adding some guardrails to Chevron deference. A couple points on this front, and then I'll turn over to the other panelists. I do think Linda mentioned, Kemp Barnett and I, over a decade ago, published a study that looked at 11 years of Chevron in the lower courts and the federal courts of appeals. And we found that it was wonderful. Like, if you care about uniformity in law, if you care about getting judges out of politics, like Chevron's a really great tool for you. It was also very workable. Although there were variations across circuits, it was much better than you'd see with de novo review or some other less deferential standard. I will say though, I haven't done the hard work since then. I don't know what Chevron looks like today in the circuit courts. My guess is it's not as strong when it comes to those policy considerations I just said. One, in the Trump administration, they seldom asked for Chevron because the Trump administration, was against Chevron, and you really added almost every judicial nominee they added to the circuit courts had expressed skepticism of Chevron. Two, I don't know what the agencies were doing. It's hard to know how that was playing out. And so we just don't have a law. And three, the lower courts that did apply Chevron, in a lot of cases, they expressed a lot of skepticism, and I think decided a lot more cases at step one. So like it's hard to compare between the version of Chevron that I like, that's from 20 years ago, that I think had a lot of good values, enforced a lot of good values in administrative law, like agency expertise, political accountability, national uniformity, and predictability in law, and the Chevron we have today in the lower courts, which my guess is just not as strong. So I think whatever happens at the Supreme Court, as a matter of policy or impact, might not be that big of a deal, because Chevron's already kind of dying away. And the other 2 points I would say, that doesn't mean that the cases aren't a big deal, though. The court is right now reconsidering a lot of precedents in administrative law and other contexts. And this would be a very symbolic way of saying, the court saying, we really don't care about statutory precedents anymore, which I think is a really, really bad idea. I'm a big fan of the turtles. There are all these statutes of turtles all over the Supreme Court. I'm a big fan of the turtles. I like courts to move slowly, especially with a precedent like Chevron that's been on the books for 40 years, that the Supreme Court, that Congress is legislating against the backdrop of, that agencies of the regulated public have structured their whole affairs around, and that lower courts have applied in thousands of cases. I'm a real big fan of the Supreme Court, deferring to Congress here and letting Congress decide whether it wants to kind of modify those doctrines. And so it'll be interesting to see on that front. This could be another signal that the court's going to expand its kind of more aggressive overruling of constitutional precedents, also in the context of statutory precedents. And the last thing I'll just say, and then I'll kind of turn it back to Mike. This feels like a weird battle to have, because in a lot of ways the conservatives already won with the major questions doctrine that the court has recognized in the last few years. In other words, is what you care about, and I do care about this. If what you care about is Congress making the major value judgments in our federal administrative state, the major questions doctrine kind of puts that back in Congress's court. I mean, unfortunately, it might also put other things back there if they misjudge whether it's a major value, right? But if that's your concern, then you already have that there. Now, agencies cannot regulate major questions, issues of great political or economic significance, unless the court has decided they have clear authorization from Congress. And so I think that strikes the right balance of all the concerns. If you listen to oral argument about agencies doing all these awful things, and whether you think that's true or not, like that's, in my mind, that's the whole ballgame. So what's left of Chevron after the major questions doctrine, and Linda kind of already hit this in her remarks, you have a very searching step one to figure if the statute's unambiguous. At step two, the court has told us the agency can't act in an arbitrary and capricious manner. So it has to act reasonably. It has to explain itself. If it changes its position, it has to provide good reasons for that change of position. And three, if it wants to regulate major value judgments, major policy questions, it has to get clear authorization from Congress. So what's left is agencies are using their expertise in a politically accountable function to fill out the details and statutes that Congress has charged them with administering. And I can't imagine a better body more situated to deal with those implementation details than a federal agency. And so I hope that the court keeps some version of Chevron and maybe adds a few guardrails, and maybe as we go back and forth, might talk about what those guardrails might look like. But I really do hope they don't overrule it, because I think that they've already accomplished what they wanted to do with the major questions doctrine.
Excellent. Thank you very much. And the amicus brief to which Chris referred has he's posted a link in the chat so that you can access that material very easily. Right. Richard, would you like to say a few words?
Sure, thanks. And I'll try to be brief because most of my remarks are going to be about the second case. But thank you to Carrie and the Widener Law Review for inviting us here. Thank you, Mike, for moderating this panel. In thinking about Loper Bright and sort of a prediction of what's, well, I should start off by saying I'm very bad at trying to predict what courts or anyone else will do. I finished dead last in our family's extended family's NCAA tournament bracket, includes a submission by our family dog who finished 6 spots ahead of me. And so take all of that with a grain of salt. But I do tend to agree with both Chris and Linda that I think this may not be, even if the court pulls back on Chevron, that it may not be a watershed impact in the way that maybe some other decisions are, ways that maybe people are imagining, or at least not standing alone if you look at Chevron in isolation. But I think when you look at Chevron in the larger context of the Supreme Court's current administrative law docket, I do get a little bit concerned. And when Chris mentioned, for example, this is putting things back in the hands of Congress. And I think it is very interesting to see what Congress, or at least some future Congress that's interested in legislating, might do when it comes to this. But I worry that the court's going to talk about putting it in the hands of Congress while simultaneously limiting Congress's abilities. So on the one hand, right, if Chevron was really a case about implicit delegation, there's not an explicit delegation from Congress to an agency. And so we have this idea of implicit delegation. We want to turn back from that. Congress could respond either by codifying Chevron in some way, or in a more case-by-case basis, being more explicit in its delegations to agencies, or giving broader delegations to agencies. Because when an agency is acting within its clearly delegated authority, the review under the Administrative Procedures Act is usually for whether the agency's action is arbitrary and capricious under the sort of state farm standard. Is there a reasoned basis for what the agency is doing, which, as Linda said, is sort of pretty similar to kind of or as some people have said, is kind of similar to a step 2 analysis under Chevron in any event. So if Congress did that and made broader delegations, then you can kind of have a return functionally to a Chevron standard, where if a statute is clear, the court's going to decide that statutory interpretation question. But if it's ambiguous and the agency is within its authority, then it's reviewed under a pretty functionally sort of step 2 standard. So it's easy to think, okay, Congress can just make these delegations and we're back to where we started. I think the problem is, at the same time that you have Chevron being restricted, you also have doctrines like the non-delegation doctrine arguably being resuscitated, or the court showing continuing interest in resuscitating them. So if Congress starts to make a broad delegation to an agency, the court could turn around and say, oh, that delegation is so broad that now it violates the non-delegation doctrine and there's constitutional constraints. So you have that, I think, on the one hand, cabining, the court sort of interfering and cabining what Congress might be able to do. And on the other hand, there's, as Chris mentioned, there's the major questions doctrine, which maybe, as Chris says, is sort of the appropriate balance to strike. But I worry, on the other hand, if Congress is trying to make a broad delegation to an agency, anticipating future things that might arise and the need for agency flexibility, it's going to be very hard for Congress to make that delegation with the kind of clarity and precision that the sort of emerging major questions doctrine may require. And so if Congress is really recognizing in a lot of areas, Justice Sotomayor, I think, asked the questions about, what an AI statute might look like and who do you want making decisions about what that statute authorizes. Congress must recognize that what AI is going to look like when the agency's acting is very different than what AI might be looking like right now when they're enacting a statute. It may be very hard for them to adequately and broadly delegate that authority to an agency without the court coming back and saying, well, now this is a major question of economic and political significance. And because you weren't sufficiently precise in how you made that delegation, the delegation isn't sufficient. So I think that when you look at those three doctrines together, I do have a little bit more concern about the sort of pulling back on Chevron or limiting Chevron or overruling Chevron in some form, even if it returns to another form of deference, because I think by they're going to be putting authority, power back to Congress in this one decision, but with other decisions, taking that away, ultimately leaving what I think this court is most interested in, which I think is its authority and its power. I think it really likes being in charge of saying what the law is in that Article 3 sense of things. And I think they want to have the authority to decide what's a major question, what's a delegation, and what did Congress say in the statute. And I think when you put all those three things together, the power is not really going to be in the hands of Congress after Loper-Bright. I think it's going to be in the hands of the courts.
Excellent. Thank you very much. And Rob, I know most of your remarks were going to be about Jaruski, but do you have any comments you'd like to make about Chevron and Loper-Bright?
I'll hold my fire until we talk about Jaruski. The three panelists, my co-panelists, have done an excellent job sketching out potential implications of the court's holding in Loper-Bright.
All right. Well, then I will ask the other three if there's if you'd like to direct any questions or offer any comments in response to what the other panelists have said. Chris, I think you have something to say, but Linda, you're welcome to jump in as well.
Yeah, I was just gonna say I don't disagree with Richard at all that that the idea of sending this back to Congress is going to mean that Congress is actually do anything with it. I mean, I think that's a big fiction, and it's a huge worry if what you care about is Congress making major value judgments or Congress revisiting judicial decisions or agency decisions. But I don't have the hope. Paul Clement, who argued for the challengers, the anti-Chevron petitioners in Loper-Bright, was really kind of playing up this idea that once you have you get rid of Chevron, that it's Congress is going to be great again. It's going to start legislating regularly, and the reality is that's just not going to happen. It hasn't happened with the major questions doctrine, and that's a much bigger, bigger, more powerful tool. I do think that as academics and those on the Hill, we need to think more seriously about how Congress can respond to these these innovations on the court front. I've been floating around an idea that's probably a little bit too half-baked and crazy to go anywhere in Congress, but one idea is that you allow for a more streamlined process for Congress to review decisions that invalidate regulations on major questions doctrines grounds. There are a number of different ways that Congress already does this. The most prominent is the Congressional Review Act, where it allows for Congress to quickly invalidate major rules that agencies do. And I've proposed in a couple different papers that Congress should enact something similar to the Congressional Review Act to quickly review judicial decisions that invalidate regulations on major questions doctrine grounds. Again, I'm not sure. There are lots of problems with anything you try to get Congress to do, including, will Congress even do that, enact that? But I do think we have to think a lot more seriously, regardless of what happens with Chevron, because of the major questions doctrine, is how do we give Congress the tools to respond, to make sure that they are able to make the major value judgments that I think they should be making in the first place.
Very good.
So I have a couple of points. One, I think that Chris raised a great issue, and Richard as well. It's like, you got major questions, you got Chevron, which way do you go? How do they fit? Is it another step 0.5 step in Chevron with the major questions? I don't know. I think there's a lot of uncertainty. At this point, maybe 20 years from now, we'll look back and say, oh, it's so obvious at the time, this is how they relate. So I think that's a real area of confusion right now, and hopefully we'll be getting a little bit more guidance as we go forward. The second thing, and I did a little better than you, Richard, on my my bracket, although I can't say I know anything about basketball. I just go based on where people publish my articles, and that seems to have worked. But I do think if I had to guess, that I can say for sure that Thomas and Gorsuch are going to do whatever they can to get rid of Chevron in its entirety. And then I do think that the liberals, Kagan, Jackson, and Sotomayor, are very concerned about the court becoming the policy decision maker. Their concerns about separation of powers were very clear in their oral argument questioning. And so, as usual, now I'm going to stick Alito over with Thomas, because that's usually where he ends up. So I'm not going to worry about him, although I thought he was a little less clear in the arguments. But that leaves sort of Roberts, Kavanaugh, and Barrett, which it always does, right? It's always these days those three. I tend to lean towards maybe Roberts jumping on the Gorsuch bandwagon. I mean, he seemed very much to believe that we're sort of not using Chevron anyway. Again, I would say we aren't. We're using de novo review. So that really, to me, leaves Barrett and Kavanaugh. And I have less expectation that the two of them are just going to jump ship. I do think that Barrett is leaning towards a Kaiserizing of Chevron, which was kind of funny because really with Kaiser, we Chevronized our, but whatever. We're just making it all up as we go along, I guess. But I think that I don't think that we're going to get a straight out. I mean, we'll see who writes the opinion, right? If it's Gorsuch, it's gone. If it's Kagan, we're going to Kaiserize it. I think that's the direction we'll end up with the majority. And I think Chris's point about stare decisis is critically important, because one of the concerns is, okay, now let's say we agree with you, Mr. Clement. What happens to all those cases that have already been decided under Chevron's second step? Does everybody get a second chance, a second bite at the apple? So there's a practical implication of overruling Chevron in its entirety as well. So that would be my guess. I don't know if I'm right, but that's my expectation. That's what I'll be telling my class tomorrow. And they can either see that I'm brilliant or really stupid. I don't know. We'll find out after they're no longer in school. So that's the good thing.
Can I just add on that one? I wanted to add on what Linda was saying. So if we talk about Kaiserizing Chevron, which is like adding more guardrails to it, I think the most obvious one is Chief Justice Roberts' dissent in City of Arlington versus FCC. And there it was like whether agencies get deference for their jurisdictional rulings. But Chief Justice Roberts' point was more that the court should ask whether we think that that agency should get deference for that statutory ambiguity, as opposed to that you get blanket deference whenever an agency is given rulemaking or adjudication authority. And so he would look at things like, do we think the agency has expertise on that subject matter? Is it the type of ambiguity we think that, is it purely legal or not? If it's purely legal, maybe we don't think that Congress meant to give it to the agency. So it'd be a lot more context specific, inquiry into Chevron deference at step one, or maybe call it step zero. I would probably call it part of step one. And I do think that would dramatically change Chevron. If you think about it, one reason why Justice Scalia and the majority in City of Arlington thought it was an awful idea is that you want kind of bright line rules of the road so that lower courts and the regulated public and agencies in Congress can know if this is what the statute does, then we know we'll get deference. And if you do kind of the Kaiserizing Chevron, especially with that type of standardish type context-specific approach, the rules of the road aren't going to be clear at all. And you're really going to have to wait till a court tells you whether you're going to get deference at all. So I think that's the big worry about Kaiserizing Chevron, is you end up with this kind of mess of unpredictability in the system. And that's definitely something Justice Scalia didn't like at all. It's definitely something Justice Kagan doesn't like at all. But I'm not really sure the rest of the court is as formalist and cares as much about this kind of rule of law value of predictability in administrative law.
To me, that's as if it's saying that the second step of Chevron would become Skidmore, which relates back to what Linda was saying in her first remarks. And I wondered whether, am I right on that interpretation of this, what you've been calling Kaiserizing or kind of watering down of Chevron? Would that be equivalent to making step two of Chevron like the non-deference deference of Skidmore? And is there really any other is there a non-deference option for Gorsuch to promote, or is just some kind of deference all but necessary when we deal with cases that come from agency interpretations.
I could take that unless Richard or Linda. I mean, my reaction is I do think it's different than Skidmore. I mean, go back and read Kaiser v. Wilkie, where we had the same debate, and Kagan and and the liberals and Roberts adopt this kind of 5-step approach to our deference, like the sister doctor that deals with deference to agencies' interpretation of their own regulations. And then Gorsuch in the dissent's like, no, we should have Skidmore. So I think Gorsuch already kind of locked himself into Skidmore, not de novo review. And then you have both the Chief and Kavanaugh saying, these are technically different standards, but they are basically going to be the same outcome in most cases. So I think that's kind of my reaction. I don't think it's just a Skidmore, like mushy standard. I think there would still be kind of on-off switches. Does the agency have expertise or not? But I mean, who knows, right? We're kind of just guessing what'll be out there. I will note in the briefing, the petitioners did not say at all what standard should replace Chevron. Like, I think they very intentionally did not tell us what the replacement should be. And I think the reason why, and we haven't talked about them, and maybe this we're already running into the second case, but like, because their constitutional challenge to Chevron, I think also would apply to Skidmore. I think it doesn't. I don't think the constitutional challenge is very persuasive, but the same logic would apply to any type of deference that agencies would get. And so that's, I think, kind of an interesting dynamic. But no, I still view this as somewhat more of a rule. It wouldn't at all surprise me if Kagan is the one that authors the opinion, and maybe she just finds and replaces our with Chevron from her Kaiser opinion and just republishes it, because that's a very similar approach that you see if the court goes in that direction.
I think that analysis under a Kaiserized version of Chevron would be more structured than application of Skidmore, which is just, is it persuasive or not? I think courts could be all over it a lot. We know there are several relevant factors, but how they work in relation to each other isn't as clear as a Kaiserized version of Chevron would be.
The only thing I wanted to add is Gorsuch and Kavanaugh are huge. I think I would say big fans of Skidmore, but they don't call it Skidmore deference. They're very clear that essentially it's Skidmore, what did they call it? Respect. That you actually earn the respect of the court for your interpretation because you've gone through the steps, right? It's the difference between Chevron, which is I have to do something because my mother told me I have to do it, as opposed to I do something because my best friend has gone through all the analysis of why it's a really good decision, right? So Chevron is this, mom told me, and Skidmore is a really good person, went through the analysis and really convinced me it was the right decision. And that's how Gorsuch and Kavanaugh both understand it.
Well, thank you all. I think it's now is a great time to begin discussing our second case. The second case is Securities and Exchange Commission versus Judicial. It involves an administrative adjudication that the Securities and Exchange Commission conducted and to which Judicial objects. The Fifth Circuit lodged 3 major attacks on the administrative adjudication here, although 2 of them got next to no mention at oral argument. The second one, we'll do the 2 that don't get much attention, and then the first. The second one was a non-delegation doctrine challenge. There was a suggestion that if Congress gives the agency authority to adjudicate a case either internally within the agency or through the judicial process, that Congress just sort of leaves it up to the agency how to do it, how to enforce the requirements, that discretion violates the non-delegation doctrine. The court also, or the Fifth Circuit, that is, also suggested that the protection that administrative law judges in the SEC have from being fired without cause might violate the constitutional separation of powers. That is, the executive branch has to have authority to dismiss administrative law judges. That one, as I say, also didn't get very much attention. But what did get a considerable amount of attention was an issue that's kind of on the the line between administrative law and federal courts, the question of the Seventh Amendment, whether there is a civil jury trial right that is abridged when an agency decides to pursue civil damages against a regulated party through an administrative process that obviously doesn't have a jury. When if a similar kind of enforcement action were being pursued in an Article III court, a civil jury would apply. So there's the question of whether this kind of action could be taken through an administrative adjudication, and if it is, whether that provides kind of short-circuiting of the Seventh Amendment civil jury trial right. So, Rob, I think we'll turn to you first and ask for your take, your analysis of this case.
Thanks, Mike. So we've already heard a little bit about Charkisy this morning from Professor Lubbers. I hope I can add to the insights that he's already provided about that case. I'm going to focus on the Seventh Amendment issue that Professor Domino just described, but I will say one thing about the non-delegation issue. So Professor Lubbers this morning told us that there aren't many agencies that have the authority that the SEC does to choose between whether to pursue civil enforcement administratively or in court. There are other agencies, though, that do have that authority, and EPA is one under some of its organic statutes. And so the non-delegation holding could affect agencies other than just the SEC if the court decides to go there. I don't think it will. I think the court's going to decide the case based on the Seventh Amendment issue. And that's what I want to talk about. The parties and the justices frame this issue in at least 5 different ways at various points in the oral argument. The court's not likely to address all of them. Its resolution of the case based on one or more of these framings may leave unresolved important questions arising from the other framings. Furthermore, the different ways of characterizing the issue, as we'll see, overlap with one another in some complicated fashions. So I'm going to briefly describe the different ways to frame the Seventh Amendment issue that arose from the oral argument and give some examples of how the advocates and justices viewed those framings. First way to frame the issue is to talk about the nature of the forum. The petitioner in the case, the SEC's lawyer, argued that the Seventh Amendment right to trial by jury is always dependent upon the nature of the forum and the nature of the cause of action. I'll talk about that one in a minute. By its terms, he said the Seventh Amendment applies to suits, common law. Proceedings in agencies, he said, aren't suits. He added that the Seventh Amendment has always been forum dependent. But Justice Gorsuch responded that, I'm quoting, I think Noah Webster described a suit as any action or process with the recovery of a right or a claim before any tribunal, which would seem to be a problem for the SEC. Second way that the issue could be framed was to focus on the nature of the power exercise. The petitioner argued that the initial adjudication of cases by agencies involves the exercise of executive power, not judicial power, because the Seventh Amendment applies to the exercise of adjudicatory power, suits. Seventh Amendment simply didn't apply in this case. This was an argument that the SEC's action was an exercise of executive power because it involved the application of law to the facts, resulting in the imposition of consequences specified by law. Petitioner said, agency adjudication of a civil penalty before an ALJ is executive action. It looks like a trial. It has trial-type procedures, but it's an exercise of executive power. The jury trial right has always been thought of as an adjunct to the exercise of the judicial power in the courts. He added, even when the executive branch conducts an adjudication and applies the law to the facts, even if it looks like trial-type procedures to enhance fairness, that's not the sort of suit that requires an exercise of judicial power or comes with it jurisdictionally. Responding to that, the respondent said, a power isn't executive just because it's exercised by the executive. I think the Chadha opinion might say something different, at least presumptively. That was the response of Charkisy's lawyer. The third way to frame the issue focuses on not the nature of the forum or the nature of the executive or judicial power, but the nature of the issue. The Fifth Circuit stated that whether Congress may assign an action to administrative adjudication depends on whether the proceeding centers on public rights or private rights. Seventh Amendment only applies if the action involves public rights. And the Fifth Circuit said Congress can't circumvent the Seventh Amendment by simply passing a statute that assigns traditional legal claims to an administrative tribunal. So the Fifth Circuit said the analysis needs to proceed in two steps. Number one, does the claim arise at common law? Number two, if it does the case implicate public or private rights? On the first question, the Fifth Circuit said, yes, fraud prosecutions were regularly brought in English courts at common law before 1789. And it added, actions seeking civil penalties are akin to common law actions in debt. It didn't matter that much of the relief sought by the SEC was equitable in nature, as long as it also sought civil penalties. On the second question, this case does not involve public rights, the circuit said, because jury trials and securities fraud suits would not dismantle the regulatory scheme or impede swift resolution of such suits. The very first question at oral argument was Justice Thomas's inquiry into how the SEC's lawyer would define public rights. The attorney responded that the concept is unsettled and contested. But he said that Atlas Roofing, which Professor Lubbers referred to this morning, established that when the federal government is enforcing federal statute, the exercise of its sovereign power for the benefit of the public, that's a matter involving public rights. So this is a classic public rights case. Justice Barrett, during oral argument, asked Jarkissy's attorney, how close to the common law tort of fraud does the SEC's action need to be to trigger the Seventh Amendment? The attorney for Jarkissy responded that a claim that serves the same essential function as a traditional common law right is a private right. But the petitioner rebutted by claiming that the statutory and common law versions of fraud serve different functions. The remedies in the statutory action under the securities laws are meant to redress public wrongs. They're penalties. They don't seek compensation. As Justice Sotomayor pointed out, Justice Thomas has a very broad conception of what qualifies as a private right. He believes any government adjudication that affects a party's life, liberty, or property is necessarily a private rights case. And there was a lot of back and forth during the argument among the justices and advocates about whether there are significant differences in the elements of an SEC 10b-5 fraud claim and a common law fraud claim. Justices Jackson, Kagan, and Sotomayor all emphasized the differences. But Justice Alito suggested that the statutory claims are sufficiently close to common law fraud claim, qualify as private rights, because the elements of the statutory claim are a logical subset of common law fraud. Justice Gorsuch cited Tull versus United States for the proposition that there doesn't need to be a perfect common law analog. And Chief Justice Roberts said the SEC's claims look a lot like claims that could be brought in private, in court, before a jury, for fraud. The fourth framing of the case relates to the identity of the parties. The SEC argued this case involves public rights because, among other things, the government is a party. That's been the longstanding view, and it's the view that the dissent took in the Fifth Circuit in Jarkissy. Justice Kagan said it's been settled law since Atlas Roofing that the Seventh Amendment doesn't apply, where Congress has given an agency the power to enforce a statute. But the Fifth Circuit majority said government's presence as the party is a necessary but not a sufficient basis for classifying a case as a public rights case. Even if the government is a party, the court must engage in an historical inquiry into whether the right being vindicated is public or private. Fifth Circuit said fraud claims are traditional legal claims that arose at common law, and they're essentially about the redress of private harms. Chief Justice Roberts during the argument seemed to agree with the Fifth Circuit, but he also seemed to want to avoid applying the public-private rights distinction at all. He agreed with the respondent that the public rights doctrine is more or less irrelevant to the Seventh Amendment's applicability. Justice Kavanaugh disagreed that the presence of the government as a party is determinative. He asked this question: what sense does it make to say the full constitutional protections apply when a private party is suing you, but we're going to discard those protections when the government comes at you for the same money? And Jarkissy's lawyer argued that these underlying claims do not suddenly morph into public rights claims just because the government happens to stand in as the proxy plaintiff. He added that the issue in the case is simple. Private rights are based on the nature of the underlying claim, not the forum that the case happens to be filed in or adjudicated, and not who the parties are. Final characterization relates to the nature of the cause of action. Seventh Amendment guarantees a right to a jury trial in suits at common law. In Jarkissy, the Fifth Circuit interpreted that term to include all actions akin to those brought at common law as those were understood at the time of adoption of the Seventh Amendment. And that could include a new statutory duty that's essentially analogous to a common law duty. Justice Jackson disagreed, saying Atlas Roofing says if the government is enforcing a statutory obligation, it's a new duty, not a traditional common law duty. And if it's a new duty, she said, we've held forever. The Seventh Amendment isn't implicated because we're not talking about a common law suit. Now, Professor Jellum talked about practical considerations on whether or not the court should overrule Chevron. Those kind of practical concerns arose in the oral argument as well. Petitioner and the liberal justices magnified the consequences of affirming the Fifth Circuit. The SEC's lawyer said, a ruling that civil penalty cases must be tried in federal court could affect more than 200 statutes involving at least 24 agencies. Justice Kagan said, Congress is not required by the Seventh Amendment to choke the already crowded federal courts with new types of litigation or prevent it from committing some new types of litigation to administrative agencies. Justice Sotomayor identified EPA, the Commodities Future Trading Commission, and the Postal Service as agencies that wouldn't be able to seek administrative penalties. All of them, she said, would have to go to court. Even Justice Barrett said to the respondent, sounds to me that what you're really hoping for deep down is a really big change, because you want even the equitable remedies out of agencies too. On the other hand, the respondent and the conservative justices minimized the consequences of a ruling for Jarkissy. They said it wouldn't be a dramatic change in the law because it wouldn't affect public benefits and therefore would affect a tiny percentage of the total things that are adjudicated administratively. Roberts and Kavanaugh and Alito all went out of their way to identify all the kinds of actions that would not be affected by a ruling for Jarkissy. Respondent's attorney readily agreed, calling it a pretty long list. So how am I going to come out in conclusion here? Court's likely to affirm on the Seventh Amendment issue. If it were to hold that there's no Seventh Amendment problem, it would have to address Fifth Circuit's holding on the removal power and non-delegation issues. But it spent maybe 5 minutes at most on removal and not even 1 second on non-delegation. And I think the court's going to rule for Jarkissy on the simplest, maybe even the most simplistic ground, that the SEC's enforcement action in this case is similar enough to common law fraud action that the Seventh Amendment applies and requires a jury trial. That kind of ruling would be narrower than some other possibilities, including saying the SEC's action for civil penalties is analogous to a common law action in debt, which would affect actions by any federal agency, like EPA, that seeks civil penalties administratively instead of in court. And I'll leave it there.
Very good. Thank you very much, Rob. Richard, I understand the floor is yours. You have time to give your take of this case.
Sure, thank you. And I don't have the near the sort of doctrinal expertise as Professor Glicksman. So, and that was a very thorough discussion of various principles in the case. I'd like to take maybe a little bit of a more less doctrinal and sort of maybe more big picture view of the case. And I apologize that I made a couple slides for this part of the presentation. So if you can't see them, someone shout if they are not visible. But if they're working, we'll go with that.
We're good, Richard. We're all right.
So as was discussed, right, the defendants in the case, right, are a hedge fund and an official in a hedge fund. And what they are saying is, when accused of fraud, I don't want to have a trial before a judge, an administrative tribunal. I want a right to have be tried before a jury. And not only was defendants saying that, but they have a number of amici who are coming out in support of a robust Seventh Amendment right in this case, including a lot of business groups like the U.S. Chamber of Commerce, the American Bankers Association, the Washington Legal Foundation, and others, all of whom really are trumpeting the fundamental importance of the right to a trial by jury, the safeguard of liberty. I don't think I've seen the word bulwark used as many times as I did when I was reading the briefs. So the feeling I got from this was that, wow, defendants and defense organizations really like the jury trial. So I started reading up a little bit about this, and I came across, this is an article from the ABA Litigation Journal. And I just want to put up a quote from the business lawyer who wrote this article as sort of the conventional wisdom. If you're representing a corporate defendant in civil litigation, the absolute last thing that you want is a trial in front of a jury. And that the thing is, juries don't understand businesses. Juries are swayed by prejudice rather than facts. They're emotional. They won't understand the complexities of the case. And so a jury is a terrible forum for business defendants. And I think this is, if you talk to a lot of defense lawyers who represent businesses in complex civil litigation, I think this is really the conventional wisdom. And then you get to, this is where it came from. This is the author of the article. And then you get to Jarkissi, and you have business organizations talking about how the Seventh Amendment is the most important and valuable right that's around, quoting Justice Story and making similar arguments like this. So I'm starting to try to think about, trying to wonder what's going on here between these two things. And what I think is going on, and this deals a little bit more with some of the things that I write about, is that this is really not about the Seventh Amendment, but about corporations trying to find ways to hamstring enforcement of all types, to give them opportunities to shop for favorable forums or forums that will delay adjudication, and to do so in ways that create specialized protections for them who might face more traditionally private right cases than other potential victims of administrative enforcement who would face more public right cases. So to get a specialized rule for companies. And so one of the areas that I do a little bit of research in is in the use of forced arbitration or mandatory arbitration clauses in consumer or employee contracts, right? As you may be familiar, if you signed up for a credit card or a cell phone, in the long terms of service, you probably agreed that if there was a dispute, you would give up your right to court and go to arbitration. This is an example from Verizon's arbitration clause, and I chose Verizon only because the U.S. Chamber of Commerce, who wrote the amicus brief in Jarkissi, has also strongly defended Verizon's arbitration clause in litigation. And what they're saying is, right, we don't want to resolve this case in front of a jury. We want to resolve it in front of a private arbitrator. And often, for some of the same reasons that come up as criticisms of administrative enforcement, that they don't trust juries is one part of it, that arbitration might be more predictable, but as well, companies downplay criticisms of arbitration, that it doesn't provide the same due process protections as a court, say, when they're demanding that consumers arbitrate disputes. Yet in Judicial, they talk a lot about the importance of due process protections that are provided in a jury trial situation. They downplay in arbitration concerns about conflict of interest or repeat player bias. And this is a common critique of arbitration, that where if you have a company who has many, many customers and the company is the one that's writing the contract and choosing who the arbitrator is, that arbitrator deciding that dispute, who gets paid for resolving that dispute, has an incentive to rule in favor of the company, or else the company won't choose that company or that arbitrator again in the next dispute. Sort of a conflict of interest that would be created. In the briefing in Judicial, there was much talk about the potential conflict of interest, which I don't disagree with. That comes along when you have the government as prosecutor and also the government as sort of creating the rules that establish the groundwork for how the rule should be interpreted. And so I see this sort of inconsistency in these arguments that companies are making in the one hand in a case like this, and what they're doing in their practices with consumers and employees in other contexts. Oh, and then just for good measure, the arbitration clause will say, oh, even if the arbitration clause is unenforceable, or someone opts out, or for whatever reason doesn't apply, and we do have to go to court, you'll also waive your right to trial by jury in that court action, and you'll agree to have a trial in front of a judge, which is exactly the thing they're arguing against in a case like Judicial. So, these are very common. Some studies have shown that over 80% of Fortune 100 companies use these clauses in their claims with consumers and employees. Chances are you're subject to one of them in some form or another. Other organizations that represent business defendants, like the American Tort Reform Association, they're fond of talking about things like judicial hellholes. They talk about where juries give very unpredictable verdicts. The Chamber of Commerce recently produced a report called Nuclear Verdicts, talking about runaway jury verdicts given by in trial cases, and why this is a problem that needs to be stopped. And so I worry, based on this, that if Judicial wins this case, it just turns into a sort of another example of corporate exceptionalism. And one of the things that struck me about the oral argument in the case was that, and Professor Glicksman talked about sort of the concern about the floodgates opening if a jury trial right comes up, and how to cabin that, particularly with respect to, say, immigration adjudication or Social Security, these very large adjudicatory agencies. And the parties really tried to cabin this and say, no, it wouldn't apply in these kinds of situations. Those are different sort of cases. And I understand the doctrinal arguments for treating them differently, but it does strike me as a somewhat strange distinction or way of cabining things off. If the jury trial right is really important for really important high stakes cases, I think that's exactly where things like immigration and Social Security and these other big agencies come in. Immigration cases are often matters of life and death. If someone's getting sent back to their, forced to get sent back to a home country where they faced persecution, death threats, and violence, involves, as you can see here, incarceration, right? A sort of a classic situation where you would have federal court involvement through things like a writ of habeas corpus or other opportunities for relief. Social Security may involve what we think of as benefits, but those benefits could really make a difference as to whether someone is living in poverty or is not living in poverty, and really push someone over the line. And I understand that the fines at issue in Judicial are large, but I would be surprised if Judicial is going to end up impoverished as a result of the litigation in this case. Maybe from the fees he's paying, but but I don't think that's likely to happen. And so it troubles me that these kinds of things aren't sort of thought about in the same way as when there's a corporate defendant. And I worry with this court, they're going to be open to being more sympathetic to a corporate defendant than they would if they don't have to worry about the implications of these kinds of cases. So what I would like to see is maybe a little more equality in how this comes out. And one of the things one way would be to open up the floodgates for all cases to have jury trials, but obviously that would be unmanageable. But another way is that maybe if an entity like Jharkhasi and a hedge fund want to work in a regulated space, one of their contractual agreements for working in that regulated space is that they waive their right to a jury trial. You want to be a public company, you agree to waive your right to a jury trial in this situation. And on the one hand, that may sound coercive. On the other hand, I would ask if that's any more coercive than the terms of service you have to click on in order to continue your internet transaction, the standard form contracts that we're all forced to sign, where we give up our right to a jury trial for any dispute that we may have with a company or with our employer. And I'm not sure that it is. And so maybe if we did the same thing to regulated entities that those entities are doing to us, we would still have an opportunity for administrative adjudication in these situations. But what I don't want to see, however Jharkhasi comes out, is a rule that gives special treatment to corporations and the kinds of claims that corporations are likely to face, but not to everyone else. And I'll stop the share there.
Thank you very much, Richard. Chris, do you have a statement you'd like to make about this case?
Sure. So I would just add just briefly, picking up where Richard left off, is that I do think another path forward, at least when it comes to civil penalties at the SEC, and David Zare and I have written about this, is just to recognize a right to remove an agency adjudication when a civil penalty is introduced. And I have a hunch that if you look at the folks that want to be in court, they tend to be individuals and smaller businesses who think a jury might be favorable to them. And I bet you a lot of the big businesses would much rather just stay at the agency where it's not as public, it's not as costly and the like. That said, I completely agree with Richard that obviously part of this is just raising the cost of enforcement generally on the agency, such that you won't have any cases, enforcement actions being brought, right, or really limited. So I think that in the backdrop, I recognize that. But Dave and I just suggest that one path forward that the SEC could do today is just issue a regulation, a procedural rule that recognizes a right to remove. And we argue that would solve all the constitutional problems that the court's confronting in Jharkhasi.
Very good, thank you. Rob or Linda, do you have any comments on anything?
If I could just chat briefly about Richard's comments. I mean, first of all, I love Chris's option. I was out early saying the ALJs are unconstitutionally appointed under Freytag. Not Freytag, I'm sorry. I'm losing my mind here, but the other case that basically took 4 cause removals is problematic. But one of the ways I got so involved in working with the SEC is I worked with a regulated entity that was challenging some enforcement actions against it. And I came away with the belief that the ALJs were not in that case at all neutral arbiters. And so I think equating, the question you asked, Richard, is why would the businesses say they don't, they want a bench trial, but they don't want a jury trial. And now all of a sudden saying they want a jury trial, they don't want an ALJ. And I think that's partly the quality of the ALJs and partly a fact that the ALJs are working for the agency. I recognize we are supposed to not think that's problematic, but I can tell you in my experience, it very much was problematic. So I think that's why you're seeing a difference there. So I hope your paper will address that. But I do agree that I don't want different rules for businesses versus others. I'm looking more for equality of everything. But as a result of that, I absolutely adore Chris's solution.
All right, once more, thank you to all of the panelists for their contributions here and to the Law Review for putting it together and inviting everybody, including me. It was a pleasure and an honor to serve as moderator for this. I learned a great deal, and I always enjoy the opportunity to chat administrative law with you, and particularly with the absolutely wonderful scholars that are part of this panel. So thank you all very much.
Good afternoon. Welcome back. We have one more panel for you this afternoon, and it is the independence of administrative law adjudicators. And moderating over that panel is Professor Joel Cheskis. So I will pass it off to him to take it away from here.
Okay, thank you, Carrie. And good afternoon, everybody, and welcome to the final panel for the day. I hope everybody's enjoyed the symposium. I've enjoyed the parts that I've been able to watch. Our topic for this panel is the independence of administrative law adjudicators. And again, I hope everyone's been enjoying the symposium today. I'm happy to moderate this final panel of speakers. Their extended biographies are included with the other speakers, and I refer you to that for more details. Again, my name is Joel Cheskis, and by night, I'm an adjunct professor here at Widener. By day, I am counsel to the chairman of the Pennsylvania Public Utility Commission. Prior to joining the chairman in December of 2022, I was an administrative law judge at the PUC for 11 years. And prior to that, I litigated cases at the PUC for the Office of Consumer Advocate for 13 years. I want to take a moment also to thank Kerry and Brian and the school for asking me to moderate this panel. I've been an adjunct since 2016 and have always considered it an honor and a privilege. Widener's been good to me as an adjunct, and I'm thankful for that. When Kerry asked me to moderate this panel, I thought this would be a small way to show my appreciation to the school for what it has done for me. So again, I'm happy to be here. Before I turn things over to the first speaker, I would like to encourage everyone to consider questions for the panelists for after they have made their initial presentations. I've asked each speaker to speak for 10 minutes or no more than 10 minutes. So we will have some time at the end of their presentations for questions, and you can send those questions to the chat box that's Kerry is going to be looking for or following for us. And I apologize in advance to our speakers because I will be trying to keep everybody to their 10-minute time limit, and hopefully I'll do that as respectfully and professionally as possible. Having said that, I'd like to introduce the first speaker, and that is Professor Nick Bednar. Professor Bednar is an associate professor at the University of Minnesota Law School. Prior to joining the faculty of Minnesota Law, he received his PhD in political science from Vanderbilt University. His research focuses on administrative law, executive branch politics, and immigration law. Professor Bednar, take it away. Thank you.
Thanks, Joel, and thank you to everyone else for joining us today, and especially thank you to Carrie and the Law Review for setting up such a wonderful symposium. So I want to spend my time talking about the relationship between adjudicator independence and the political control over resources and procedures. So typically, when we talk about independence of agency adjudicators, we focus on the ways in which the agency's structure and the agency's leadership influences the decisions of the administrative judges. And specifically, we worry that extrajudicial or political pressures may seep into the adjudicator's decision-making process. And the perception of extrajudicial decision-making impedes due process principles because we want judges to reach decisions based only on a thorough consideration of the facts and the record. When we as legal scholars and reformers become concerned that there's an undue influence on agency adjudication, our immediate reaction is to come up with additional procedures that increase the likelihood that decisions reflect a more thorough consideration of the record and are a bit more transparent. And what I want to suggest today is that's not always the best solution, that adding on procedures without considering other things going on with respect to adjudicatory agencies can lead to some problems. So specifically, we often fail to consider that elected officials control the procedures and resources provided to agency adjudicators. And imposing additional procedures on the adjudicatory process comes with a cost. It takes time, energy, and staff for adjudicators to comply with additional procedures. And without sufficient resources, agency adjudicators aren't able to arrive at the timely, accurate, and thorough decisions that we expect. So when judges, specifically agency adjudicators, lack sufficient resources, we tend to observe that they take procedural shortcuts and ultimately reduce the thoroughness with which they review the administrative record. So let me briefly discuss one agency from my own research where empirical evidence suggests that we should have some concerns about resource constraints. And specifically, that example involves the Executive Office of Immigration Review, which is an agency in the Department of Justice. So typically, most people know this as the immigration courts. So the immigration courts, if you're not familiar with them, adjudicate removal proceedings by deciding which non-citizens will be allowed to remain in the United States and which will be ordered to return to their home countries. And we'll hear momentarily from Judge Sanoff, who I'm sure will offer kind of an internal perspective on the immigration courts, but let me offer a perspective as just one external observer. So in 1998, the immigration courts had a backlog of 116,000 cases, which is a sizable backlog. When I checked earlier this week, it's at 3.5 million cases. In an average week, the average immigration judge hears 14 merits hearings, and each of these merits hearings typically has a record of about 100, if not more, pages. So let's focus on a single resource that aids immigration judges in managing their workloads, and that's their law clerks. So law clerks play a fundamental role in any adjudicatory system, but in particularly the immigration courts, because they have such high workloads. So these law clerks review the administrative record, provide the immigration judge with bench memos, and draft proposed orders. And in doing so, they provide an additional check on immigration judge decision-making, helping to ensure that the immigration judge's decision reflects the evidence offered in the record. But ultimately, there's an insufficient number of law clerks working within the immigration courts. So in every budget request, the immigration courts have consistently requested funding for a 1-to-1 ratio of law clerks to immigration judges. And at the time I did my study, the agency has never met that ratio. So my empirical work suggests that providing an immigration judge with an additional law clerk increases the likelihood that the judge grants an individual asylum by over 5 percentage points. And conservatively, my analysis suggests that if the immigration courts completed their backlog today with the current level of staffing that they have, they would remove 45,000 additional individuals from the United States than if the immigration courts had just 200 more law clerks. So we can debate which group of judges is correctly applying the law, whether it's those with the law clerks or without. But regardless of the answer to that question, we should be concerned that resource disparities are producing different outcomes in these cases. An additional problem emerges in the immigration context because presidents in the Department of Justice also play a role in shaping the procedures that immigration judges must use. So let me give one recent example of how control over procedures affects perceptions of due process and the way that adjudicators conduct hearings. So in March 2018, the Trump administration announced new performance metrics that would require each immigration judge to complete a minimum of 700 cases per year to receive a satisfactory rating under the new performance metrics. And the goal of the Trump administration was to try and reduce the backlog, this now 3.5 million pending cases backlog, but in a way that would also increase the amount of removals we were seeing. So 30% of judges failed to complete 700 cases prior to this, despite having caseloads greater than 700 cases. And that's in part because they lacked the resources they needed to move through this case log. And when the performance metrics ultimately went into effect, immigration judges without law clerks reduced the average hearing time by 24 minutes for merits hearings. So judges with sufficient resources were able to avoid reducing the quality of their review despite these additional procedural burdens. Yet judges without sufficient resources were forced to hold shorter hearings to manage their workloads. Now, at this point in time, the backlogs in the immigration courts are fairly well known to the public. John Oliver has a long, segment on it that became quite popular. It appears in the New York Times or the Washington Post every couple months. People tend to know about this backlog problem. So the question becomes, why do Congress and the presidents invest so little in the immigration courts and spend such little time providing them with the resources they need to manage their workloads? And ultimately, a significant explanation for the lack of resources in immigration courts, and frankly, all adjudicatory agencies, is political control over the budgetary process. So building and renovating courtrooms, hiring new judges and new staff, and just generally ensuring that the agency has what it needs to do its job requires money. And specifically, that money is controlled by Congress in the federal context. So a sizable literature demonstrates that Congress and the president want to invest money in things that improve their chances of re-election. And ultimately, neither members of Congress nor presidents perceive adjudicatory agencies as a top priority because the public doesn't really observe what these agencies do. And so individual members of the public, voters, may have opinions on border security or humanitarian benefits for immigrants, but they rarely view funding in the immigration courts as connected to those policy concerns. And so it's unclear how we get individuals to care about that in a way that encourages Congress and presidents to invest in the immigration courts. And if we want agency adjudicators to offer parties a thorough and expeditious resolution of their case, which I think due process requires, then we need Congress and the president to offer sufficient resources to those adjudicators. So to summarize and conclude, we need to broaden, in my opinion, our understanding of adjudicator independence and think about who controls adjudicators' resources and the procedures they use to reach decisions. Because it's not just who can ultimately controls the decision, it's how can you manipulate the context in which those decisions are made to achieve different outcomes. And we should be concerned about that with respect to resources. So I'll conclude there and turn it back to Joel.
Great, thank you very much, Professor Bednar, and great job keeping to the 10 minutes. So appreciate that. Our next speaker for the panel is the Honorable Charles Thomas. He is from the District of Columbia Department of Youth Rehabilitation Services and has in fact served as the first administrative law judge for the District of Columbia assigned to that department, and has been doing so since August of 2019. Prior to joining that department, he worked for the Deputy Mayor for Health and Human Services as a policy advisor, providing technical assistance and recommendation on, among other things, citywide violence prevention. I know that I referred everybody to the full bios that are available online, but I did want to just note that he is an alumni of the University of South Carolina, and of course, their women's basketball team just won the national championship, so I wanted to point that out. Having said that, Professor or Judge Thomas, take it away. Thank you.
Yeah. Oh my gosh. Now I'm on the big screen. That's pretty scary. So thank you for having me, and congratulations in advance of this wonderful conference that you have. Let me first start off by getting the disclosures out of the way. I'm here as my own voice. None of my opinions here are the opinions of the government for the District of Columbia, past or present employers, and I'm not adopting any of the positions the panel members who might have come before me, especially since I haven't heard them all. But let me start off by saying I wanted to bring to the table in the discussion sort of the foundations as to the importance of the independence of administrative law judges. And I'm going to throw in hearing officers into that bucket as well, because I'm on the board of the National Association for Administrative Law Judges and Hearing Officers. And if you guys are interested in that, please search up NAHO, N-A-H-O, and look at possibly joining that organization. I also wanted to offer that DC is a great model for independence of and when I say DC, I mean the district government. Many of you may know there's the federal government, and then there's the separate District of Columbia government, which acts as the local sort of state, county, and city government for the District of Columbia, although we're all under congressional oversight in the long run. I wanted to offer that DC government is a model in terms of the structure that we use for the independence. And I wanted to first talk about the foundation for the importance, and then possibly give you guys some insight into what you can bring back to your jurisdictions or advocate as you appear before agencies, or if you're performing these duties as a hearing officer or an administrative law judge, what you can recommend and advocate in your own local areas in terms of changing of rules and job descriptions and things of that nature to sort of help sort of safeguard the independent nature of administrative law judges and hearing officers. The first important factor for the independence is obviously the impartial adjudication. Independence ensures that ALJs, administrative law judges, can basically adjudicate cases fairly. You don't have to worry about, are you losing your job, or are you going to not get a raise, or are you going to get the office in the corner of the basement next to the boiler? If you make a decision based on the facts or the law that the director or whoever your supervisor may be does not agree with that. So that's sort of the baseline, is it allows that impartial third party, neutral party position from the get-go of any case or matter that might be before you. The second, obviously, is the preservation of due process. I mean, sometimes, as we all know, what people with power want is more power. And when they have more power and they can create the rules of the game, they will take the opportunity to write it in their favor. And while that's okay sometimes in some of the lanes, we have to remember that some of the guardrails on those lanes and those regulations are constitutional protections, such as due process. And oftentimes we'll see in jurisdictions or in agencies where they try to, there's an attempt to rewrite the rules or the regulations in an effort to sort of skip over the due process or shorten it into a manner that will violate either procedural due process or substantive due process, and allowing a neutral third party, independent of the agency's intent or actions or outcomes, to sort of protect those guardrails is very important. The third is judicial integrity. I mean, for those of us who are judges who are also lawyers, and those of us who might be a hearing officer, as well as those of you who are appearing before such officers, judicial integrity means a lot. And it means a lot not only to the public, which I'll get to next, but it also means a lot to ourselves, because we're a self-regulating profession. And allowing the judges the ability to do their jobs based on the law and the facts and the details, instead of a political outcome or an agency operational outcome or a budgetary constraint, allows us to maintain that freedom and privilege that we have of being a self-regulated profession. Number 4 is public confidence. I deal a lot with the public. I do juvenile cases, special education cases, employee terminations, business licensing revocations. I do fraud residency cases and a couple of others that I can't remember. But they all jump at me they're all coming at me with members of the public, and they're all coming from various educational backgrounds or interactions with the law. As many of you may know, administrative law judges and hearing officers are the most likely judicial officer that people interact with in terms of the government, even before they even go into court. So it's a way to maintain that confidence with the public, that when they interact with their government, whether it's county, state, or city, or federal, that at least they're going to get a fair shot, a fair hearing, and that the rules are not tilted in a way that the person hearing their case, who may be employed by the same agency that they're contesting, has already made a decision, because ultimately they're looking out for their skin more so than the parties who may have skin in the game. The consistency and predictability for the independents is very important. So you're not flip-flopping from one administration to the next. You're not making decisions that are not based on the law, and it's really more of a who wants to please the boss between the administrative law judges. It allows for that consistency and predictability in terms of maybe not necessarily the outcome, but at least in terms of the rules of the game and the process that will be followed. Next is checks and balances. That is probably the biggest pushback that I get, because nobody's happy when they lose, whether it's the agency or whether it's the private party. But as the administrative law judge or hearing officer, if you have true independence, you're able to be that accurate check and balance against the agency, specifically when you know that based on the law and the facts that what they're doing is not correct. And it allows you to say, stop it or fix it, whatever the case may be. Some of these other ones are pretty basic, like the legal expertise, the protection against arbitrary actions, and adherence to the rule of law. All of that is pretty basic and maintained by the obvious factor of the reason why we have a separate branch of government on the federal level and the state level being the judiciary is because it allows for all of those things to fall under the umbrella of separation of powers. So in short, I'm going to stay within my 10 minutes and say that, I'll offer these things as sort of tools that you can bring back to your own jurisdictions or thoughts if you're in an agency and you feel like you're not getting a fair shot, or that perhaps the hearing officer or the law judge is reporting to the wrong person, or the fix is in, or whatever the case is, or if you're in an agency and you just want to kick it up a notch and maintain a higher level of integrity. I'll offer a couple of things. One, here in the District of Columbia, my job description specifically says that I am not to report to any member of the agency's general counsel. So that means the agency lawyers are the agency lawyers. I don't report to them in any way, shape, or form. I don't have to listen to any recommendations, any suggestions, any pressure coming from them. I report to the agency director. So, and we have a very strong tradition here in the district that you're sort of in the agency, but you're not of the agency. So while you sit in the agency and you report to the director or the chief administrative law judge, if you have one in that particular agency, you're sort of left alone. They sort of obviously pay your salary, give you the workspace and the resources that you need. But there's a culture there that is instilled that, we're here, but we're not of the agency. So that might be a tool that you may want to start working on or start planting those seeds in your respective agencies. The third tool that we have is that specifically in our job description, it states expressly that adverse decisions cannot be the basis for discipline or removal in any way, shape, or form. So it allows us the freedom to call out the agency, even if it's, my boss, the director, and say, hey, the director made a mistake, or the director issued told the agency to do something in violation of this party's constitutional rights. And having the freedom not only enshrined in writing somewhere, but specifically having it in your job description, which holds the agency's HR department and everyone else to account, is a way to strengthen the independence in your separate agencies. So keep that in mind as you go back. There's some other tools that we use here in the district that may not be necessarily appropriate in wherever you practice. Like for instance, all of the hearing officers at a set point moving forward in time and administrative law judges have to be licensed attorneys. The ones that weren't before sort of grandfathered in, but as the district moved to up its game of independence and knowledge of the law and facts and the independence from those that they report to within an agency, obviously bringing the ethics that come with being a licensed bar in the District of Columbia sort of helps put the pressure not only on the agency to leave that person alone, but also the pressure on the acting official to maintain the ethics to not even reach across the aisle for the party who they may report to, such as the agency. So I'll leave it there. I'll come back for any questions that you have, and I'll turn it back over for the next speaker.
Great. Thank you so much, Judge Thomas. Our next speaker is the Honorable Mimi Tsankov. She is in her second term as the president of the National Association of Immigration Judges. and also serves as a vice chair of the Federal Bar Association's Judiciary Division. At the American Bar Association, she is chair-elect of the Judicial Division, National Conference of Administrative Law Judges, and she is also a member of the Board of National Association of Women Law Judges. Judge Stankoff, thank you.
Thank you so very much for that introduction and for the fascinating presentations that I've already heard today. I'm really excited for this panel, and let me go ahead and provide you with my disclaimer language, some good footing as I describe what I'm here to talk about today. Let me just get all of my language in front of me. So I am appearing today in my capacity as president of the National Association of Immigration Judges. I'm not speaking on behalf of the Department of Justice. The views that are expressed here do not necessarily represent the official position of the United States Department of Justice, the Attorney General, or the Executive Office for Immigration Review. The views represent my personal opinions, which were formed after extensive consultation with the membership of the National Association of Immigration Judges. So Professor Bednar did a really great job of framing what the challenge is at the immigration courts. And I'll put a little more flesh on the bones of what he described. So you know that we have about 700 non-managerial immigration judges at the court right now. And there are almost 70 courts around the nation. You heard about the case backlog, which is reportedly at over 3 million cases. And if you were to calculate that out and do the math, it comes out to about over 3,500 cases per judge. So you hear that the immigration judges are clearly dealing with a lot of work, as we all are. And the judges are on the bench pretty much almost every day, all day. They sometimes handle 3 to 4 individual trials a day, and sometimes deal with master calendars that have up to or more than 100 cases at a time. You heard Professor Bednar when he was talking about the resources and the challenge of resources. And he talked about the value of having more judicial law clerks and attorney advisors, which are our second-year law clerks, appointed to the court. We welcome that. In fact, Congress and the Executive Office for Immigration Review have submitted in their appropriations requests the funding of what they call judge teams. So a study's been done, and they say that the ideal grouping to make a judge effective on the bench would be 5 individuals per judge. It includes the judge, a 0.5 full-time equivalent of a Board of Immigration Appeals attorney to handle the appellate work associated with that judge's cases, a 0.5 full-time equivalent of a judicial law clerk. Professor Bednar might take issue with some of the ratios here, but that's what Congress thought was a good idea, and that's what EOR said was a good idea. 1 full-time legal assistant for each judge, and then 3 other individuals that could be another legal assistant, interpreters, and other mission support personnel. So this is what they say you need in order to have a really effective judge on the bench, to make sure that all the forms have been sent out, all the hearing notices have been timely mailed to the parties, and that all the documents are in place in order to ensure that a hearing is ready to go forward on the day of the hearing. And so, despite the fact that a lot of those requests have been made of Congress, and this has been a pretty high profile issue for quite some time now, not only on Capitol Hill, but in the media, we haven't always been successful in getting the appropriations that we need to deal with the volume. One of the things that obviously has raised a lot of attention is this growing backlog. So it seems one of the most recent studies that I saw from the track team is that the judges are more efficient than they've ever been and completing more cases than ever before in real time. However, that backlog is just growing. So that's a worry. And we certainly as a society need to find a way to address that. One of the concerns you heard expressed by Judge Thomas was that when you pit, in a sense, the needs maybe of an agency against the needs of the judge to ensure due process and a fair system and ensure judicial integrity, there can be an incentive to cut some corners. And so that's where in our agency, the National Association of Immigration Judges has a real role to play. As the president of that organization, we have been very vocal on Capitol Hill. We're invited quite often to speak on Capitol Hill about issues facing the immigration court. We've also been quite vocal in responding to media inquiries in the past. Because the public is very interested in understanding what's happening with the immigration courts and why the backlog is growing. We garnered a lot of attention over the past, I don't know, maybe, 10 years or so. And it resulted in a real backlash on the part of the last administration, where we were targeted for decertification of our union. It's almost unheard of to have a union that loses its certification. I think the only other one were the air traffic controllers, decades ago. So we were targeted, and ultimately the last administration and this administration too, they were successful in decertifying us. However, we think it's an extremely important fight to continue to fight to regain our union status, because we are the check against the potential for, ways in which due process could be violated or judicial integrity undermined. And if we're not there fighting to ensure that corners aren't being cut, we can certainly anticipate that there'll be less public confidence in the decisions of the court. So what is another area that is really driving, I think, the questions about the integrity of the immigration court, separate and apart from the high volume of cases that we have currently pending? It's the fact that we have our court housed within the top law enforcement agency within the US government. We consider that an inherent structural flaw. We're housed within the same agency that's charged with prosecuting, we're housed within the same administration that's charged with prosecuting the immigration cases before the immigration court, the Department of Homeland Security. But in addition, the same agency is charged with prosecuting immigration cases in federal courts. The Attorney General controls the jurisprudence, the docket management, and even the terms of employment of the immigration judges. And this has led to undermining of public confidence in the courts. So what do we do to try to fight against that? Well, we try to highlight the fact that this is a potential problem. We raised enough concern that it was picked up by the House of Representatives Judiciary Committee, and they were very concerned about the charges of potential politicization at the Department of Justice, controlling the case law and controlling the cases, the way the cases are presented, not necessarily presented, but assigned to judges, and politicization around the dissemination of resources. So there were hearings that have been held, and in 2022, we were very happy to find out that the House Judiciary Committee introduced a bill to create an independent immigration court under Article 1 of the US Constitution. We think that that would be a good solution. It would restore integrity to the system and ensure judicial independence. And it is a solution that has been fully supported by the American Bar Association, the Federal Bar Association, the National Association of Women Judges, and even the American Immigration Lawyers Association. So we continue to, as an organization, liaison with our partner organizations around this issue and work. As you heard, I'm involved in a number of different organizations, the ABA, FBA, NAWJ, and others, to try to continue to make sure that we raise the profile of this concern. And we're fortunate that the House Judiciary Committee, once again during this Congress, has introduced another Article 1 bill. So I think I'm at my time of the allotted time, and I'll go ahead and stop there and hand it back to our moderator to let the next speaker present.
Great, thank you so much, Judge Sankoff. Our next presenter is Chief Hearing Examiner Deborah Rand. Deb Rand, she is currently the Chief Hearing Examiner with the Department of State here in Pennsylvania and supervises that office. She also has experience with the State Civil Service Commission, the Pennsylvania Commonwealth Court, and the Office of General Counsel, Department of Corrections. So she not only brings a more focused Pennsylvania perspective, but does that from a variety of different vantage points. So Judge Rand, and I've known her for a long time, so I'm going to call her Judge Rand, but I've always known her as Deb.
And
so.
I will do the disclaimer I always do. I'm not a judge. I'm a hearing examiner. I can't put you in jail. And I tell that to anyone who calls me judge because I don't like misleading people. And I cannot do those things. Good afternoon, everyone. Thank you very much for joining us. I am going to switch the focus a little bit. Joel is correct, to the state system. A lot of what we've heard has been about federal and immigration law. So what I'm going to be talking about is strictly law in Pennsylvania and how things work. We have a somewhat unique situation here in that the Office of General Counsel, which is counsel to the governor and oversees all of the agencies over which the governor of the state has jurisdiction, has created this Office of Hearing Examiners. Now, we're housed within the State Department of State, but we actually service it's about 25 different agencies, and we write adjudications for them. Our work is everything from just making a record and certifying it back to the agency to being the final decision maker. That is, that it is the final appeal that would go to a court, to writing a recommended decision. We do all of those things depending on what the particular agency is asking us to do. So we have some considerable variety. We do not have the system that Judge Thomas described, which is if you write a bad opinion, we can't fire you. We don't have that. But I'm happy to say we don't seem to have needed it. It doesn't work that way. At least it has not, in my experience, with the system. What I have seen and what I have counseled my hearing examiners to do is we are independent. We make the decision we believe that the law and the facts compel us to make. We sign our decisions, and that is our decision. And that while we may and often do disagree with the agency head or the agency department or whatever it might be, it's about the tone. It's really about the tone. I have found in my years of government experience, which is now more than 40, that you can pretty much tell somebody anything if you say it in a way that's respectful and understands their constraints. I think that's really the key. No one wants to look a fool. And if you can write your decision in a way that says, although I don't agree with your position, I understand why you took it. I understand why you did what you did. I think that goes a long way. And that is part of what I think helps us be independent without having to worry about the political backlash that we might face. I want to point out a fact that is so basic, but often people don't even think to say it. Administrative agency laws and administrative agencies themselves are actually tripartite in the sense that they really contain all the aspects of government in one body, because an administrative agency can write regulations, which are akin to statutes. It can do judicial work, which are akin to administrative decisions. And it has somebody who is the head of that department, who is essentially like a little mini governor, who is making the decisions, the head decisions for that agency. So unlike the federal or the state government, where you have 3 different people or bodies doing this, it's all happening in one place. And that does present challenges. And I think those challenges have been fairly highlighted here, that there can be pressures on administrative judges to roll with the punches, do what the agency wants. This is really an important decision to us. Don't embarrass me, whatever it is. And we do have to stand strong on that. And I think, again, a way of dealing with that is to be sure that you include in what you write your understanding of the point of view that you may not be adopting. One of the things Pennsylvania does, which helps us, I think, to minimize some of these problems, is we follow something called the Linness rule, which comes from Pennsylvania state law. And I'm not going to go into the long details of the case, but essentially the courts were concerned with a situation where people who are acting as the prosecutors for the agency are having conversations with the people who are deciding ultimately the case without the other side being there. It would be like the district, a district justice or a judge having a conversation with a district attorney about the merits of the case without either the pro se or the public defender there. So that is a concern. And even if nothing bad happens, what the courts have said is it's the appearance of bias that presents the concern. And I do believe they're right about that. And I do want to harken back to the statements others have made, that it's really important to show trust in the government. For people to trust the government, they have to believe it's on the up and up. And I'm sorry to tell you, a lot of people don't. And that's not about whether you're voting red or blue. There's a lot of people on both sides that are distrustful. So I think it's extremely important that we are on the up and up. I do not speak to one side if I do not have the other on the phone. If a pro se emails me something, not understanding they need to carbon copy the other side, my response automatically carbon copies and forwards it so that they know, so everybody knows I'm not having secret meetings with one side. And I think really for me, we deal with so many pro ses with the many agencies we have. My biggest concern is the perception that the pro se has, or even if it's an attorney who does not routinely practice administrative agency law, but for some reason is known to this person who hired them. I want them to feel they're in a fair and neutral forum. And I do think that making sure that they understand we don't have secret talks around here. Everybody gets the same respect around here, and opinions will be written with courtesy, goes a way towards it. And yes, I have received letters from people who have said, thank you. Thank you for hearing me. I understand why you did what you did. And I think one person at a time, we can help to really regain trust, but it is a long process. That's it. Thank you, Joel.
Great, thank you. Thank you, Deb. And our final speaker, I hope everybody's also thinking about questions, because we're going to turn to questions after Jen is done, but also focusing on Pennsylvania, and also someone I know very well, works right down the hall from me. Jen Barrier currently serves as the Executive Director of the Pennsylvania Public Utility Commission, which is an independent administrative agency that regulates all public utilities conducting business in the state. Prior to joining the commission, she served as the Secretary of the Pennsylvania Department of Labor and Industry, where she had oversight of things such as workers' compensation, workforce development, unemployment compensation, and various safety and labor laws that protected Pennsylvanians. And I think she's the only one on this panel who is a proud alum of this very institution. So welcome back to Widener.
Thank you, Professor Cheskis, and thank you to everyone for inviting me to participate in this wonderful panel. Just very grateful to be asked. You know, at first I didn't know if I necessarily fit into this discussion, but, you know, I think after meeting with the different panelists and hearing what they had to say, I think I bring a little bit of a different perspective to the conversation. And that's more from the agency head administration perspective. You know, I served as the agency head for the Department of Labor and Industry, and am now responsible for the overall operations of the Pennsylvania Public Utility Commission. And I have that experience of overseeing the resources ultimately that are allocated to administrative proceedings, and also to looking and reviewing recommended decisions and orders. And so I have a little bit of a different take on administrative law independence. And let me begin by saying these are my own opinions. They're not reflective of the PUC or the Department of Labor and Industry, just based on my experience and what I've done. But I have to say I've always respected the independence of administrative law judges and hearing officers. As an agency head or as the main administrator of an agency, obviously you're dealing with a variety of matters that come before you. And at the end of the day, back to what Judge Rand said, you want to make sure that people feel heard and that they were part of a process. And due process is so vitally important, especially at the executive level, when you have those different hats that you're wearing, the quasi-legislative hat, the quasi-judicial hat, and also the executive role. So, you know, as an agency head and an administrator, I place a great deal of reliance on our administrative law judges and hearing officers. You rely on these individuals to truly be experts and make sure that due process is followed, that people are receiving hearing notices, and that their witnesses and documents are being presented fairly, and that it's before a neutral fact finder who will ultimately draft a proposed decision and order. So, you know, it's interesting because at the Department of Labor and Industry and at the PUC, you know, I've dealt with the Department of State, Judge Rand's compadres overseeing some of the laws that we enforce at Labor and Industry. And, you know, there would be recommended decisions and orders that we would designate the Department of State to hear, and that would ultimately come back to the department for the final order to be issued. And that was really important because as the agency head, you do have to make sure that, you know, you're not commingling those prosecutorial and adjudicatory functions, because, you know, ultimately when issues are heard and ultimately appealed before the judicial branch, you want to make sure that there's integrity with that decision and that the folks who are going to be representing those decisions before in the appellate courts have good cases to rely upon and have those strong facts and those arguments to support the rationale behind the agency's decisions. So it was an interesting time because you know, at some point I was unable to talk to certain parts of my team as an agency head as far as what they were doing on the prosecution front. We were always very careful to never talk about or discuss matters that were being prosecuted. But also, I was also very careful to not speak to the people who were ultimately being the fact finders that were going in and issuing the decisions that were going to be coming before me. So, you know, it's a very precarious role to navigate, but I think that with the court decision that Judge Rand referenced, that I think agency heads and agency staff are fully aware of making sure those walls of division are up and have put in place the infrastructure to ensure that doesn't happen. The Department of Labor and Industry is definitely one of the most political agencies in government. Obviously, you have two stakeholders that are kind of opposing. You have, you know, workers versus employers. And, you know, while judicial independence is very important, you do often see the pendulum swing in the agency as far as whether there is a Republican governor or a Democratic governor, and the personnel that you have during those times really they really want to try to sway one way or the other, and having that judicial independence is so vitally important to making sure that there is a fair process. And, as an agency head, I have had some recommended decisions and orders come before me. And for the most part, I'm happy to say that I've had no problem affirming them. Sometimes when there's a close call and I might feel a little bit differently from the proposed opinion and order, I might, change that order and that decision just a little bit. But when you do that, you really run a risk, because this is the person who ultimately gathered all the facts, who was there with the witnesses and with the parties, and really made that call. So there's a great deal of deference that you give to those decision and orders. And I think that as an agency head, you take that into consideration when you're reviewing it. In addition to working with the Department of State as an agency head, there's also other administrative law judges that have fallen within my purview. I know Professor Cheskis mentioned the workers' compensation, which has its own system in place. There's workers' compensation judges, then there's a Board of Appeals, but that's a little bit unique since it's outside of the Office of General Counsel. These are judges that are actually cohabitate within the agency. And in order to kind of give them that independence, they're actually civil service employees. And that's actually the same at the Public Utility Commission as well. That means that their hirings and the way that they're recruited is merit-based. It's not based on a patronage system, which is purposeful, and it is meant to ensure that independence. I'm unable to discipline a judge without cause. A judge has that protection within their role from being terminated without proper cause. And frankly, to build that kind of case, it has to be a really strong case, and there has to be something there that would merit a termination and ultimately would be upheld before the Civil Service Commission, or if it was appealed, the court system. So there's an infrastructure in place that I think protects judges within the Commonwealth, within the state of Pennsylvania, and that's part of the civil service system. But it has been very challenging as an agency head, especially when you have folks who are more political coming into the governor's office and not understanding, well, why did the judge issue this decision? Can't we just get rid of them? No, these individuals are independent, they're protected. This is what they found, and it needs to run through the system as far as due process being appealed, whatnot. Professor Bednar made a really, I think, an important point about resource constraints. And, I think that is a really interesting concept. And I know I deal a lot with budgets and, resource allocation. And within the Commonwealth, what I typically see is, there's line items for budgets. And when you reduce resources, you're not just reducing it for the ALJs, you're also reducing it for the prosecution of those types of cases. So from a political perspective, there are certain accounts that are restricted and that are not as much up to that political process of the legislature determining the budget. It tends to remain stagnant. But there are some program areas I have seen with reduced resources, whether it was intentional to clog up the works and kind of slow things down, or whether it was just because it was a tight year. That's not for me to say, but one could speculate. But it's definitely something that, we're going to have processes in place, and we're going to have due process within the administrative aspect of what we do. We need to make sure that we provide adequate resources for prosecution and also for due process. It's what we owe the citizens of our state and of our country. So that's my 10 minutes.
All right. Great, thank you for that. And everybody did a great job keeping into their 10 minutes, and which means that we have a lot of time for questions. I don't know if we have any that have come through the chat, but again, hopefully people can think of some and send them through. I do think it was a great perspective, or variety of different perspectives. We've had both people at the federal level and the state level. We had Professor Bednar and judges. And quite frankly, Jen, even your perspective from I guess an agency headed by one person, let's say, as opposed to some agencies like the Public Utility Commission that has 5 commissioners. So I think that that's a wide variety of perspectives, and I'm just going to look to Carrie for a second. So I will move to my first question, and this sort of builds off a little bit of Deb, about what you were talking about. I think you said that in your role you see, I think you said about 20 different subject matters, which leads me to the question about the central panel concept. And we don't have a formal central panel here in Pennsylvania. It's an issue that pops up from time to time at the legislature. And by central panel, just for the audience, I mean, there are some states that take the adjudicatory role out of the, physically out of the individual agencies and put them into a more, a centralized agency that, quite frankly, as far as I understand, just focuses on adjudication. So, they may be seeing, a variety of different subject matters, but all they do is adjudications. And again, that's outside of being housed within a particular agency. So I just want to throw it out to the panel to see if there's any thoughts about the central panel concept as it relates to this overarching theme in this panel of independence for administrative law adjudicators.
Yeah, so here in the district, we have probably, I think there are maybe 3 models total, maybe more. So we have well, really 4. We have the traditional in-housed administrative law judges and hearing officers. Then we have hearing officers that can be contracted by the agency. So they don't report directly to them, but they're contractors who come in solely to hear cases, and they don't report to anyone. We have central panels of 1, which is sort of where I sit, where I'm just one person, but I hear a multitude of subject matter cases, including the agency where I'm housed in, but it involves several other agencies as well. And we also have, well, really 4 models. We have a board, depending on like the labor adjudications are done through a board of law judges. And then we actually have a court of administrative hearings, which are just administrative law judges that are a central panel that hear a whole collection of subject matter cases, that come before them. So here in the district, we just sort of meld it all together depending on the subject matter and the issue in question. So whereas unlike most jurisdictions, I'm an administrative law judge that can detain people. I can lock someone up as part of my judicial powers and authority. Most jurisdictions don't have that. But while I can lock someone up and take away their constitutional liberty, I cannot issue monetary fines. That is for the Court of Administrative Hearings and Appeals. So it just depends on 1, what the subject matter is, and 2, what the call of the question is for that particular case.
Anyone else want to chime in on that topic?
I would add that our situation is such that we can bring in an independent contractor to hear a case. That's actually part of what we're permitted to do. But there are some limitations on it. They're generally available to us if we have a temporary overload, and we've done that in the past where we've had that, or where for some reason no hearing examiner could really be neutral. Now, a great example of that is one of the agencies we hear cases for is the retirement board, the state retirement board. And all of the hearing examiners that are part of my office are all state employees. So if we would be hearing something which would cause an interpretation that might favor us in some way, ultimately, that would be a case where I would say, no, we need to have somebody coming from outside. So we do have it, but it's not used very often.
Interesting. Thank you. Thank you. Again, I just encourage people, as part of this concept of the independence of administrative law adjudicators, want to make sure I got the title right, to just consider something, this concept of a central panel. I know it's popular, or I shouldn't say it's popular, but it's used in many states. It just doesn't happen to be formally used here in Pennsylvania. And Carrie, I think
We have a question.
we have a question.
We have an attendee inquiring what is one change in administrative law that you would like to see at the state or federal level?
Okay. Anyone have any thoughts?
I mean, I have so many changes that I would like to see.
Where do you begin, huh?
If I had to choose one, I'm actually, I mean, I don't know if it will be a central panel or a unified court or a division of the court, but I would love to see just all the administrative law judges of a jurisdiction just condensed into one contained body that would self-regulate, similar to the court, right? You could have a chief administrative law judge and all the other ones, some assigned to the civil cases, some assigned to, nuclear commission or labor law or whatever that is. Because it's very hard to mind meld, for lack of a better word, and connect with your colleagues, because we're all scattered throughout all of the agencies, throughout all of the jurisdictions. And sometimes it's hard to know what the trends are for that jurisdiction for administrative law, because you're so busy with your own cases, and to track down these other people is a whole nother task, versus if their office is in the same building, you can sort of confer with them and move forward with an overall sort of idea as to where administrative law may be going, not only in your particular type of case, but in the general area that you might practice in as well.
Great,
The
thank
one
you for
thought
that.
that I have, if I could add to Judge Thomas, when you asked the question before about the central panels, well, I have served on the American Bar Association National Conference of Administrative Law Judges Central Panel Task Force to try to determine whether a central panel would be advisable. Right now, the American Bar Association has not endorsed that. They've still been studying it, as far as I can tell. But I can also say that in my capacity as president of the National Association of Immigration Judges, I recused myself from participating in rendering any conclusions there, because we all believed that creating an independent immigration court under Article 1 of the Constitution was the only way to truly create the independence that our court needed. And so while I think some of the fixes that I've been talking about, more staff, we've all been talking about more staff, performance measures that don't violate due process, improving integrity. When it comes to our court system, we feel like those are working around the edges, and all of those are important in the short term, but the only long-term enduring solution is this independent immigration court. And that kind of brings to, I know you have another question, potential question having to do with, independence from who, from what? And I'll throw it back to our moderator to continue to moderate this group.
Great, thank you.
This will make people laugh probably, but if it were up to me and I could choose just one thing to change, Pennsylvania is in a situation where the Supreme Court handles the discipline of attorneys. In addition, hearing examiners and administrative law judges don't have contempt power. It doesn't happen very often, but our ability to control a rogue attorney is rather circumscribed. And I would like to see something that gives us a little more authority. There is some authority under some state regulations. There's a question as to whether that survives given their decisions by the court that it alone can discipline attorneys.
I'll just add to that, if you don't mind, because we, by regulation, the immigration judges have contempt authority, but, well, by law, we have contempt authority, but there have never been any implementing regulations. And over the past few Congresses, there have been bills that have been introduced, and I think one might be pending before Congress right now, to ensure that we actually get this authority, to contempt authority, actualized before us.
Interesting.
Yeah. Great. Thank you for sharing that. Anyone else want to chime? Judge Thomas?
Oh, I was going to ask a question, but go ahead. Professor.
I was just going to echo something Judge Sankoff said, which is one of the things that makes me most queasy in administrative law is whenever you have a prosecutor and a court within the same agency, because even if it's the case that you can separate those two, right? The perception is that there's going to be an influence regardless. So I'm all on board with an Article 1 or, an independent immigration court. And I think that's true of any agency that is also engaged in enforcement and benefits distribution, but also adjudicating those decisions after the fact too. Something like another change here, or a change that is ongoing that I would like to stop, is there's a lot of pushback right now, and whether you agree with me is going to depend on how you read the Constitution, about for cause removal protections with respect to judges, right? And so perhaps like people think like, okay, you can't have for cause removal protections because it's a constitutional violation, fine. That still jeopardizes agency independence, right? And another thing we're going to start seeing as a result of that is there is a risk adjudicators are going to be less willing to start working for certain adjudicatory agencies. If you track where adjudicators move between different agencies, those without less or with fewer removal protections currently in their statutes are more likely to try and jump to agencies that have greater protections for employment. And so the more we push back against kind of the for cause removal protections and other sort of civil service protections, I worry less people are going to be willing to even pursue careers as adjudicators.
Great, thank you so much for that.
Can I ask a question to our agency head? Is it Jennifer?
Yes.
Yes. I often get cases where we talk about political influence or the games of the people at the head of the agency. I don't necessarily traditionally get the case of you will do as we say you will do kind of bucket. I tend to get we agree with the other side, but we don't want to be the one making the final decision cases. And because the majority of my cases are the final decision, unless they're appealed to the agency head, they're happy to bring it to me and say, oh, well, look, we didn't make the decision. This judge made the decision. And so, oh, our hands are clean. Don't hold it against us, because we're politicians or, we're whatever. I wonder what your thoughts were on that. Do you, I mean, I'm sure you can't name cases, but are you slightly guilty of this, or do you think this is common in other jurisdictions? Or
I think it really depends on the person. I mean, I think it depends on the ethics of the person who is also the agency head. I'm an attorney by trade, so I still hold myself to the same ethics code that all attorneys hold themselves to. I have not been guilty of that, but I have felt undue pressure at certain points of my career from above me, and to try to try to figure out how a certain case was going to resolve. And I kind of always considered myself to be that buffer between that political pressure And I was always, so I started out prosecuting within the agency. So I was always very cognizant of having maintaining that independence with our adjudicatory functions. So I might be a little bit different, but I think I understand where you're coming from, and I've experienced it, but I have never in my career done that or found that to be greatly influential, because at the end of the day, you have to withhold appeal. And if you're going to, if you know, for us, we had more recommended decisions. If you were going to disagree with the recommended decision, I think you have to have a very strong case and facts to support that case as to why you're going to disagree with the hearing officer. So that might be a little bit different.
Yeah, in my cases, the agency have no appellate rights. So,
right.
Yeah.
Okay, so I see that we're approaching 4 o'clock, and really just want to thank all the panelists. This was really great, and I appreciate the perspective that everyone's brought. And there's a lot of issues we can still talk about. We were touched on about the distrust of government, which I think is a big issue, and the concept of independence from whom. And there's a lot of political issues. It's a fun topic to teach for me at the school, and I'm grateful that I have the opportunity to do that. But you'll have to sign up for my class next semester in order to find out. But again, thank you to all the panelists, and thank you to the school. I think I'm going to turn it over to Carrie now.
Indeed, and I'm going to come back here so that you can actually see me instead of being a disembodied voice this time. On behalf of Widener Commonwealth Law Review, thank you very much for all who joined us today. If you need CLEs, please use the link that's been in the chat throughout the day. Fill out your paperwork to make sure that you get your CLE credit. You will receive a certificate through the email system within, I think, 24 to 48 hours. This session, the whole day has been recorded. So if you didn't get to see it all, you are more than welcome to see the recording. It will be available, I'm going to say 1 to 2 weeks. Because our amazing IT folks are pulled in a whole lot of directions, and graduation is in 4.7 weeks. So they've got a lot going on. But that will be available both on the Law Review Symposium page, which is in your chat, as well as on our Widener Commonwealth Law YouTube page. Again, this is the Law and Government Institute's 25th anniversary. So this was a huge anniversary, huge event. We had great representatives from our alumni, from Pennsylvania state government, from the federal government. The panelists today were phenomenal. We couldn't have done it without the Widener Law faculty and staff, particularly Brian Fernbar, our IT folk, as well as Professor Jill Family, who was sort of the faculty buddy for me to get all the names and panelists, or a lot of them today. And then, of course, Professor Quinn Yeargain, who is the Widener Law Commonwealth Law Review Advisor. And with that, I'm going to pass things over to Professor Yeargain for closing remarks.
Well, hello, everyone. I wanted to first off thank everyone for being here today. Professor Jellum had remarked earlier that we all owe a deep debt of gratitude to the audience, because without them, there'd be nobody to speak to. And I absolutely echo that. I want to thank a whole bunch of people who you haven't seen today. I want to thank our excellent IT folks, Brian and Rob, for their excellent work and making sure that everything has worked really smoothly today. I always anticipate things like this with some trepidation that something will go wrong, but nothing did. I'm especially grateful for Steph for managing our online presence, for Molly and John for handling CLE registration and the credit process afterwards. And I really want to echo Carrie's deep gratitude to Professor Jill Family and Rob Teplitz for their contributions in building out the panels, recruiting folks, et cetera. They really did fantastic work. And of course, deep thanks to Carrie Nace and the entire Widener Commonwealth Law Review for their work in bringing this all together. It's my deep honor to serve as the faculty advisor to the Law Review. I'm incredibly proud of what they've done today, and certainly I'm very grateful for everybody who's been here today. And with that, we are adjourned. Thank you very much. Have a great rest of your day. And make sure to do everything that Carrie advised to do to get CLE credit or to watch after the fact. Thanks so much.